Good morning, everyone. Welcome to the second day of our oral argument session for the spring here in Philadelphia. The Pennsylvania Supreme Court is the oldest appellate court in North America, in case you didn't know that, because I say it all the time. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Judiciary Act of 1722. In 2022, we celebrated the court's historic 300th anniversary here in Philadelphia. As you likely noticed entering the courtroom, our court has a tradition in all three of our courtrooms and surrounding halls by the courtrooms of hanging portraits of our former Chief Justices. Just by way of historical knowledge, I'd like to just tell you briefly about three of the portraits today. To my left is the portrait of Chief Justice Ronald Castile. I was fortunate to serve with Chief Justice Castile from 2008 until his retirement in 2014. After graduating from Auburn University, Chief Justice Castile was commissioned as a second lieutenant in the United States Marine Corps. He served in Vietnam as a platoon commander when in 1967 they were ambushed by a Viet Cong battalion. Castile was seriously wounded and ultimately lost his leg. In this portrait, he proudly poses with his Swiss crutches, or as he'd call them, his medals. Castile came to Philadelphia and became Philadelphia's district attorney. He served from 1986 to 1991 and was elected to this court in 1993. Next, we have the portrait of Chief Justice Robert N.C. Nix, Jr. Chief Justice Nix's grandfather was born into slavery before becoming an academic dean of South Carolina State College at Orangeburg. Nix's father was Pennsylvania's first African-American congressman, and he served for 20 years. Chief Justice Nix was the valedictorian of Villanova University and graduated from the University of Pennsylvania Law School. After developing a reputation for protecting civil rights as a lawyer in Philadelphia, he was elected to the Court of Common Pleas. He was later elected to this court, becoming the first African-American elected to a statewide office in Pennsylvania. He then became Chief Justice in 1984, again making history as the first African-American state Chief Justice. Last, I'm going to comment on the final portrait on that wall, and that is a portrait of Chief Justice Horace Stern, a Penn Law graduate and the court's first Jewish justice. Admitted to the Philadelphia bar in 1902, Stern entered private practice only to be interrupted for service as a major in the Army. After serving as a Court of Common Pleas judge in Philadelphia, Stern ran successfully for a seat on the Supreme Court in 1935. In 1952, he became Chief Justice and was sworn in this courtroom. With one speaker, former U.S. Supreme Court Justice Owen Roberts, remarking that Stern shared the qualities of two other great judges of the common law, Oliver Wendell Holmes and Benjamin Cardozo. Stern served as Chief Justice until his retirement in 1956. I thank our court crier, Brian Minner, for taking such an interest in the history of our court and for compiling these biographies of our Chief Justices. I'd like to announce that we have some students here with us today, and I'd like to introduce them. They are from my alma mater, Lincoln High School in Elwood City. These students are enrolled in the AP U.S. Government and Politics and the American Government classes, and they are here with their teacher, Mr. David Gabus. Would you stand, students, and Mr. Gabus? We're glad to have you here. Welcome. I believe this is the 13th year that Mr. Gabus has brought his students to Philadelphia for an educational trip, and they always spend one day observing our oral arguments. I hope that a few of them may decide to become lawyers, and I hope that none of the arguments today will dissuade them from their career choice. Thank you, Mr. Gavis. Thank you, students. Welcome. We have some law school students too, don't we? Okay. Are there other students here with us today? Do we have some law students? Professor, did you bring your students? We do. Yes, please stand up. I thought we had some law students here. And you are from? Well, welcome. We're very glad to have you. Thank you. Before we hear the first case, I'd like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. After that, you may begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with the cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. I also remind you that we do not permit rebuttal. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we want to explore further. While there is no set time limit for oral argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case. In this matter, LeVar Brown filed a petition under the Post-Conviction Relief Act claiming that the Commonwealth suppressed evidence that a witness who identified him as a participant in a criminal conspiracy resulting in the death of Michael Richardson had also falsely identified an innocent person in that crime. The Philadelphia District Attorney's Office agreed that Brown was entitled to relief on this claim, and the parties filed in the PCRA court a joint stipulation of facts supporting the grant of relief in the form of the vacation of Brown's life sentence imposed for that murder. Notably, this life sentence served as one of the aggravating circumstances in a separate case in which Brown was sentenced to death for the first-degree murder of Robert Crawford. As there was no party to challenge Brown's entitlement to PCRA relief due to the Commonwealth's concession, the families of Richardson and Crawford, the deceased murder victims, sought to intervene in Brown's PCRA matter. The PCRA court denied the family's request to intervene, although it permitted them to participate as amicus. The families did not appeal the denial of their request to intervene. Subsequently, the PCRA court, with the consent of the Commonwealth, granted Brown's PCRA petition and vacated his life sentence imposed for the murder of Richardson. The families of Richardson and Crawford thereafter petitioned this court to exercise King's Bench jurisdiction, claiming that they were the only party to challenge the PCRA court's reliance upon the joint agreement between the Commonwealth and Brown. We granted King's Bench in order to review the PCRA court's order vacating Brown's life sentence. As well, we directed the parties to address whether and via what procedure a common pleas court judge may grant relief based upon the concession of the parties. This court further invited the Attorney General to participate as amicus and to present oral argument in this case. Please proceed.
Absolutely. Good morning, Chief Justice Todd, Associate Justices of the Supreme Court of Pennsylvania. My name is Christopher Lynett, and as the Chief Judge just laid out, I represent the surviving family members of two murder victims, Michael Richardson, who died on January 19, 2003, in a botched robbery involving defendant LeVar Brown, and Robert Crawford, who was killed on December 10, 2003, in a street corner in Philadelphia because Mr. Brown believed he was cooperating in this case. And as this court is well aware, this case has been here before. And we're here again to answer the question of whether what this court said in Brown in 2018, the judicial merits review, favorable to the petitioner, that is necessary in order to grant PCRA relief to vacate a conviction, can stand where you have the parties below conceding error and directing the trial court essentially to a conclusion. And Chief Justice Todd, to go back to your history, there's three major underpinnings here that the parties' actions have undermined. The first is the necessary adversarial process, which this court is seeing play out right here today. We finally have an adversarial process, and you see the evidence that has been produced to this court in the first instance, evidence that completely undermines the concession. The lack of an adversarial proceeding below impacts the merits judicial review that is required. And I intend to talk about what Judge Bronson said below and the issues he thought were critical and what the parties told him about those issues before granting relief. And then third, because of those two errors, those two compromises of what I would call the essential procedural safeguards of our criminal justice system, to use Justice Doherty's word in the concurrence in Parent, impacts the constitutional transparency that is required in these proceedings. The adversarial testing you have seen happened here in front of the Supreme Court of Pennsylvania. And it happened because we submitted a memorandum from March of 2003, and I'll just take a step back of what happened below.
Yeah, Counsel, can I just for the sake of clarity here, your client participated as amicus.
That's correct.
Briefed all of the issues before the court.
That's correct.
Did not ask for a hearing. Am I correct?
That is, we did not believe a hearing was necessary on the record before the court. That is correct. Okay.
And didn't appeal from the denial of intervention?
We did not appeal from the denial of intervention, Your Honor. We intend, because below, our position has always been that this record is so bare that petitioner just cannot meet his burden to prove by a preponderance of the evidence, considering all the evidence in this case, not the limited evidence that the district attorney's office and the defendant proffered to the trial court, are insufficient to grant relief. And all you have to do is to look to what facts, verifiable facts, about Ronald Van's supposed statement in inculpating Kenesha Page could be verified. Who did he give that statement to? When did he give it? What was the context? What did he say about her? We have none of that here because the parties below never interviewed a witness. They reviewed the paper file and came to what I would say the lawyer's belief as to what happened, and then walked into court and represented to Judge Bronson specific factual things. I want to be clear what they said.
Referring to the stipulation.
Yes.
And your argument is that the stipulation cannot be a substitute for a judicial decision.
It cannot be, and that's what this court said in Perrin. And I think there's a lot of parallels.
There's a difference, isn't there? Because here, it's not a concession as to a credibility determination. It's a determination, and not solely by the DAO, but by Judge Bronson, if I'm not mistaken, that impeachment evidence was never turned over. Particular impeachment evidence was never turned over, excuse me, to the defense. And I thought what was going to happen here prior to the grant of this petition was the DAO was going to try this case again. Am I missing something here?
No, that is, first of all, that is correct. The district attorney's office has represented that they want to try this case again. But to your point about Judge Bronson, I want to read some things that he said in December 2022 to the parties to make very clear what he was trying to figure out. I want to share my view that it seems to me that the record in front of me, including the stipulation, does not resolve the factual question of whether Mr. Van actually identified Kenesha Page as a participant in the Rite Aid conspiracy. I don't believe that's something you can stipulate to. That's at Appendix 997. And then 5 pages later in the transcript, 2 in the appendix at 999, he says, he's asking about the 483. That's the 483 where Defendant Brown and Kiana Lyons are supposedly first mentioned. We know that's not true, they were mentioned months earlier. And he said, the 483, if that predated Detective Baker's July memorandum, that's important. And then he goes on and says, if the 483 predated those memorandum, then that argument would be totally, I don't know. And I think totally is the word he's going to say is undermined. Because here, he was presented with facts that suggested that detectives interviewed a witness, or at least investigated a witness, and then confronted Ronald Van, who was the key witness here, and said to him, you got to change your story. And then, based on the record below, he gives a statement where 2 new suspects are named, LeVar Brown and Kiana Lyons. And what they represented repeatedly to the trial court below, and I want to just make sure I'm very clear what the parties told Judge Bronson, but amici, we, making the argument that this is not material, not prejudicial, ignored that these statements also did not mention Kiana Lyons or petitioner himself. They were first mentioned in Van's July 21st and 22nd, 2023 statements after investigators determined that Van had lied about Page's involvement in the Rite Aid robbery homicide. That is literally true, but factually inaccurate.
Counsel, what I'm hearing you say is the trial court erred.
I'd say the parties erred and forced the trial court to err.
No, the trial court did an independent review of the record. Your argument is he erred in reaching the findings because they weren't supported by the record.
Because he was missing critical evidence that was necessary to those findings.
It doesn't matter. It doesn't matter. Your argument is
Yes.
he erred.
I believe he erred. That's exactly right. And he erred. I'm just explaining the reasons for Judge Bronson's error.
It doesn't really matter, does it?
For us,
if he erred and we agree with you, then we would reverse him,
Absolutely.
as we would in any PCRA case.
Absolutely.
To me, the critical point is that the trial court engaged in an independent review of the record before him. He could have said it's insufficient, but he didn't.
Absolutely.
So your argument is he erred and he should be reversed.
He should be reversed. And there's part of your statement there I just want to make. Because of the record before him, which was controlled by the parties, and there was no adversarial testing.
Counsel, I want to try to elevate this because this is not a PCRA appeal.
No, this is a King's Bench appeal.
King's Bench. We took this for, to wax poetically or opine on a much broader topic, which was whether and via what procedure a common pleas court judge may grant PCR relief based upon concessions of the parties. Now, how we answer that question may impact the case here.
Absolutely.
And result in a reversal or affirmance. But I think the reason why we're here is this idea of when I don't think we're saying that the Commonwealth and a defendant can't stipulate to facts. No. They certainly can.
Absolutely.
The question is, if they're going to stipulate the facts in the context of overruling a jury verdict, what do we expect them to present evidentiarily wise to support those stipulations so that a judge can make that independent judicial determination to override a jury verdict?
Absolutely.
So that's why I'm here.
I understand, Justin. And I was addressing, and I forgot to introduce my co-counsel, Ronald Eisenberg from the AG's office, and Lou Tumalo from the Beasley firm. I'll be talking about most.
We already knew them. We already knew them.
I figured you knew Mr. Eisenberg. But to your question, Justice Robson, I think that one of the things I pointed out is inviting the people who've been actually accused of wrongdoing, the detectives and the former ADAs, to participate in these proceedings. And that comes right from the right to reputation. This court has held that individuals within our Commonwealth have a right to have their reputation maintained. And when the district attorney's office, with the help of the defense, comes into a court and convinces the court to say that there was detectives knowingly withheld statements from the defense, that is saying that those detectives committed.
Now you're into a whole different, now you're moving into an entire, this becomes a globe-spanning proceeding then. And I certainly don't understand how you could envision us directing a protocol that would provide a mechanism for the vindication of the reputation of every person about whom adverse things could be said in a court proceeding. There, there's immunity, obviously, for what's said in a courtroom.
Absolutely.
And people, including us, get maligned all the time. It comes with the territory.
Absolutely.
And it comes with the territory for a lot of public servants, including, alas, law enforcement officers. But with respect to the protocol that you were discussing with Justice Brobson, I don't understand, zooming out to the broader issue here, because we're not only dealing with this Brown case,
Absolutely.
right? What kind of authority do we have to create some protocol on the fly for reviewing these kind of stipulations or agreements? And is it substantive? Is it procedural? It's not in the PCRA, right? The legislature didn't give us this.
No, they didn't.
So where are we getting this authority to ramp out some protocol because you're frustrated the way this DA's office administration is handling these cases?
Well, to be clear, the petitioner has to take the position that this can apply statewide, but Justice Wecht, what we're talking about is that a notice procedure at least that the parties could come in and say, have these individuals been contacted? Are they aware of these proceedings? And they're aware that they have an ability to come in and defend themselves if they'd like to. I think that's all you really need.
Well, that's us. That would be us. And again, it's not just this. It is statewide, as you acknowledge.
Exactly.
So we'd be prescribing rules for the way DA's offices across 67 counties are handling these cases, and these are elected officials.
Yeah, absolutely.
So we'd be directing some aspect of the management of DA's offices across the Commonwealth.
I don't think that you're necessarily reaching in. What I'm saying is that you're telling the trial courts there's competing constitutional interests here. And that's really what you have, is the constitutional interest of the criminal defendant to have his PCRA petition, which also implicates the constitutional interest of these individuals who are accused of misconduct. And I don't expect, Justice Wecht, it to be every police officer. In this case, it was 2 detectives and 2 DAs. That's it. Those are the 4 people who are accused of wrongdoing.
So let me circle back on that particular point, because I think it's been raised many, many times in this particular case, and I have to disagree with my colleague. I don't necessarily think this impacts on the administration of a particular DA's office. It really has to do with fundamental fairness in the practice of law. So my question to you is, early on in the process, Judge Bronson indicated quite clearly and unequivocally, I think, the need for a hearing. So those DAs were, was it Fisher and Malone?
Yes.
Why weren't they called?
To
To me, this seems to be a discrepancy of what was turned over, if it was not turned over, and its effect on the trial, and why it wasn't turned over. Because the DA's office originally made the position, I think, in a prior PCRA, that they didn't think it was material. They thought it was cumulative, and they thought it wasn't material, this particular document. Now that the DA comes back and says, we think it was material, but nobody called the DA and nobody called the detective to find out what they did and why they did it.
Absolutely, and to your point, you talk about this is a Brady claim only in front of this court. The Kenesha Page claim is a Brady claim, and so those detectives were not even contacted. Detective Baker was never interviewed in this case. Detective Judge was never interviewed in this case, but they walked into court and accused them of wrongdoing. And to your point, you're right. It's about how these proceedings could go to protect the constitutional interests of the defendant, to have his judicial merits review of his PCRA petition, and allowing those people who've been accused in an open court of egregious misconduct, egregious prosecutorial and police misconduct, of at least having the minimum opportunity to appear and to hear the hearing and participate if they would like.
I'm sorry to jump in again, but
okay.
That is not the purpose of the PCRA. And it's not, if we go down the road you're proposing on this aspect of your petition, as a matter of principle, we need to envision and presumably develop some protocol by which witnesses, police witnesses, but other witnesses also who are, in your view, maligned in a courtroom, get some forum to clear their reputations. And I don't understand where that comes from. It's just to me, it's unheard of, and I guess I'm not sure where you're sourcing that.
Well, I'm sourcing it from the Pennsylvania Constitution, which has undeniably a right to reputation. In this case, this court in the FOP case talked about how the right to notice and ability to participate are critical. So to the extent that the PCRA conflicts with our Constitution, Judge, it's not a hard call. The Constitution must prevail.
Just one more thing, and then I'll stop on this. You're absolutely right that we have been robust in defending the constitutional right to reputation, as Mr. Eisenberg is well familiar with the grand jury matters involving the diocesan officials, right?
Absolutely.
But now you're extrapolating from that, as I understand it, the need for a protocol that would allow persons, right? It can't just be one category of persons about whom unfortunate things are said in a courtroom to have some opportunity to be heard. And that would create a cottage industry of, that would create litigation around the Commonwealth of unfathomable duration and dimensions.
Justice, but I don't know where these people would have their day in court then.
They can bring a lawsuit.
They could, well, I don't know what kind of, they could.
Well, bring an action against the district attorney's office, and we know where that will end up. The district attorney will have immunity.
We'll have what? I'm sorry, Your Honor.
Will have immunity.
Exactly, and so that's.
But see, our system covers all of these issues. And what you're suggesting is that we create some mechanism in a PCRA proceeding to overcome impediments in our justice system. And that's just not what the PCRA is for. I mean, if you were arguing that these individuals had critical evidence that had to be heard, a different issue. But that's not what you're saying at all. You're just saying they should have a forum to say they're lying. We are not corrupt. We did not, withhold evidence. It's not what PCRA are for.
I understand that I'm making a distinction between, and I want to be clear, we do say that. Detective Judge's statement, which we put before this court, categorically denies what happened and shows what he would have said if given the opportunity to testify.
So why are you arguing they have a right to vindicate their reputation? That's not what PCRA proceedings are for. If what your argument is they had facts that should have been heard, that's a different level of argument.
Well, Your Honor, I was addressing the procedures that we thought were appropriate and the petitioners believe would appropriate. We vindicate the constitutional rights of the people who are involved in these proceedings.
You're answering the what procedure aspect.
Exactly, and that's what I'm attempting to do, and it's difficult. I agree.
I do think you're, and again, maybe either you're making it too complicated or I'm too simplistic.
It's probably me, frankly.
No, it's usually me. To me, the question is when your parties, whether it's a PCRA case or any matter before a judge or a jury or what have you, and you're going to represent as officers of the court a stipulation of facts.
Yes.
You're going to hand that to the judge and say, we stipulate these are the facts. I believe that lawyers have an obligation to make sure they're really facts, and that if they're representing to the fact finder, the judicial body, that they're stipulated facts, then they're stipulated facts. It's not something up for debate. It's not it's supported by evidence. Everybody agrees that, Penn State is the best football program in the country. I mean, these are verifiable facts.
I'll plead the fifth on that.
Yeah. So, I mean, that's to me what the issue is in this case. And we can go off on a sort of these detours of what could have happened or what happened, but the principle of your case is that the district attorney and the defendant presented a stipulation to the court that were not facts. They were their preferred view of disputable evidence, and half of it at best, because they chose what they were going to give. They mutually agreed what evidence they were going to give to the trial court, the PCRA court. They excluded some evidence because they didn't want to inundate the judge with too many documents. There was no hearing. So the real question in this case is, can the district attorney's office and the defendant in a PCRA context stipulate to facts that arguably aren't facts?
And I don't think they can, because.
Well, I don't think they,
I
it
agree
sounds
with
like
you,
a pretty easy
and I think
proposition.
that's a simple way to put it, and I agree with you, Justice. I don't believe they can. And to this point, this is what I want to go back to the parent issue of credibility determinations. This is a case about inferences. This is not, there's no direct evidence here. There's no document from Ronald Van where it says, here's Kenesha Page, she was identified on X date at X time, here's her role. What we have are second and third party documents, some of them without an author, some of them, Detective Baker, we don't even know what information he had.
Can I just ask you on that issue, would it resolve this petition if this court simply directed a hearing? That's what you wanted from the get-go. You wanted the hearing. Now you've come and I guess you're asking us to reverse and just deny the petition with prejudice, but spooling backward here, you wanted a hearing. So why not ask us to just direct the hearing, and if the DAO insists on taking a knee, we can invite the AG to take it over. Why wouldn't that end this case rather than trying to manufacture a protocol that's not in the PCRA?
So, to the extent that I don't know what a remand would look like under these circumstances, to the extent that the court is thinking about appointing an intervener, that would change the circumstances. But right now, what does a remand look like? We go back and we just present the same arguments we did before on the same limited record that was presented to the PCRA court. And Justice, to your point, is that whatever you direct is going to be, the trial courts are going to take that as a signal of what was appropriate in these circumstances. So I would suggest to you, if you're going to remand like that, issue a full opinion, because you're remanding with instructions of what a court should do under these circumstances.
I think Justice Weck's point is and he put it in his question. We remand and we do nothing else. You're not a party. The Attorney General's not a party.
Exactly.
We remand it. The parties are the district attorney and the defendant, and the DA's office takes a knee, as Justice Weck says. We're not in a different spot. Even if we remanded it for a hearing, we can't force the district attorney. I mean, we could say we really, really want you to fight this, but if they don't want to fight it, I'm not sure we can do much more than that.
Absolutely.
So you're not a party. A remand doesn't get you anything. The question remains, what do we do? Let's assume we issue some broad statement that says the district attorney's office can stipulate, not a problem, but if the district attorney's office stipulates, then the facts have to be apparent of record presented to the trial court in support of the stipulation. Let's say we say that. Is that good enough? They have to be, the stipulated facts have to be apparent of record.
And I would add one, in terms of that, I would just want to be clear about what the broader question and the limited question. The broader question, I would say,
I'm focusing on the broader question.
Apparent of record and could actually be proven in court. How are they going to prove what happened now? Detective Baker is dead. Ronald Van is dead. They had this petition sitting since 2020 and didn't talk to Detective Baker, who's the key in this case. So my position in this case is that they've waived their ability to prove it. They said these stipulations are good, these stipulations are what we can rely upon, and I don't think the stipulations get you there.
Well, again, you're going micro on me.
I'm sorry.
I'm trying to understand the principle.
And the principle.
Not whether let's ignore the question of how this is going to impact this particular case, and let's look at the issue we took for King's Bench. What is wrong with saying any stipulations presented by a district attorney and a defendant in a PCRA case that lead to ultimate relief and granting the PCR have to be apparent of record, meaning it's not a disputable fact?
Or better yet, require a hearing.
Or require a hearing. But I'd just add the line, I think, and can be proven in court if necessary. I think that is absolutely critical to what this court talked about, apparent.
Isn't that the definition of a stipulation? Isn't that inherent in the definition of a stipulation?
I think it should be, but I don't think in this case it is.
Well, I mean, how much further can we go? This is, applies to DAs all over the Commonwealth. We don't run their offices, and these are elected officials. I mean, how much do you want us to intrude into that branch? I'm trying to be very clear. I don't want this court to direct district attorney's office to do things. I want this court to empower PCRA courts to know that there's mechanisms that they can use, if necessary, when they face this kind of situation,
where you have a judge who's sitting and saying, I don't know what, these stipulations really don't make sense to me.
But this court could have done that. This PCRA court could have said that. He didn't. And that's why I understand we took this on King's Bench review, but the predicate of all of these arguments that we send it back for a hearing and we make sure that that presumes that this PCRA court committed an error. I mean, the first question we have to address is whether or not there are facts of record that support his conclusion. Only then can we, go down this route that we're ordering special kinds of proceedings. But, at the end of the day, we ordered in our first Brown case that what has to happen is an independent review of the record. This PCRA court, according to what you've argued and read to us, had some reservations. He could have said, I'm having a hearing, and I want the following witnesses, or I'm rejecting the stipulation. He could have done all of that, but he didn't. So what are we to do with that? What are we to do with that? Tell a trial court that his judgment based upon an independent review of the record is not good enough? We're going to second guess him and say, not a good enough record, not independent enough. You see what my problem is? This comes down to a basic question of did this PCRA court err?
And you mentioned two things, Justice Donahue, it's the record and his review of it. We're not challenged. Judge Bronson reviewed the record. We agree with that he did that. It's the composition of the record as the parties below. And to your standard of review, you talked about the PCRA, whether it's supported by the record. It's our position that this is all de novo. We're not here on a PCRA appeal. We're here on a King's Bench constitutional position.
I understand that,
Yes.
but we can't pretend that we don't have a decision from a PCRA court, because we do.
Absolutely.
A PCRA court who appears to me to have worked pretty hard on this.
He did.
And tried to do the right thing here.
I think he did try to do the right thing.
Could he have rejected the stipulation?
Could he have?
Yes.
Yes, he could have.
But he didn't.
He opted not to. That's correct.
But he didn't.
No, he was relying on the parties' representations about the facts as they existed.
But counsel, you're going to answer something to Justice Donahue, which I thought is interesting. What was the record?
So the record was, it was the stipulations and some attached documents, no witness affidavits.
How is that a record? I mean, that's my problem is when I think about a record, I actually think about a certified record, something that was offered into evidence in a proceeding. How is this? This is a record that was this was a record that was compiled by the parties to support the stipulation, not a stipulation that was created based on a record. Am I wrong?
That's correct. That's our reading of it. The stipulations were designed to reach the relief in question, and that's what I am encouraging.
And the record that the trial court reviewed was the record that supported the stipulation, not a record that was created sans a stipulation.
No, and I think I know that there was a submission yesterday about glossip, and I think that glossip helps us because it talks about the prejudice analysis, and that's what Judge Bronson was doing. Requires a cumulative evaluation of all of the evidence. All of the evidence, not just the evidence the parties decide to put before the court. So I want to be really clear. Judge Bronson worked hard on this. I'm not disagreeing with that. He obviously did, but our position is hamstrung by the parties' clear factual misrepresentations, and that cannot stand. Because if you affirm on that basis, what you're telling the parties is that they could omit critical evidence, and you hear Judge Bronson, he said it would be totally, I don't know. And he's asking them to produce this evidence. And an affirmance rewards that conduct. I just want to be really clear.
It's not an affirmance issue. It's a deny.
It's a deny.
King's
Yes.
Bench or grant King's Bench. I mean, there's been no appeal. A new trial date was set, right?
That's correct.
So I don't know what you mean by if we affirm.
I think that in denying or refusing to grant relief, or I'm just trying to imagine that if this court opts not to grant this petition or write an opinion that says what happened below is appropriate or the procedures were appropriate, that it would empower the parties to do this again. And I don't think that that's something this court wants or needs.
You kind of danced around the question a little bit, but my question to you is, in the record that the judge had at the time he was trying to do an independent judicial merits review, were there documents that were contrary to the stipulation that weren't provided to him?
There were, actually, and in fact, the district attorney's office has now admitted that they cited facts from the March 2003 memorandum. It's at Appendix 310, 311, footnote 8.
So how do you do an independent judicial merits review when you don't have the records to enable you?
And I've never encountered an instance where a document is cited and relied upon for a specific fact, and that same document is then withheld from the trial court. And it does not go to Judge Bronson's review, it goes to what he had before him. And what he had before him were things that were factual, were things that were literally true. 3 statements, but factually misleading. There was a 4th.
Commonwealth, are you indicating that if we were to agree as to my esteemed colleague's position, that in fact we would be blessing the local district attorney and PCA court's commutation power, which they have no lawful right to do?
That's correct. I just want to correct you, Justice Doherty. I used to be an assistant district attorney.
Oh.
I am no longer. I have since
My bad.
left the office, but this reminds me of being a district
Counsel.
attorney. Yes, and I think that's the point, is that if you deny the petition or write an opinion saying what happened below is correct, you are telling the parties this can happen again. And this cannot happen again. Because the full transparency is so critical to the public trust in our court proceedings.
When you say this cannot happen again, apart from appeals and motion practice, et cetera, why isn't the attorney discipline process adequate safety valve for you if the DA or his staff is violating rules of professional conduct?
Well, that's one way to hold the individual prosecutors accountable, but it does nothing it does nothing about the conviction, which the community has an interest in undoing the wrong there, in bringing that conviction back, which has been vacated based on factual misrepresentation.
Isn't that why we have elections for DAs in Pennsylvania?
It's one of the reasons we have elections.
Not to destroy the existence of the law as we know it. In essence, what could possibly, if we were to support or put our imprimatur, then any district attorney's office who makes a policy decision to assume a concession of error could result in what I'm saying is withdrawing maybe aggravating factors in a capital case, as long as we have capital in Pennsylvania. That is what the concern is here, correct?
Yes, that is, and that's one of the concerns with this case, because this case was an aggravator for the Brown murder, which this district attorney's office in this very courtroom in 2018 tried to concede it from this panel, and it was squarely rejected. So hearing that the bench is quieting down, I'll wrap up. It's been a long morning. So I just want to reinforce that what we've seen here happen before you is the adversarial process that is so critical. It should not have played out here. It should have played out in front of Judge Bronson, who is empowered to make the correct decision. And Justice Donahue, I think that if he has the correct documents in front of him, he does make the right decision. He denies the petition, and he came close to saying that in the December hearing.
But he didn't.
He didn't, but after that hearing, I want to be, yes, but I just want to just clarify one thing. It was only after that hearing did they tell him specifically that this was the first, after the Baker investigation, was the first time this defendant and the other cooperator were first mentioned. And that's when he entered his order a month later. It is clear that factual misrepresentation, or the factual omission, I'll say it's an omission, contributed to the order below, which we believe is erroneous. And for the reasons put forth in our brief, we ask that you grant the petition and you write an opinion consistent and allowing trial courts to do their job when a district attorney's office has decided not to. Thank you.
Thank you, Mr. Lynette. Let's hear from Mr. Eisenberg.
May it please the court, Ronald Eisenberg on behalf of the Office of Attorney General. We have a unique experience in this case, the question before this court, because it's our office that's been asked on numerous occasions to involve itself in cases where judges were very concerned that they weren't hearing everything that they needed to hear. And from that perspective, I will say to you that I will depart slightly from my colleague. The issue here is not really reputation. It's the integrity of the decisions that judges are making. And the way that our system guarantees that integrity, the American system of justice, is through the adversary process, and it didn't occur here. Justice Weck, we are not asking this court to tell district attorneys what to do. We're asking the court to tell judges what to do. We have elections, but elections are not what guarantee the integrity of the PCRA process. Judges do that, and judges cannot do that when they don't have opposing advocacy to expose all the information. And because of that, it's not enough, I would respectfully suggest, Justice Brobson, for you to tell the parties that they should only stipulate when it's really true, or when they're...
I mean, look, the opposing advocacy thing, I'm a big fan of the adversarial system. I think it's the best system in the world. My wife tells me it's great. But I think it's impractical to suggest that every time that the district attorney agrees with the defendant, we have to bring somebody in to give an opposing view. That's why I'm sort of focusing on this stipulation thing. And because I agree with you, if the judges are going to accept the stipulation, the judges should be able to reach some sort of an independent judicial assessment that the facts laid out in the stipulation are really facts, and not necessarily one party taking a knee or whatever Justice Weck said. Here, my concern is that it's sort of a chicken and the egg thing. Which came first, the stipulation or the record? Was the stipulation drafted first and then the record came on back of it to support the party's view of what the facts are? Or did a record exist and the parties said, wow, based on the record, we have to agree that, these are the facts?
The record is, as Justice Bundy addressed, just a few documents that they are relying on.
So that's my concern is, doesn't that address it? Because we have to allow prosecutors to stipulate. I mean, stipulations are a good thing. But this case, which concerns me, and maybe only me, is should the courts be bound by a stipulation that is based only on a fractional share of the fulsome record and only tells a part story that the two parties agree to?
Well, and I would add to that, it includes inferences, not simply facts.
That's correct, Your Honor. And the problem here is, of course the court shouldn't be bound by that, but the court has no way of knowing. And this is not the only case. As I said, we've been involved in several. I assume the court is familiar with the Wharton case. It's not just about whether the facts are apparent from the record somehow.
Well, see, when I say, just so I quick, because apparent of record is something I said. When I think of a record, I think of an adversarially developed record. I don't think of something exhibit slapped to an affidavit or a slap to a stipulation. That to me is not a record.
That's exactly right, Your Honor, and that's exactly the problem. And what I mean when I say we're not telling district attorneys' offices what to do. If they want to agree with the defendant and concede an issue, that's fine. But in particular circumstances, that's not good enough for the court to act.
Well, it can't be that those particular circumstances are this particular DA in this particular county, because what we're going to do here, if we do anything, is of statewide importance. There's no special docket for this DA in this county. So suppose you have because we're not just, it's not just this matter. So suppose there's a case with all kinds of troubling concessions where the DA's taking a knee and there's a problematic history overall. But it just so happens that there is new DNA evidence proving actual innocence. So you want us to ramp out this protocol, which would say in that circumstance, we need to appoint your office to defend that conviction anyway. Is that what you're saying?
I'm saying that where you have a pattern of problematic concessions, not just one, not just something random around the state, but wherever it might develop around the state, then judges have to guarantee an adversary process. And the only way to do that, regardless of what county it is, regardless of what district attorney it is, regardless of what elections occur, regardless of any disciplinary proceedings, the only way to do that is to have a third party come in.
We've invited your office on many occasions. We've invited your office in those scenarios to get involved. And you yourself have argued some of those cases, but now this is a farther bridge, and arguably a bridge too far, Because it would seem that what you're arguing for, this whole species of cases, you want us to affirmatively displace the DA and have your office?
Absolutely not, Your Honor. As I said before, we are not asking you either to tell district attorneys what to do or to tell them that they have to get out of the case. They can stay in the case. They can advocate strongly for the defense, as they have in this case and by our count by now over 130 other cases, mostly first-degree murders, life sentences. The only problem is the judge has to be able to hear another side. The judge can't develop that on his own. Remember, the essence of the post-conviction process and the order granting this petition specifies concessions during the post-conviction process. The essence of it is that extra record information is developed. And in fact, most of these concessions have been largely Brady claims, many ineffectiveness claims. Those are claims clearly that appear on the post-conviction stage because they demand reference to facts outside the existing record. It is the development of that new record that we are talking about, Justice Wecht, and that record cannot be properly developed at the PCR phase without advocacy when it appears that the advocacy process has broken down.
I don't know why that's true. It seems to me that it's not a bridge too far to say that a district attorney's office, an officer of the court, even if they see the case a certain way, in the PCRA context, must ensure if they're going to stipulate, basically stipulate to the ultimate relief or stipulate to the facts, that a record is developed, a fulsome record is developed, not only to support those facts, but basically to make sure that the trial judge, the PCRA court, who has to make an independent assessment of those factual stipulations, has all the information available. I'm not sure we need anything more than that, unless we are to infer that that kind of requirement will not be followed by the Commonwealth.
Your Honor, I think that the vision that you paint is fundamentally at odds with the whole idea behind the adversary process. That idea is that the system, the adversary process, doesn't prohibit the bias by the parties. It processes that bias by balancing competing factual and legal claims. That's how the adversary system process works.
You're suggesting then that the district attorney's office shouldn't agree to a guilty plea. That if they're going to agree to a guilty plea or a reduction in charges, that they have to bring in someone who's going to fight vigorously for the higher charge.
I'm not, Your Honor, and this again goes back to Commonwealth versus Brown, where this court, as we had argued in our briefs and this court held, recognized that the discretion of a district attorney changes and actually decreases over the life of a case. The district attorney has maximum discretion at the point where the charging decision is made, still has discretion at the point where a guilty plea is considered, but once the jury enters a verdict, this court held in Brown, the district attorney doesn't own that verdict. It's not up to the district attorney or any other party. And when we're on the post-conviction stage, as I said, which depends on, the essence of which is the development of new facts, we can only reliably develop those facts in cases where the kind of questions that have arisen with these other concessions exist. We can only reliably develop that facts where biases are balanced, okay? If you're advocating for the defendant to vacate a post-conviction, a conviction at the post-conviction stage, at the collateral stage, you're an advocate. And the DA's office has acted as an advocate in these cases.
So your test is, your procedure in response to the question that we took King's Bench on, is if the district attorney's office is inclined to concede the right to PCRA relief, we must, or the court must, invite the Attorney General to participate.
If it's inclined over this run of cases like we've seen here, and if numerous courts have found...
Well, the run of cases thing is difficult because I don't know how many a run of cases is, but let's just start with the principle of you're basically saying if the district attorney's office takes a knee on a PCRA, we invite the Attorney General's office in.
Maybe not the first time, maybe not the second time, maybe, in one
Well,
county.
the problem with your argument is the maybe aspect.
Well-
Well, there's also the problem that it's not in the PCRA, and we don't pass the PCRA, the legislature.
But if I could finish my question, it's long. What if we do invite the Attorney General's office and the Attorney General's office takes a knee? What do we do then?
You're right, Your Honor. There's no perfect solution to this problem, but a problem it is. And the reason we've been asked to begin with to be involved in these cases is because courts had doubts about what they were seeing, and those doubts proved to be legitimate doubts.
Well, that's not necessarily true. I mean, why you've often been asked to participate is because we wanted to hear the other side of the case. But that doesn't mean that there was necessarily a decision on our part that the Commonwealth, as represented by the Philadelphia District Attorney's Office, was wrong. We just wanted to hear the other side of the case.
That's at the appellate level, Your Honor, and this is a very different thing. The development of an evidentiary record at the post-conviction stage is fundamentally different than what happens on appeal with legal issues.
Counsel, let me ask you this question. Could this PCRA court rejected the stipulation, or in other words, just denied PCRA relief on the basis that the evidence was insufficient to meet the defendant's burden?
He could have, Your Honor.
But he could have, correct?
My point is that because the adversary process didn't work here, he didn't have the information he needed in order to...
He had hesitancy. We've been read portions of the record about the PCRA court's challenges in working through the information presented to him. He could have said, I deny relief.
He could have said, I did not believe.
I deny relief.
I'm sorry,
which is what was before him.
He didn't have the crucial memo that contradicted the memos from which the parties inferred a particular result. He didn't have that.
Are you speaking of the March 3rd?
Yes, I am, Your Honor.
Memorandum?
That's exactly what I'm speaking of.
In essence, what was submitted?
That's exactly, Your Honor.
That was within the Commonwealth's possession, but not turned over as part of the stipulation as to fact, because there was an absence of a material fact, that being the March 2003 memorandum.
That's correct, Your Honor. No, not just to the Commonwealth, but to the defense, because the Commonwealth had given it to them, but not to the amicus or to the court. And I don't want to go micro here, as the court has mentioned, but I agree with you, Justice Donahue, that you've got this case, and it's relevant for determining, for addressing, thinking about the broader question. The claim was that Ronald Van only identified the right woman, Kiana, in July, in his July statement. And the reason he did that, they were very specific about saying numerous times that that was the first time he mentioned Kiana. And the reason they said that he did that is because a week before that statement, Detective Baker chased down this other woman, Kenesha, and found out that she couldn't have been taking part in the crime. And the inference that they are asking the courts to draw is that, although there's no actual record of this, is that Van must have been confronted with that new, brand new information in July, and that's when he first supposedly switched from Kenesha to Kiana. The March memo shows that, 4 months earlier, Van had already given a statement naming not Kenesha, but Kiana.
Why are we microscopically getting into that on a King's Bench matter? Why isn't this for a judge? I mean, we shouldn't sell short our capable common pleas judges and the appellate process we have. Why is your case so very special that we need to take a microscopic deep dive on King's Bench?
I am getting into it for two reasons, Your Honor. First, because your colleagues have asked me about those specifics. And second, because this case is an example of the problems that we have identified in other concessions where information like this was not given to the court. It puts the court in a Hobson's choice, Either the PCRA judge has to go out and be the advocate himself or herself and actually investigate for witnesses, interview people, call witnesses, even if you have a hearing. What happens then? The judge calls the witnesses, the judge cross-examines the party's witnesses? That can't happen. There's no way that sort of process can develop a legitimate decision that has integrity. And it wasn't this judge's fault that he didn't have all the information. So it's not about saying that the judge was just doing his best and trying.
That's what I'm saying, is we're spending a lot of time on there. Your argument is simply that in stipulating to facts, the parties engaged in an agreement to only provide the trial court with the portion of the record that supported their facts.
Of course, Your Honor.
That's the case.
Of course, Your Honor. And the point about that is...
No, but I think it's that simple, right? I mean, why can't we stop at that principle?
Because
if you're going to stipulate to facts to a trial court in a PCRA case, you have to give the trial court everything.
Because the point, Your Honor, is that lawyers are advocates, and they're
No, I know you're going down the advocacy route, and I get that, and I understand that. But again, why can't we say as a court that, look, if you don't do this, you're going to be replaced. You're going to be in trouble. You're going to be, I don't know what we say, but I would like to think that our district attorneys, if we tell them that trial judges need the full record, everything, you put that in first, and then you can submit stipulations that you believe are based on the record, and the trial court can evaluate the full record and compare to your stipulations, everything like that. But that couldn't happen here because, your claim is, the district attorney's office and the defendant manufactured a record that supported their preferred narrative, and they gave it to the trial court judge, and the trial court judge had no way of knowing otherwise.
Well, they didn't manufacture a record, you're not saying that, but they handpicked the documents to include.
That's right. They manufactured a reduced record, in effect. And yes, of course you could tell them, Your Honor, but you have told them. That is, in essence, what you told them in your original Commonwealth versus Brown decision.
Mr. Eisenberg, I don't mean to interrupt, but we keep going back and forth between the macro and the micro. In this particular case, what I think you're suggesting, and I think what we're hearing, and I've only been up here for about 14 months now, is a bit of a breakdown in the Philadelphia system, specifically, a crisis of confidence, if you will. We're not an error-correcting court. What is it you're suggesting that we direct the trial courts, which is going to have applicability across 67 counties, as to how to handle a PCR hearing? Because trial courts are not equipped to investigate the veracity or the credibility of every single claim made, and we want to encourage stipulations, as Justice Weck mentioned. How do we direct, or what kind of standard or applicable standard are you suggesting we impose upon trial courts in accepting stipulations? Because that's really the question in my mind.
We're asking you to tell trial courts, and I don't think it's about merely their review of stipulations. I think it's a broader question than that. We're asking you to tell trial courts where there has been a pattern that suggests a breakdown in the normal adversary process, that they need to bring in a third party so that there will be an adversary process. That's what we're asking. And I know
it presumes an epidemic of breakdowns around the Commonwealth, and there's no basis for us presuming such a breakdown. What really underlies your position is your utter lack of confidence, which may be completely valid in this DA in this county. And that's not what this court's here for. That's why we have an electorate out there.
Your Honor, this is not about our feelings about what they're doing. They think that prior prosecutors had a culture of suppressing. From our view, it looks like there's a concession culture that's actually happening now. They can examine as many cases as they want for possibility of error. They can have at it. What they can't do is concede those cases based on incomplete information or lack of investigation. And there's no way for the judge to know when that's happening in the individual case. There was no way for the judge here to know that there was another memo out there that contradicted everything that the parties were saying on their main claim. And this is not the only example of that. The Wharton case that I mentioned, for example, is a case where the issue was the defendant's alleged positive adjustment to prison after he was originally sentenced and before he was resentenced. And the certification made to the court, the stipulation made to the court was, there is no other evidence out there that you don't know about already that contradicts his positive prison adjustment. When in fact, during that exact period of time, this defendant was in a courtroom in this building, on the second floor of this building, and broke out of the courtroom, assaulted his guard, unlocked his handcuffs with a handcuff key that he had smuggled in, and ran out towards the street and was only stopped when an officer was able to shoot him in the leg and stop him.
Yeah, but Mr. Eisenberg, we know the facts of Wharton. I mean, Judge Goldberg called their bluff and appointed the Attorney General's office who investigated those particular claims, and then he wrote a scathing opinion against the DA's office. I keep coming back to the same point because, as interesting as the Wharton case is, what do you want us to tell trial judges? To call the Philadelphia DA's office bluff every time they kind of bring a PCRA claim?
I want you to ask them to exercise the same degree of skepticism that Judge Goldberg did. We're at the point where that skepticism is called for. The Third Circuit actually upheld sanctions against the district attorney's office for that conduct.
And are you suggesting that falls within the discretion of the PCRA judge?
Well, discretion, except I would say more within this court's discretion. This court has plenary supervisory authority over the trial courts. You've asked Justice Weck, what's our authority? It doesn't have to be in the statute. Most of the rules of law about when third parties participate are done by case law or by rules of court promulgated by this court. Of course you have supervisory authority to tell trial judges to do this. You don't have authority to remove a district attorney's office. That's controlled by statute. We were in a case where this court, I believe, asked us to participate where that issue arose, and the party representing the Commonwealth there was this same district attorney's office, and we came in and said, they're right. Courts don't have the authority because of the statute. This is not a statutory question.
Mr. Eisenberg, I believe we do understand your argument. Are there any other questions? Let's move on then. Thank you very much. Let's move on to counsel for respondent.
Good morning, Madam Chief Justice. Tim Kaine on behalf of LeVar Brown. I have never seen, and I hope this court has never seen, a litany of extensive and well-documented Brady and NAPU violations as there are in this case. And I realize that Judge Bronson only addressed one discrete Brady claim regarding the Kenesha Page accusation. But if you look at the case as a whole, as Glossop, as the Supreme Court's decision in Glossop last week requires, then there is no question but that Mr. Brown did not receive a fair trial. The entire argument that I have heard today and that was presented in petitioner's brief regarding manufacturing a record for Judge Bronson is simply not true. Of course we pled our claims, and to go, Judge Bronson, to go to your question of the chicken or egg, just to be clear how this progressed below, we were given access to the H file and to the DA's file, and then we found an immense amount, not only of trial era suppressed documents, but also of the former prosecutor's own investigation into it, which substantiated those claims.
Let me ask you a question.
Yes, please.
The joint stipulation.
You don't represent the Commonwealth, do you?
Yes, I represent Mr. Brown. That's okay.
Old habits die hard.
It's a Freudian slip.
I get mistaken for sovereigns all the time.
Because you two have been impugned, so.
Yes.
Got that DA look about you.
The stipulation that was entered into record was involving Tuesday, July 22nd, 2003 stipulation. But at that time, the Commonwealth was in possession of the March 3rd, 2003, which contradicted the July. So why wasn't that presented to the trial judge or the PCRA judge at the time of stipulation?
Justice Doherty, I simply do not agree that it contradicted the stipulation or that it was in any way relevant to the claim that Judge Bronson was.
Why wasn't it given to the trial judge for him to make that determination?
That's a credibility call.
I don't, look, I think it's not relevant on its face.
The question is, why wasn't it turned over when a judge ordered all the information Your office is not permitted to make credibility calls. Your office is to provide the information as ordered by the court. The question I have is, you made a stipulation regarding one memorandum, but you failed to provide a previous memorandum that was evidence for the judge in his independent review to determine whether he believed it or not. So it's a singular question. Why didn't you provide it? What was, you accused the former prosecutors of hiding evidence. It appears, at least on paper, you're doing the same thing. So do two wrongs make a right? And if you're accusing the former prosecutors of hiding, why don't you show the public that you are not like the old office, you're a new office, and you share this information?
Well, Your Honor, we did not plead or provide the judge with lots of irrelevant materials. I mean, let me step back here and explain what our claim was. Our claim was that there was...
Stop you right there, because I think I really need to follow up on that question, because you keep saying your justification for not turning these documents over in response to Justice Mundy and Justice Doherty is they weren't relevant. Isn't that the exact same thing that the former detectives and the former DA said about the document that you claim was impeachment material?
Well, no, they didn't. Well, they did actually argue that
They said they didn't turn it over because it was irrelevant. It had nothing to do with their case.
No, I don't agree that they said that. They actually, Detective Baker's actual words were, if we find out that Kenesha Page was incarcerated at the time of the crime, it will show that Van, our star witness, was lying.
I know that, but Detective Page wasn't responsible, or Baker wasn't responsible to turn the documents over. The DA's office was, and that was Fisher and Malone, right?
Yes, but the Commonwealth as a whole is responsible to do that.
Weren't they? Didn't they say the document wasn't turned over because they didn't think it was relevant?
No, they never said that. And what happened here, and what the documentation of the DAO's internal investigation in 2010 shows, is that when they were cultivating cooperating witnesses, and they got a false or unverified or off-message statement from him or her, they didn't write it down. And that goes to petitioner's counsel's accusations of, oh, well, we can't say where or when this false accusation was made.
This goes to my concern in this case. This is a narrative that you, on behalf of your client in the district attorney's office, formulated based on a cold record review. It's a narrative that someone reasonably could have reached a contrary conclusion on. This is the narrative you presented to the trial court as stipulated, to the PCRA court, as stipulated, undisputed, no way anybody could reach a contrary conclusion fact. And you did it by presenting not an entire record, but a chosen record. What you believed outside the context of the jury's rulings on, or the trial court, PCRA court's rulings on relevance, anything, you made all the decisions. You decided what was relevant, you decided what was fact, you decided what inference was were to be drawn, and you laid it and you put it in a bow and you gave it to the trial court. That's what I have a problem with, is once you do that, somehow, some way, there's got to be, in the system, there's got to be something to make sure there aren't shenanigans going on.
The sole point that the stipulation was offered on. So there was a record before the stipulation, Your Honor, and we pled...
Where was the record created?
Well, I'm saying the record was what we pled and all the supporting documentation...
That's not a record, that's a pleading.
Well, it's the reproduced record before this court, but yes, it was a record. There's no transcript of an evidentiary hearing.
Right. There's no testing of the evidence, no whether it would be admitted or admissible or not admissible, whether it was hearsay, not hearsay, business record, nothing like that. There was nothing. It was a pleading. Pleadings are not facts. They're pleadings.
That's right. And the former prosecutors, working in concert with the petitioners below, in all caps, objected to a hearing and told Judge Bronson, despite him wanting to hear one, that they did not want to have one. And that is in line with their internal deliberations on these claims in 2010 when they said an evidentiary hearing would be bad.
To me, that's a red herring because we're not here on that. We took this on King's Bench. Issue preservation, appeals, that doesn't matter. We're here on King's Bench. The question, and you don't want to address it, is it a concern at all for you, or should we be concerned at all? And I'm not saying this is what happened here. I think there's, we can have reasonable disagreement on whether that happened here. We'll look at the record. Is our system of justice prepared to deal with a situation where a district attorney's office and a defendant, post-conviction, after a jury trial, agree in a stipulation to things that aren't really facts, that are just our preserved, our belief, what we believe really was, because we're now in charge and we don't like this conviction.
Your Honor,
how does our justice system protect that from happening? I'm not saying that's what happened here.
Okay.
I'm saying that's why we took this case.
Right. So I think what this case shows is that Judge Bronson and the parent...
I'm going to stop you. I apologize. I don't want to talk about this case. I want to talk about the issue that we took. And I want to know, how does our justice system currently protect that from happening, what I just laid out?
I think Judge Bronson protected it from happening here. I think this court's 2018 decision in Brown is being followed faithfully by lower courts. I think things have changed and that courts are skeptical.
How could it possibly have happened in this case if we know now, as a matter of fact, the PCRA court did not have the complete record to evaluate the stipulation?
But he knew he didn't have the complete record either. I mean, he knows that a district attorney's file and a homicide file is thousands and thousands of pages long. I mean, his whole point in asking for an evidentiary hearing was to expand the record.
Don't you, as a counsel before this court, have an obligation, an ethical obligation, to advise the court of any facts of the case or any law of the case that is contrary to your position?
Of course, absolutely.
And so why would it be any different if you have a file of documents that support or do not support a stipulation, that you're obligated to provide the trial judge with those documents so he can review the stipulation and truly make an independent judicial merits review?
Well, we certainly would have if we thought there was anything relevant to the claim that he was focused on. And in our view, there simply is not. And if I could just say, I know the micro and the macro are at odds here, but a murder conviction and life sentence is macro to Mr. Brown. And this court did take up the question of whether the grant of a relief was proper.
Well, counsel, correct me, because at least I didn't understand if you provided Justice Bronson with an answer at all to his question. The fact here is the development, if any, of a new procedure regarding a PCRA court. And the way I see it, our system doesn't contemplate the concession to a jury verdict. Yet that's what you're asking us to do.
No, I just don't agree.
My understanding from an amicus, it's happened in maybe 130 other cases. So it appears to be a pattern. So are you indirectly asking?
I will let Ms. Ernst address the 100 other cases.
Let's just assume that, as again, it's an offer of proof from an attorney, assuming it's true. Are you standing here saying that based upon a particular office, or what you're asking us is the procedure should be that we can permit or should permit when a DA's office and defense counsel confess error to a jury verdict, that we must accept that and reverse the jury's decision?
Absolutely not.
Okay,
absolutely.
That's what I needed to hear. Thank you.
Yes.
That was my question.
Okay, well, I'm sorry. I'm sorry. I'm not trying to answer his questions and not yours, Justice Bronson.
Well, but that's, so how does our system, how does our judicial, because maybe we don't have to do anything. Maybe this isn't broken. So how do we make sure that doesn't happen? How do we make sure, remember, there are generally two parties. There's the prosecution and there's the defense.
I understand,
right?
Your Honor.
If they agree on a view of the world that is contrary to the conviction, what ensures that the trial judge can make that independent merits determination if the two people that agree on the world are the only ones making the determination of what is relevant to put in front of the trial court to support the stipulation?
I think amicus participation can do so. I think most of these cases that have been listed—
Does amicus have the same open record review that the defendants had?
They were offered that here. The former prosecutors were invited to view the DAO file and the H file in this case, and they declined. In fact, this March proffer that they say we were hiding was on record in the co-defendant's case during the litigation before Judge Judge Bronson. It was there for anyone. No one was hiding it. It wasn't presented in our case because no one thought it was relevant. Hard stop. Like, that's it. There's no conspiracy here. There's no false fact that Judge Bronson relied on.
What is the document that affirmatively shows that there was this misidentification? That if all I did was look at the document and nothing else.
There are two sort of sets of documents. The first is the document showing that Van was giving confidential information to the police on one robbery homicide, that being specified as this one, and then a variety of other robberies. And then it lists the people he is giving confidential information on, identifying Kenesha Page and the co-defendant, in this case, Jamar Richardson, as him giving information on this robbery homicide. And then it goes on about the robbery. That's the first one.
What is in that document, other than a case number? What is in that document? Because maybe the case number was wrong. Maybe the information was related to a different case.
And Judge Bronson,
how do we know that? How do we know that?
Judge Bronson thought that that document was ambiguous. How we know that it was about this case and that he made that accusation is in the reproduced record at pages 210 to 215, where the police do an investigation of that accusation. And in the course of that, Detective Baker says that Van named Kenesha Page, and that if they found out she was incarcerated at the time of this crime, they would show that he was lying.
How do we know that wasn't wrong?
That wasn't wrong?
Right.
Well, it's
How do we
just
know that the
the
police
face of the
officer in that-
document.
How do
Well,
we
I mean,
know
any document could be wrong. But
Correct.
yes,
true.
yes. But, Your Honors, I have to call the court's attention to Glossop, the Supreme Court's decision in Glossop last week, where the same exact situation presented itself, where the state conceded relief, where there was no hearing below, where the documents that were being relied on for a NAPU claim were subject to different interpretations, and where the court said it's enough that the natural reading of these documents, and frankly the literal reading of the documents in this case, are that Van identified Kenesha Page in this case, and that he was lying about that. And Judge Bronson, I mean, that's what the stipulation was about. The stipulation was about Judge Bronson's uncertainty about whether that accusation was actually made in this case, or, as the petitioners were arguing below, with respect to some other homicide. And that's why we entered the stipulation well into the proceedings to address that one particular fact, that one particular factual question. And on that ultimate question that his decision turned on, he declined to accept the stipulation. He said, and I think Petitioner's Counsel actually quoted that, I'm not going to accept that ultimate question of whether he was identifying Page in this case. That was his decision to make. And he made that in looking at the 2 sets of documents that I've just described. In addition to the stipulation, which noted incontrovertible facts that these documents were found in this murder file, that they were stamped with this murder case number, that they were directed to the detective for this case, and so forth. All of the evidence, direct and circumstantial, was that Van made this accusation and that he made it in this case. And it was obviously a false accusation. When you talk about materiality, like there is nothing more material than a false accusation that an accusatory witness has made in that same case. The question of materiality is what competent defense counsel does with impeachment evidence. Competent defense counsel drives a bus through this. I mean, this is their star witness whose credibility they propped up in all manner of ways. And if I may, before I yield to Ms. Ernst, just give the court a sense of what this trial was like. Van lied repeatedly on the stand about the number of statements he gave. He lied about whether the prosecution had made him any promises, and thus about his motivations for testifying. He lied about his own lies, saying they were only in the beginning before he was ready to face the music. They then presented the one other witness who inculpated Mr. Brown, and she lied. She lied about whether she had given previous statements. And most crucially, she lied about whether the police had informed her or her attorney of what Van was saying. Because the key point of the defense, or of the prosecutor's closing, was you can trust these unindicted co-conspirators because even though they're corrupt and polluted sources, they are saying the same thing and they never had contact with each other. They were never told what the other one was saying. He closed on that, and that was false. And Detective Baker was then presented testifying at trial to those false facts, that he had never influenced Lyons's testimony, that there had never been this proffer, or that there was no proffer in the time period that they did, that they had one in which she also, like Van, gave an inconsistent version of events. Under the Supreme Court's decision last week in Glossop, in determining the due process violation of any one of these claims, this court has to consider all of the other due process violations that happened. So even if it were a close call on the materiality of the Kenesha Page accusation, and I don't think it is, the overwhelming evidence of all the violations put together demonstrate that this was an unfair trial.
Counsel, before you sit down, if you could clarify when amicus was offered the opportunity to review the entire file and...
It wasn't amicus, so the former, as soon as I think Mr. Ernst will know the details better, but Mr. Malone, Justice McCaffrey, you referred to Mr. Malone earlier, he was invited repeatedly to come view the file as soon as they were conceding this relief, as was the PCRA prosecutor who had done the internal investigation. She was invited. This is long before, well before Judge Bronson ruled.
That's not what I asked. I asked when the, I think Justice Donahue did too, asked about the amicus. When were the amicus given an opportunity to have open record review prior to the
I
PCRA?
see them as the petitioners, and I thought the Attorney General was the amicus. but they were the amicus.
The Office of Attorney General, not the two prosecutors in the case. I want to know, was the Office of Attorney General and the petitioner given full record review to,
the victims' families,
check?
No,
hold
the
on,
victims'
counsel,
families.
hold on.
Okay,
Counsel.
sorry.
Because you told me that the stopgap is the amicus. That's what your answer to my question was. The stopgap to make sure that the world doesn't come to an end is the amicus. My question to you is simply, did they get the amicus, and I'll add petitioners, because I think they were given amicus status.
They were given amicus below and petitioners
Understood.
here.
So
That's
when
my
I said
confusion.
amicus, I mean the amicus. Were they given open record review? Your answer was yes.
But you meant no.
Well, it's not that clear. There are two separate litigants here, but below they were working in concert, and that's an of-record fact that these former prosecutors were working with.
No, I'm not asking about the former
Okay.
prosecutors. I'm asking about the amicus, because you said the amicus or the backstop. Were the amicus given open record review below?
No.
Thank you.
Not the petitioner's family.
But
No.
was anyone given full record review?
They were invited to, they declined. The former prosecutors who were
they-
co-authoring their briefs below were invited to review the documents and declined.
Thank you.
Okay, thank you very much. Let's hear from the much maligned Philadelphia DA's office. Ms. Ernst.
Madam Chief Justice, and may it please the court, my name is Deputy District Attorney Catherine Ernst. I am now the
Your name is deputy?
That's my title. I'm now the supervisor of the law division. That's the only reason why I wanted to state what my title is, so that you understand that I'm speaking with authority. Or maybe I shouldn't. Maybe I should hide.
You're not an interloper, in other words.
I think I'd like to jump in first with some of Justice Brobson's questions regarding the stipulations. And one thing that I would urge the court to do is to read the stipulations, because I agree, and Judge Bronson below agreed, that it would be inappropriate for us to stipulate to credibility, and he said that he did not read these stipulations as agreeing to the ultimate question of whether Van falsely implicated Kenesha Page, and he believed that that was a determination that he had to make on review of the record evidence here, and I think that that's appropriate. We heeded this court's call in Perrin to not or certainly not to, ask a court to be required to accept credibility stipulations, and we did not do so here. And as to the hearing, Justice Wecht earlier said that what Mr. Lynette had wanted all along was for there to be an evidentiary hearing. But in fact, Judge Bronson indicated that he would like to hear from the prosecutors who were accused of participating in this case. And my office did not oppose that hearing, and in fact suggested that the judge may also want to hear from the detectives involved, Detective Baker and Detective Judge, who was the assigned detective. And it was actually the amicus here that opposed the evidentiary hearing, and Judge Bronson, during the hearing, said that, well, if they didn't want an evidentiary hearing and we didn't think one was necessary since relief was so apparent from the record, then he wouldn't hold one.
That's so odd. That's so odd that that you would, they weren't invited. Were they amici or were they parties? I mean, the fact that the trial judge said, I want to have a hearing, and then looks to non-parties to object or indicate whether a non-party wants to have a hearing or not, that's such a strange, odd thing.
It is, Your Honor, and actually what Judge Bronson asked the parties and the amicus to brief was when there would be an evidentiary hearing. At that point, Judge Bronson didn't know that amici would oppose the hearing.
Yeah, but they're amici. I mean, whether they oppose or not is not it's an interesting thing, but really the question is the parties are the ones that get to object to whether there's a hearing or not amici.
Correct. I don't disagree with you, but what I was...
Did you object to a hearing?
We did not object to a hearing.
Then why didn't you call the witnesses that the trial judge wanted to hear from?
What we said to the judge was that we believed that the documentary evidence here very clearly established that there was withheld material and that was material to the outcome of this case. As Mr. Kane described, there wasn't just one claim here, there were multiple claims that were heavily documented in our file. And so we didn't believe that a hearing was necessary, but we didn't oppose one, and we recommended that if there would be a hearing, that the detectives be called in addition to the prosecutors. But what Judge Bronson asked the parties and amicus to do is brief, if there, for when there would be an evidentiary hearing, what the level of participation amicus would get. And Judge Bronson actually indicated that he was willing to allow the amicus to question the witnesses. And so from Judge Bronson's perspective, this amicus participation would have been quite fulsome, and nonetheless, they opposed having an evidentiary hearing. Another thing that I would urge this court to read, and I'm sure that you, if you haven't already, that you intend to, is the United States Supreme Court's case in Glossop, because the facts of that case and this case are really on all fours, in that a prosecutor's office looked at the record in the, looked at the notes in their file by prior prosecutors and came to the inescapable conclusion that there were Brady and NAPU violations. And because of that, the state of Oklahoma agreed to relief. And there was no hearing because the parties fundamentally agreed to what the facts of record were. And what the United States Supreme Court said is that it's appropriate for the prosecutor and then for the judge to look at the straightforward inferences from the documents. And here, there's a document that a detective wrote that said that Van was lying when he suggested that Kenesha Page was at the crime scene on the night of the murder. And so that, among many other NAPU violations and false testimony that was given to the court, led our office to believe that we just couldn't stand behind the integrity of this conviction, but we do intend to retry Mr. Brown.
Violations alleged in this case.
Yes, there were. So the NAPU violation, which isn't the claim that Judge Bronson ultimately granted relief on, but the NAPU violation that was alleged is that there were two key incentivized witnesses that testified against Mr. Brown.
But before Judge Bronson, there was not a NAPU violation that's coming up to us right now.
So the claim was before Judge Bronson, and when my office agreed to relief, we agreed to relief based upon the cumulative error of multiple Brady and NAPU violations. Judge Bronson ultimately granted relief on the single claim, and we believe that that claim standing alone does provide for relief, but nonetheless...
Is there the word NAPU in the opinion of Judge Bronson?
No, as I said, Judge Bronson didn't reach these other claims that were raised and formed the basis of our agreement to relief. So, one moment.
Could you share with us why the March 2003 memo was not surrendered?
Yes, so, Your Honor, our file in this case, my office's file, is 20 bankers' boxes of documents. There are many documents in those boxes that are relevant to the claims at issue before the court, and there are many documents in those boxes that were not relevant. The Kenesha Page claim, which is the claim that Judge Bronson ultimately granted relief on, was a claim that that Ronald Van falsely identified Kenesha Page as being a participant in the murder. My opponents are arguing, they claim that we purported that there was some sort of switch between Kenesha Page and Kiana Lyons, and they claim that this new document, this March memo, that does not relate to Kenesha Page, but only relates to Kiana Lyons, was relevant because they claim that we argued a switch theory.
Hey, counsel, share with me why this information is not relevant to the independent review of the trial judge. The first paragraph, this is to the file from Bill Fisher, interview of Ronald Van. ADA spoke with the defense counsel alone and gave him a copy of the defendant's statement. Also informed him that the defendant had given an informal, oral statement to Detective Brooks in Santa Mala. ADA didn't inform the defendant attorney about specific content of oral statements. However, counsel was informed that the oral statements were more expansive or conflicted with the written statement. Counsel was given an opportunity to speak in private with Van prior to the interview. Van was not immediately forthcoming, but eventually he probably told most of the truth in a patchwork, halting, painful, reluctant manner. Now share with me, why is that not information subject to review and a credibility call by the judge as opposed to being irrelevant as indicated by the federal defender?
So there were 3 statements made by Ronald Van that were disclosed.
I'm asking you about that statement. That's a file to the memo in the district attorney's office saying that there's a conflicting statement and that Van was not honest. How is that not relevant to a credibility call for this court or that court, the PCRA court, to make? But yet, you provided a subsequent July statement which even contradicted that. That's the question. Tell me. Because you keep accusing the former DA's office of hiding evidence. And sadly, I'm asking you to share with us why we shouldn't think the same of you.
So, Justice Dockery, what I would say is that this March memo about an undisclosed proffer that happened in March, there were many statements that were given, some disclosed and some not disclosed. This is yet another example of a private conversation that they had with Ronald Van where he gave information that conflicted with information that he gave in the disclosed statements. And in fact, at the beginning of that I think you read, it talked about how he had given other informal statements to the detectives. Those statements also were not recorded. So I don't know the full number of statements that Ronald Van gave and the changing nature of each one of those statements.
And you don't think that's relevant to a credibility decision which you stipulated is only made by the judge?
So I don't believe that I don't know that we stipulated, I mean, I know that we didn't stipulate anything to Ronald Van's credibility.
You can't.
No, what we agreed is that there were 2 memos written by Detective Baker, and appended to them was a fax to the Gannondale School that showed that Kenesha Page could not have been present at the time.
No, but I'm asking you about ADA Bill Fisher's memorandum to the file for which I just gave you the introductory paragraph. I'm asking you very simply. Defender indicated that it was not relevant. I'm asking you, do you believe a statement in which the district attorney has a file that says the defendant is not truthful, has not telling the truth, protracted statements, gave other statements, you don't think that's relevant to the PCRA issue? It's a yes or no answer.
I think to the extent it's relevant, it shows that yet again they found Van to not be truthful, which is exactly.
So wouldn't that be, now you're saying it's cumulative, right? Or no? Why was that not relevant?
I don't believe that this document is relevant to the Kenesha Page claim because Kenesha Page is nowhere in this document. And so therefore, and I didn't work on the case below, but I can say that looking at this, it didn't strike me as anything that was important to the Kenesha Page claim based upon the fact that Kenesha Page is not mentioned. But now standing before you, do I wish that we would have given the judge all 20 bankers boxes? Absolutely. However, former prosecutors who co-wrote the amicus briefs below, we offered them full file review. We gave 17 dates for one of the prosecutors to come in to review the entire file, and they never took us up on the
But
offer.
I believe exculpatory material is mandated for the Commonwealth to provide. It's not at the request of the defense, it's your obligation as a prosecutor, correct?
Well, so the defense did come in and do file review. I'm talking about that they are now suggesting that this document is so important, even though it doesn't mention the woman that Van falsely accused. And what I'm saying is and there's a suggestion that we were hiding documents, that we were trying to keep something away from Judge Bronson. And what I'm trying to say is that we offered them, or people writing their briefs, file review. They could have seen our entire file. We didn't oppose an evidentiary hearing. We recommended that the detectives be called in an evidentiary hearing. And I don't know what more we could have done to be transparent in that regard.
You said you recommended that the prosecutors be called?
Sorry, I think I said detectives, but if I misspoke and I said prosecutors.
Well, did you call them then?
There was no hearing.
I mean, you were in the driver's seat. If you recommended, I mean, you were in the driver's seat. You recommended that they be called, then why didn't you call them?
There was so much undisclosed Brady in this case, and as I said, there were many different claims. Kiana Lyons was one of the key witnesses in this case. She testified at trial very, very clearly.
No, that's not answering the question, but you said you recommended to the trial court, the PCRA court, right? You made a recommendation to the PCRA court that they hear from the detectives, right?
Yes.
Then why didn't you call them?
Judge Bronson said that he wanted to have a hearing at which he heard from the prosecutors. And we said that if he was going to hold that hearing, then we should also hear from the detectives. But what we said is that we didn't independently think a hearing was necessary because the documentation of the claim was so clear.
I think that's kind of brings me back to my point. If I look at those documents that you're relying on, I don't think it's clear beyond, reasonable argument that Van was directly implicating Page in the crime. I think your office, and you have every right to do that, I'm not saying you don't, but your office decided to agree with defense counsel that you both read those documents the same way. But are you telling me it's not possible for someone to read them a different way?
Well, I'll say to you essentially what was said to Judge Bronson when he also expressed similar skepticism as you, and we asked him to just look at the documents very clearly and make his own independent determination as to what he thought happened here. And after his full review of those documents, even though he expressed similar skepticism of yourself, he determined that...
You said that on the record to him, don't look at our stipulation, here's the documents, although you excluded one document, but here's the documents, and you make we're not stipulating to it. You make your own conclusion. You said that on the record?
I forget the specific individual who said it, if it was us or if it was defense counsel, but I think it was someone from my office. He said, just look at the documents here, and I think once you do, it'll be very clear what happened.
Yeah, but the documents themselves show what was said and when it was said. It doesn't say why. The only one who can explain why was the person who prepared the document, which keeps coming back to what Justice Brobson just said. This is why you need a hearing, because in essence, it's a backdoor attempt to stipulate the credibility. I mean, you're arguing it says one thing, and this is when it was, when it was said, and what it says on a piece of paper. They're arguing a different interpretation, but the only person that can tell you why he or she wrote that and what it meant was the person that wrote it, the author, which in this case would have been the detective or the DA. I mean, I think there's something here. Justice Doherty read you a quote from ADA Fisher, which was ADA Fisher's memorandum to the file about a proffer interview with Jerry Stein, who was representing Mr. Van at the time, right?
Yes.
So again, I keep coming back to the same point. It seems like you're asking the court to stipulate to what was said and when it was said without an explanation of why it was said, and it was subject to two different interpretations.
So again, to me, there are not two different interpretations. There's a document that a detective determined that Van was lying about Kenesha Page. And what Glossip holds is that...
But we know Van was lying. He lied throughout this process. He gave up little bits and pieces. He lied multiple times. But that all came out during the course of the trial, which comes right back to the argument about, well, even if you assume that your interpretation of this particular document was correct, it's cumulative. We know Van's a liar. He admitted it.
So at the trial, what was presented regarding that is that to the extent that Van lied across the 3 disclosed statements that the jury heard was to protect himself, to minimize himself in earlier statements. That's what was presented to the jury, and it was asserted that the jury could trust the final statement because the only way in which he lied was to protect himself. And so therefore, learning that he actually falsely identified a completely different person, that is a different category of impeachment that could have changed the jury's assessment.
But I'm not getting you here, and I'll tell you why. When you look at this particular issue, you have a young black girl who's identified at first. There's a Kenesha Page mentioned when he was giving up information on multiple other robberies. Then the name Kiana pops up. Eventually, we settle on Kiana Lloyd, right?
We settled on, I'm sorry?
Kiana Lloyd.
Kiana Lyons?
Kiana Lyons, correct.
Okay.
And Kiana Lyons is then brought in, and she testifies that she's part of it with LeVar Brown and testifies to it at trial, right?
Well, so
how does any of this relate to, I mean, why isn't it cumulative, and why do we know for a fact? I mean, we're talking about fundamental fairness. Kiana Lyons was ultimately the one who was identified as the black female Kiana. Then it turned into Kenesha Page, and it was back to Kiana. And then she said, yeah, I was there, I was part of it, and as was LeVar Brown.
So it is my opponents who claim that Kiana Lyons and Kenesha Page were replaced by Van. We have never asserted that. And actually, I think...
Wasn't she called to trial?
Excuse me?
Wasn't she a co-defendant, Kiana Lyons?
Kiana Lyons was a cooperating witness, but
Did she testify that she was part of it with LeVar Brown?
No, I'm not saying that Kiana Lyons didn't testify that she was part of it. What I'm saying is that the role that we've never said that Van said Kenesha Page played the role that Kiana Lyons did. And in fact, I would direct your attention, they say that we must be saying that, even though we've never said that, because they claim that Van only ever talked about one girl. But I would direct your attention to the supplemental appendix at 1168, where they have a declaration from Special Agent Brian Peters, who said, quote, I distinctly remember that Van discussed 2 girls that lived in the area and hung around these suspects regularly. And so what I'm saying is that Kenesha Page and Kiana Lyons just have nothing to do with one another, which is why we didn't think that a document that mentioned Kiana Lyons had anything to do with Kenesha Page.
Okay, I think we're beating, if not a dead horse,
No, I
a
have
nearly
one more
dead
question,
horse.
if I may.
Surely.
I want to bring this, back to the question of the King's Bench. We're trying, if we should, establish a procedure regarding concession of cases. Now, I find this more analogous to the Luzerne County juvenile, quote-unquote, kids for cash case in which the Supreme Court appointed a master to reverse adjudications of delinquency, only with regard to 2 particular judges and 1 county. With regard to this case, I know my colleagues keep saying that this opinion will affect all 67. I may beg to differ. Here's my concern. We know the Third Circuit, we know your office was reprimanded in the federal system. We're all aware that a common pleas court judge listened to testimony from your former chief of homicide, which in essence could be construed as perjury. And the record indicates through amici briefs that at least 130 cases, capital cases, have been conceded by your office based upon very similar allegations. That should bring to this court, our concern should be on the same basis as what was happening in Luzerne County to defendant juveniles, except now we're talking about homicide victims and their families. Share with me, with that information, under the assumption that we believe there's a problem in the First Judicial District, what is your recommendation as to how we should create a process for concessions in the PCRA matter?
Well, first I'm going to have to dispute that there is a problem in the district attorney's office.
Do you dispute that you were sanctioned, your office was sanctioned by Judge Goldberg? Is that a dispute?
No,
Do you dispute that was a scathing opinion regarding your office?
no.
Yes, okay. Did you dispute that a former homicide prosecutor indicated that he never reviewed a document for which he verified is true in fact, alleging the improper conduct of a district attorney? Yes or no?
I provided a letter to the court that
I'm asking you a question right now, Commonwealth.
the witnesses are under sequester, so if you're ordering me to answer the question, I will answer your question, but I'm under a sequestration order from the judge in that
Fair enough.
ongoing
I'll
matter.
respect that. Are you disagreeing that there's been over 130 concessions from your office regarding similar matters with similar allegations of improper conduct on the former district attorney's office? It's a yes or no.
Yes, but can I?
Okay, fair enough. No, I'm just trying to drive it down. Share with me, do you believe that there should be a process for now concessions regarding how a judge should, in the first judicial district, should address a concession by the defense attorney and the Commonwealth? What would you recommend?
What I would recommend is exactly what Judge Bronson did in this case, which is that he heard from the parties, he permitted amicus participation because in his view it was warranted and they wished to participate, that he read hundreds and hundreds of pages of briefing from all parties, and then he himself reviewed the record and determined in his own independent review whether relief was warranted. I think the way that Judge Bronson handled this case is the model for how cases should be handled, and in my experience is the way that judges handle their cases. But I did just want to say two things. One, we made a mistake in Wharton, and I am not here to say anything otherwise, and it's a mistake that I am committed to not make again. We have made sure that we are improving communication with victims, and we are now writing responses in all of our cases to ensure that the judge can see what our review was, and therefore that can assist them in their own independent review. And as to the fact that we've agreed to relief in approximately 120 cases, this is in the context of 2 homicide detectives having been convicted of crimes related to their work. And so that has led to quite a few of cases being reversed, and as well as our open file discovery policy that has brought some new Brady claims to light. But just as a comparator, there was a detective, Louis Scarcella in Brooklyn, who also, he was never convicted of having committed crimes, but he had found to have committed misconduct in his work. Our CIU reviewed all of the cases that Detective Nordo, who was one of the detectives that has been convicted of crimes in Philadelphia, out of 106 cases that Nordo worked on, they agreed to either exonerate or plead a lesser charges in 20 cases, which is a vacate rate of 21%. Comparing that to Brooklyn with Detective Louis Scarcella, their rate was 20.6. And so all I'm saying is that you can hear a number of 120 cases and think that that sounds a lot, but in the context of the large number of cases that we handle and in the context of the serious misconduct that has been committed by detectives who have been convicted of crimes, it's not as bad as it seems on paper.
Thank you for sharing that.
Okay, I think we understand, and this was well argued and exhaustively briefed, and we appreciate all of your input, and we'll take it under advisement. Now let's take a 5-minute break to allow Mr. Minner to clear the courtroom.
Much more IDAs. Wow.
Love it.
minor child to a trampoline park operated by appellants and digitally signed an agreement which contained provisions requiring arbitration of all claims arising out of or relating to the child's access to the facility. The terms of the agreement further provided that the signatory parent was entering into the agreement on his or her own behalf, as well as on behalf of the non-signatory parent and the child. While at the trampoline park, the minor children sustained personal injuries. At least one parent of each child subsequently filed separate actions in the Philadelphia Court of Common Pleas seeking damages related to their child's injuries. Appellants thereafter filed motions to compel arbitration based upon the arbitration provision of the agreements, arguing that such provision was valid and that the plaintiff's claims fell within its scope. The Common Pleas Court denied the motions to compel arbitration in each case, and the Superior Court affirmed the lower court's rulings. This court granted review to determine whether an agreement signed by one parent on behalf of a minor child containing an arbitration provision is binding on the minor child or is binding on the child's other parent. Please proceed.
Madam Chief Justice, may it please the court, my name is Andy Kessler and I represent the Sky Zone appellants. You are presented with a question that this court has never addressed, which is whether a parent may, on behalf of a child, agree to pursue litigation through arbitration as opposed through the court system. While it is unique in this Commonwealth that we don't have an answer, there are a number of other courts around this country who have looked at this issue, and most, if not all of them, have found that a parent does have that authority. It is vested with that privilege. The notion of whether a parent can bind a minor child to go to arbitration for prospective injuries that may occur in the use of an amusement is founded on two principles, both of which this court recognized in other areas, but which in this situation come together to, in our position, is compel the fact that a parent has this authority. One is that there is a presumption in the law that parents act in the best interests of their child.
And that they're the natural guardian of the child. The problem is, when we move on to the child's property interest, the child's estate, I don't know that that same analysis applies.
Well, the parents make decisions for their children in all kinds of affairs. So
They do, but that's not the same thing as forfeiting a right of action, which doesn't ripen until they reach the age of maturity.
but they are not forfeiting a right of action. They are merely choosing the forum for where that action is to be heard. And
I want to stop you there because what they sign is a release. It contains an arbitration provision, and that's what ends up being the subject of this case. But they do sign a release which, does what Justice Weck suggested.
But the question of whether the release is effective or whether it's contrary to Pennsylvania law is an issue for the arbitrator to decide. It's not a guarantee that that's going to occur. That's an arbitrator's decision point to make.
Only if we say that the agreement is enforceable, which is why we're here, correct? It's the only reason we're here.
Correct.
Because you want this to be, the arbitrability to be decided by the arbitrator, so the arbitrator can then enforce the immunity provision.
Or not. I mean, there's no guarantee that an arbitrator is not going to see that and say that that constitutes a waiver of rights that...
But it's a property interest that belongs to this child, and the child is entitled to make that decision upon reaching the age of maturity. There's a distinction between natural guardian and guardian of the estate that we tend to respect in our law. And you would override that distinction, wouldn't you?
I don't think it's overriding the decision, frankly, Justice Weck. It's really a question of, if you look at what rights parents are vested in, what they have the authority to do under the law, this is not something that is so out of that realm. Parents are vested with the right to bring an action.
But they can't discontinue it without approval by the court.
That's correct. And in any event, whichever way, if this case were to go to arbitration and an arbitrator makes a ruling, that's going to get reviewed by the court as well. Under the Pennsylvania rules, any verdict, settlement, award has to be approved by an orphans court judge.
Again, that's not the frame of analysis upon which we focus here. The frame of analysis we have to focus on is whether you can force the child into arbitration before the age of maturity.
And our position is, if the parents are vested with the authority to bring an action on behalf of a child, which they are, if they are, they don't have to get court permission first to file an action on behalf of a child. The parents are vested with the authority to go out and find legal representation. The parents are vested with authority to enter into a fee agreement with an attorney. The parents are involved with strategy during the course of any litigation, perhaps discerning what venue it's brought in, whether it's Montgomery County, Chester County, Philadelphia County, depending upon where everyone's interest lies. The parents are involved intimately with ultimately settling the case with the advice of counsel.
Not without court approval. They cannot compromise the claim, they cannot settle the claim or discontinue it.
And that's the only time when the court's approval comes into play. All the other decisions are left to a parent with the presumption that the parent is always going to act in the best interests of the child.
You're assuming, counsel, aren't you, that that this chosen action is the same, regardless whether we're talking about an arbitration forum or a civil or a court of common pleas. In other words, you're assuming, I think, aren't you, that this stick in this bundle of property rights is the same stick if it's an arbitration or a civil proceeding. It seems to me quite an assumption you're making.
If I follow your Honor's question, what I'm assuming is that the child's right to a cause of action, if a child is injured in the facility and wants to file a suit, that right is preserved whether the child goes to a courtroom or goes to an arbitrator. It's the same right. They're having the same issues that are going to be determined.
It's not the same right. In Pennsylvania, the right to trial by jury is a constitutional right. It is nowhere near the same right. What the parents are giving up here is a child's constitutional right to a trial by jury. The only contracts that are enforceable entered into by parents on behalf of children are those for necessities: food, shelter, clothing. This is not a contract that we would consider to be enforceable when entered into by a parent on behalf of a child. For that contract reason, and for the fact that we're talking about giving up a constitutional right to trial by jury.
And what you then have, Your Honor, is there's a balance that should be struck between the constitutional rights of the parents to raise the child in their best interests as they see fit.
We've already decided that. I mean, there are two different issues, really. I mean, if you look at it in terms of what our law in Pennsylvania is as to the enforceability of contracts entered into by parents on behalf of children, what you look to see is whether the contract involves a necessity. And those contracts are enforceable. This, just based on basic contract law vis-a-vis parents, children, and third parties, would not be enforceable. Without ever getting into the issue of the sanctity of the right to trial by jury that's being given up here, or attempted to be given up here by a parent.
And those issues as well are then, this Commonwealth has a policy, a public policy that favors arbitration. There's a federal preemption issue that exists with regards to the preemption for arbitration agreements to be upheld and the constitutional rights that the parents have.
Only if we jerry-rig our state law to result in non-arbitrability. This is not jerry-rigging our law to avoid arbitration. This is just pure and simple enforcement of our law regarding contracts by parents on behalf of children, and the ability to give up a right to trial by jury by someone other than the person who holds it until he or she reaches the age of 18, plus 2 years. I mean, all of those things are part and parcel of what the attempt here is regarding this arbitration agreement.
Well, I think what the attempt is here, and I'm sitting here arguing on behalf of the facility, but I'm literally arguing the parents' rights, which is my esteemed opposing counsel's client. But the fact is that if parents have the right to make all these decisions, why is this one to be carved out?
Because there's a property interest. It's very different from the Troxel versus Granville right to the care, custody, and control of one's children. The reason our law provides that this is postponed until the age of maturity is that the law recognizes a property right, a cause of action that's going to vest after the child reaches the age of maturity, and then the child will make a decision whether he or she wants to consign himself to arbitration for him or not.
And while I appreciate that, the issue that is troubling to me is that the property right, which is what Your Honor is talking about in terms of the cause of action, still exists if the parents decide, we would like to pursue this, we're not going to wait, we're going to pursue this now. The agreement that the parent signs in order to gain access to the facility for the child merely says you're going to pursue that in arbitration.
Give up your right to a trial by jury, right?
Correct.
Because it's a question, isn't it a question-begging proposition that you're advancing here? The question being begged is whether this is, the first question is this a valid agreement? We're not talking about the policy of arbitration at Santiago and Concepcion, et cetera. We're talking about whether there's a valid agreement here, aren't we?
Yes, and it's our position that there is a valid agreement. The child is essentially a third-party beneficiary of the agreement between the facility and the parent.
Well, a third-party detrificiary if we accept your construction.
Well, if you're assuming that arbitration is somehow inferior to the courtroom, I mean, we have a policy in the state that says arbitration is favored because it's quicker, there's fewer costs, it's less formal, especially if a child is involved. We're not saying that arbitrators are unfair or unqualified to do this. I mean, if we're saying that in every situation, arbitrators are not the equal of a courtroom.
We're not saying that. We're saying this is a child and that the law doesn't entitle forfeiture of his or her decisions until he or she reaches the age of maturity, makes that decision for themselves. It's a cause of action. It's a right. A cause of action is a property right.
And our position is it's not being taken away. It's merely a choice of forum. And in
Counsel, can I ask you a question on that?
Sure.
So I think I hope everybody agrees that put aside the arbitration clause for a minute. A parent can bring an action on behalf of a minor child for a tort committed on the minor child, correct? Doesn't have to wait until age of majority.
Correct.
So let's say the parents here sued in common pleas court, which I guess they did, right? Do the parents have the authority to ask for a bench trial?
I believe they do. I believe they could file the case as a non-jury case.
If this becomes a right to jury trial case, then arguably that proposition goes out the window. The parents can never waive a jury trial.
But a parent with assistance of counsel, obviously, they make the determination, do we file it as a jury or non-jury?
He's trying to help you.
I understand that. I'm thankful for that, to be quite candid. But that's the point. We vest parents with all these decisions throughout the litigation process. And I can't recall the case, but there was one situation in which the parent comes in and they disavow the contract. On behalf of the minor, they disavow the contract. And the court says, well, if a parent can disavow the contract on behalf of the minor, how is it that the parent doesn't have the rights on the other side of it? You know, it's like picking and choosing what the parental rights are going to be. And as a fundamental premise, parents have overarching rights as a parent, as long as it's not to the detriment of the child.
Your overarching issue here is a practical one, not a matter of our legal construction, because we have theme parks, we have sporting activities, we have every variety, not just trampoline parks, that this would impact, because our opinions obviously impact the whole state. And it's really a difficult proposition for an owner of that kind of an establishment to face if the right of a child in this kind of an agreement cannot be handled by the parent. What do? It's really a conundrum.
Well, that's what the amicus brief that was filed on our behalf is essentially their point, is that, you know, you have ski resorts in the state, you have ice skating rinks, you have go-kart, a ton. You go to a Phillies game 15 blocks down, there's something on the back of your ticket with regards to what your rights are if you get hit by a baseball.
There's somewhat different issues there, aren't there? The different precedents as well.
There are.
This may have been a different case, like in my view, if your arbitration agreement wasn't so very difficult. I mean, it cuts the minor statute of limitations to 1 year, and it basically acts as a complete release of all claims. If the arbitrator follows your arbitration clause to its letter, it's not merely saying, I'm choosing for my child arbitration. It's basically saying, I'm choosing arbitration and I choose to lose.
Well, I don't think I would go that far, Your Honor. I think what it says is, I choose arbitration. I have to make that choice in a timely manner, which is within 1 year. And yes, there is a waiver provision within the document, and the arbitrator is going to have to decide, based upon the pleadings, whether that's going to be upheld or not, or whether that's inconsistent with Pennsylvania law.
Is it severable?
Pardon me?
I mean, I didn't, you know, I confess error. I wasn't focusing on all the other things that are set forth in the arbitration agreement. I thought this case was simply a forum selection case. Is it your client's intention to seek enforcement of all those other add-on provisions to the arbitration clause other than the simple forum selection? So
what I can say is this, because I'm not an employee of Sky Zone, and I don't know what their corporate policies intend to go forward with, but the document, the participation agreement, is an evolving document for Sky Zone. There are versions that have been modified over the years based upon issues that have arisen with it. And what my feeling would be, and frankly my legal advice to them, is if we were fortunate enough to get a ruling from this court that says the arbitration provision is enforceable, that they remove those concepts of waiver and the statute of limitations.
Why are you saying that we are incompetent to say what portions of the arbitration agreement a parent can consent to, but what portions of the arbitration agreement they can't?
Well, it's not an arbitration agreement, right? It's a
participation agreement.
A robust agreement with an arbitration.
Well, I'm focusing on the arbitration clause.
That's because Superior Court called it an arbitration agreement, but I don't think it is.
Well, okay.
I'm not saying that this court is incompetent to do that. I was saying that in your question, you limited it to just the arbitration provision. My feeling is this court is empowered to do whatever it wishes to do
that's what's in front of us.
Yeah. Correct.
Is the arbitration provision of the participation agreement, and you know, I've signed these, by the way. I mean, I think every parent in this room has probably signed these things. My question is, could we say the forum selection of arbitration is something that a parent can consent to for a child, but other limitation things in there that relate to the substance of that proceeding and how that proceeding will go and what defenses there are, what waivers there are, that stuff is a no-go?
I believe that type of clarity is exactly the reason this issue needs to be decided. You know, in arguing this in the trial court level, in the Superior Court, the fact that this was a case of first impression was kind of odd to me, given the prevalence of these types of agreements throughout industries in the state. I think that if this court is going to make a pronouncement about the arbitration provision and whether or not that can be enforced, I think it is equally available to this court to say, we are going to allow this type of provision. However, it may not include the following. Those negatively impact the property rights of, a participant in this type of activity, whether it's ice skating or skiing or going to a trampoline place.
And we can, in your view, in your client's view, blue line the arbitration clause that way.
I think that the issue here is that the arbitration provision should be enforced. If the only way to enforce that is to limit the other scope or mechanisms within that provision, then I say that that has to be done, yes.
And in that approach, the sky would not be falling, in your view?
I don't think the sky is falling one way or the other.
We could make the sky fall.
I'm sure. But my point is, I think that the key issue here is simply, can a parent agree to this type of forum for these types of disputes? And, courts in California, New York, Florida, Ohio, there was a recent decision by a federal court in Illinois that all found the same thing, which is it's inherent in the parents' constitutional rights to raise their children to be able to pick the forum in which the case is heard.
The only problem, and this all makes so much sense when you say it, but the only problem is you're moving over to the other lane so effortlessly from guardian of the natural guardian of the child to guardian of the child's property. There is a difference.
Okay, if you want to open up a bank account for a child, there has to be an adult present, right? You can't just take the child into the bank and say, go ahead, have at it, right? Similarly, if a child is given money by a relative or a friend, who takes control of that property? The parents do. Because the presumption is the parents are going to act in the child's best interest. Are there situations in this world, unfortunately, where the parents don't? Absolutely. But you can't take the exceptions and somehow eviscerate the general concept, which is that parents, we watch out for our kids and try to make the right decisions. And if a parent reads this agreement and says, you know what, I'm not going to let my son or daughter jump on a trampoline because I don't think this makes sense to me, they're free to do so. And that's all there is to it. But to come in and say, well, I didn't have the right to do it, I think that's the distinction that Sky Zone is trying to draw here. Parents have the rights to raise their children as they see fit. There are guardrails in place, just like the courts have a procedure in place so that if there's a settlement, comes before a judge and they say, you know what, that's fair, or they say to an attorney, hey, your fee's too high, or how come these costs are out the window? There are mechanisms to ensure the fairness of it. And they only come into play in the legal situation at the end of the case. They don't make any issue in the beginning about how you retain your attorney or what court of common pleas you file a lawsuit or who you may include as defendants. They don't get involved in settlement discussions. It's only at the end where they say, okay, we're going to make sure this was fundamentally fair on behalf of the child, to make sure that there isn't any overreaching on behalf of the parent or, God forbid, an attorney. So that's our position, that there are guardrails in place here. And if there's only, as I understand it, there's only one other state which says as clear as a bell that you can't do it, and there are at least a dozen others, I don't believe that the explanations and the justifications that have been provided by those courts for why they found this way are any different than they would be in this Commonwealth.
You make a strong argument. Are there other questions for Mr. Kessler? Thank you. Let's hear from...
Right, Justice Mundy does.
I'm sorry.
Doesn't your position run afoul of the tenet of law, the proposition which is that a minor's claim includes claims for a minor's pain and suffering and for losses after minority, which Pennsylvania law prohibits the minor from personally bringing before reaching majority?
I'm not sure that I can, I'm not sure I understand the distinction being made there. The fact is that when you file a lawsuit, whether it's on your behalf or behalf of a minor, your recovery, theoretically, is for all your issues that have gone on in the past and a consideration of what you're going to incur in the future. So, my future pain and suffering is part of any verdict. And if a settlement does not take that into account, an orphans court judge would then say, I can't sign off on this, it doesn't make sense to me. So I think that the rules of civil procedure afford a guideline for assisting the court with that.
Counselor, are you submitting your first issue on the papers? You didn't advance your first issue at all.
My first issue?
Spousal.
Oh. I will.
Are you abandoning it, submitting it on the papers?
No, if the court would like, I'll address that summarily. I think that this issue about having both parents have to sign the consent form is a false narrative. I think it is a convenient way to argue that the agreement doesn't bind everybody because, well, one parent isn't there. But as I understand it, in this Commonwealth, both parents have equal responsibilities for the upbringing of the child.
But that's the upbringing. Reverting to the issue of the child's upbringing and proposition of family law has nothing to do with this agency question. I mean, there seems to be a presumption that the one spouse is the chattel of the other, and that's a concept completely foreign to agency law.
Except I think that question is sort of dependent upon the other issue that we've talked about. So if a parent can enter into an agreement on behalf of the child to pursue arbitration, one parent can enroll a child for school, public school in this Commonwealth. You don't need both parents to sign. One parent can sign a consent form so that surgery can be provided to a child.
I think you're mixing the two issues together. This issue that you're addressing now, as I understand it, and Justice Wecht has asked you about, relates to the ability of one parent to bind another parent for the parent's claims as a result of the injury, not for the child.
And the parent's claims in this instance are always derivative of the child's. So if the child is bound by the arbitration agreement that one parent can agree to, then those claims should be, for lack of a better phrase, following that decision.
But in this case, Mr. Santiago was not there, and Mrs. Schultz was not there. Under what theory of agency law would you maintain that those absent adults are somehow bound by something they may have had no idea about?
In the facts of these two cases, both parents are not present. One parent has testified that I believe she was aware that the father had taken the child to the Sky Zone 6 months earlier, and this was the second time in 6 months the child came back. So you only signed the participation agreement once. The issue for the agency part of it, Your Honor, is that how can any business in this Commonwealth go into the type of inquiry necessary to make that determination in the course of its business?
Well, I'm not here to manage a business. I'm here to decide a legal issue along with 6 colleagues. And how a business insures or runs its business is not my business, right? So whether they want to tell the one parent, bring the other parent, right, or whatever, it's up to them. But we don't have the law of coverture. Like the one spouse is not owned by the other spouse. So I just don't see your agency theory here.
And I think that the agency theory does not fit easily into any of the categories that exist. I agree with you. It's a difficult issue to deal with because what you're basically saying is anytime one parent is going to make a decision for a child, that's not binding. You'd have to have both parents make all those decisions together.
I don't see the issue that way. I think the issue is, I think you could win on one and lose on the other. I think you could win on the can a single parent bind a child to a forum selection clause. I think you could win on that. This is a different question. Can one parent bind another parent to a forum selection clause? That's, to me, a separate question that could reach a different conclusion.
And if you don't bind the second parent who's not present, inevitably it's that parent who turns into the guardian for the purposes of the lawsuit.
No, that doesn't mean that that parent can then turn around and bring an action on behalf of the child in a common pleas court. That just means that whatever derivative claim they have for that is personal to them can be brought in a common pleas court.
Correct, and that's my point. In other words, the spouse that's not present invariably turns into the named plaintiff because they have a claim for the medical expenses that they want to pursue. And then you are caught in a situation where the primary claim, which is the child's claim, which is now bound to arbitration, has a train car behind it that's a derivative claim for medical expenses, and you're then going to say, well, the arbitrator can't decide that. Now you're going to have then two separate actions in two separate jurisdictions, and that's a problem.
Counsel, is that possible under Pennsylvania law? I don't think we can split causes of action that way in Pennsylvania. So if you lose on the first issue, the parents don't have a claim to arbitrate. Their derivative claim will bide the event of the child's claim.
Correct.
Correct. So I think that's sort of the end of, I mean, if we decide the first question against you, then the second question becomes moot.
Right, and I think the corollary is if you decide the first question in my client's favor, the derivative claim has to come along.
Probably true. Probably true.
Any other questions for Mr. Kessler? All right, thank you very much.
Thank you.
Go on. Hear from Mr. Schmidt.
Madam Chief Justice and other justices, may it please the court. I'm Jeffrey Schmidt. I'm here on behalf of Aplt Alessandra Schultz. I would be remiss if I did not introduce Mr. Foley, who wrote the amicus brief, who will not be presenting here. So most of my brief and most of my arguments were gone through already by this court, but I'm going to start off with addressing many of the points which Mr. Kessler has made, which have been addressed here. The first one is the action itself, where we talk about where the parent may bring the claim or disavow the contract, but that doesn't really tell the entire part of that story. What a parent may do is bring the claim within 2 years, within the child's age, before they reach the age of majority, or they may choose not to do so at all. Then the claim accrues to the minor, and they have 2 years as an adult to do it. During that period before they've reached the age of majority, it's under the court supervision at all times. It is not the parent doing it by themselves. The moment they decide to invoke court jurisdiction, they're no longer controlling the property, which is the point that's been discussed, that it's a property right here.
Counsel, if you just expand on that a little. When a parent brings a court action when their child is still a minor, they proceed as guardian ad litem. Is that correct?
That is correct.
Okay, and that is just contrary to any concept that's attendant to bringing a claim in arbitration.
Yeah, that is correct. That is correct. And
Can you expand upon that? How's that correct?
I'm sorry, I don't understand.
Exactly. That's why I don't understand either.
Because
How is that correct that somehow arbitration is that a parent is acting in the best interest of a child in common pleas court, but not acting in the best interest of a child in arbitration?
Well, there's safeguards for that, because then there are judges who review it at different points, just like cases that I've had. Yes, it can move forward to settlement, and then the judge decides whether...
You're saying that's impossible to layer on top of arbitration? That if you go into arbitration and you settle it, that going to the orphans court for approval of that settlement can't happen just because you chose an arbitration forum?
I think it takes it out of the court's ability to monitor the proceedings as they go.
But it's more than the court, isn't the point that the child gets to make the decision on that upon reaching the age of maturity? It's not that arbitration is inherently evil or anything to that effect. Isn't the point that it's divesting this future adult of the power to make that decision about this right that he or she has? Isn't that the point?
That is the exact point, and it's divesting them of what's a constitutional right.
But doesn't the parent, are you telling me that when a parent chooses to initiate a common pleas court action in Dauphin County instead of in Philadelphia County, that they need court approval to choose the forum?
They don't need court approval to choose which judge to bring it under, but under the supervision and control that a trial court does have over the proceedings, a trial court has the ability to make an independent determination as to whether the case should be transferred.
Or whether or not the parent is the appropriate guardian ad litem.
That is exactly what...
A parent calling themselves a guardian ad litem isn't the end of the day. Someone can challenge that parent's suitability in court. I know it's happened.
Yep, whether they have the right to bring it. And I've also seen a court make a decision whether it was the appropriate time for a claim to be brought based on the permanency of injuries and the level of healing.
Counsel, you indicated that the child has a constitutional right. One, to do what and what constitutional right?
They have the constitutional right to a jury. They have the Constitution, and that's a property claim, that they have the constitutional right for their case to be heard by a jury.
So the parent can't waive a jury trial?
It's not a matter of waive a jury trial. It's a matter of they can file as a bench trial, which is what I believe that you discussed earlier, but then that will come before a judge who will make a determination whether that jury trial should be waived or may be waived or not.
But how does that come before the judge? I'm speaking practically. You're telling me that you file an action on behalf of the child, the parents, and the parents waive a jury trial. They don't want a jury trial. They want a bench trial. You're telling me when they put on their pleading that they want a bench trial, that somewhere down the road, a judge sua sponte is going to say, okay, now we need to have a hearing on whether the child's best interests are secured by waiving of a jury trial. You're saying that actually happens?
It can happen.
No, I'm not asking you if it can. We're talking about safeguards that appear in the common pleas court that don't appear in arbitration.
Yes.
So either the safeguards exist or they don't exist. Opining whether they might exist doesn't mean they exist.
I apologize if I said they might exist. They do exist. We have pretrial conferences before judges who have, in my experience, looked at all parts of the case, whether the correct medical experts are in play. I've never filed a minor's action looking for a bench trial only. I've only wanted a jury, so I've never faced that particular question. But along with all of the other elements of a case, that would be looked at by a judge, and if it's not appropriate, that can be changed. In Philadelphia County?
I think that's a pretty strained argument. Wouldn't it be a better response to Justice Brobson's insightful question to say the dividing line is not between a bench trial and a jury trial, but between the decision prematurity to consign oneself to the arbitration?
Thank you, Justice Weck.
Rather than the civil proceeding.
I'm just responding to the fact that you talked about the right to a bench trial, and you're saying the bench trial right, or the right to a jury trial, and you're saying that the jury trial right is the property interest here. And if it is a property interest following the rationale that you have invoked, it can't be waived by a parent.
I don't believe it can be waived by a parent without judicial oversight, but as Justice Weck said, that it's still the court oversight. Those are the rules of civil procedure our legislature has promulgated, where all of that has to be looked at by the court. There's oversight, there's control. We lose all of that if we go to arbitration and have it outside of the court system, not to be heard by judges.
I would be remiss if I didn't point out that your client signed a waiver that you're now claiming is unconstitutional, so their child could participate in an activity that was inherently dangerous.
Well, with all due respect, my client did not sign a waiver. Alessandra Schultz signed a waiver. Her estranged husband, who she was separated from, came in from his military leave after he was forbidden from taking the children there, decided this would be a fun thing to play cool dad, took his kids to a trampoline park. He signed the waiver. They've been separated since then. So she absolutely did not sign a waiver. She would not have, and she would not have taken her kids.
Did he have joint legal custody or no? Because I didn't see that in the record.
There was not a custody order in place at that point. What he had done is he had enlisted, and he left the area. He was in Virginia. He came up.
So without a legal custody order, are you saying just because parents separate that they, without a divorce or without family court involvement, that one parent has more rights than the other?
I'm not saying that.
That's what you just said. I'm trying to have you clean that up for me because I'm not buying it.
Well, Justice, I was specifically responding to the question whether my client had signed that. And my point was simply that no, she had not signed that.
It's a thin reed to stand, I mean, it would be an awfully thin reed to stand on to parse or decide this case based on degrees of estrangement between parents, right? I mean, the issue isn't, are these folks estranged, separated, living together episodically or whatever, the legal issue isn't determined by whether they're an intact marriage or not, is it?
No, it is not.
And also, the issue isn't the constitutional right to a jury trial. The issue is this arbitration agreement binding? Isn't that the issue?
That is the issue.
So that comes before the question, the validity of the arbitration agreement comes before everything else, doesn't it?
It does. And there's a question of whether an arbitration agreement like this can even be entered into by a parent. One of the common things that we deal with in practice is that the guardianship of as a parent and the guardianship of their property are different. If we write wills, those are different rights. If we bring lawsuits, those are different rights. That's the parent's patriae by the court, as opposed to the ability of a parent to just bring
The appellant and its amici are afraid, I think, that these bounce houses and sky zones are all going to move to New Jersey and Ohio and West Virginia. How do you respond to that? And Maryland, New York?
In other words, the sky will fall.
Well, that's not happening. They're not leaving here. But they draw the line where they say, we're not looking for exculpation, we're only looking for the forum. So if they're not looking for exculpation, are they really? Are they looking to shorten the statute of limitations? Are they looking to get out of cases? Or they just want to have it moved elsewhere? Because if they're looking to move the forum, then they're still on the hook for negligence. You can't exculpate that. And they don't have to operate their premises any differently if they're going to be on the hook for negligence.
So what would you consider the alternative for businesses who want to limit their liability if children are not covered by the arbitration agreement?
They don't have that ability. That's a cost of doing business. If you want to have minors here, their property rights cannot be waived in respect to this. Schools can't do it when they go on school trips. Jump houses can't do it. They have that right. That's the risk of having entertainment for minors, which could
It's interesting that a juvenile doesn't have a right to a jury trial in, say, a delinquency proceeding where he or she could be convicted of a felon and removed. But a child who has a property interest for a bouncy house, that survives until the child's 18. Seems somewhat conflicting, doesn't it, with regard to putting money above a child's liberty?
I can't say that because that particular instance has been specifically contemplated by the legislature and I believe this court, while in terms of contracts and property rights, it has not been.
We could derive it from, McKeever, the 1971 case, which the Supreme Court said that delinquency proceedings are not criminal, they're rehabilitative, but therefore it precludes a child from having a jury trial. But yet, somebody who might injure an arm or a leg in a bouncy house, that right is preserved to he or she's 18. I just find it interesting.
Good subject for a law review article.
The right is actually preserved.
What's that?
I was amusing.
I apologize. The right is actually preserved until they're 20.
Okay.
Not 18.
Works.
Do you have the address of the Journal of Trampoline Law?
All right, do you have anything else for us, Mr. Schmidt?
We got it.
I do not.
That's great. Thank you.
Brief. Thank you all.
We're going to hear from Attorney Chikata, whose name I may have mispronounced.
Madam Chief Justice, Your Honors, my name is Reno Sakata. I represent the Santiago family in this matter. I promise I will not cover territory that's been covered extensively so far by other counsel. One thing that concerns me about arguments that have been made by Mr. Kessler, first before the trial court, then before the Superior Court, then in his brief for this honorable court, and then again today, is the extent to which he agrees that this participation agreement is more than just an arbitration agreement.
Well, it is more than just an arbitration.
It is.
It's an agreement which contains an arbitration provision.
It is. It also contains a very explicit liability waiver. It specifically says the releasing parties hereby forever, irrevocably, and unconditionally release, waive, relinquish, and discharge from liability, Sky Zone. Now, Before the trial court, Mr. Kessler did not suggest that Sky Zone would be interested in focusing only on the right to a forum, to arbitration. He did not suggest that they would be setting aside the liability waiver. And then, before the Superior Court, Mr. Kessler did argue, and it is in the record before the Superior Court, that Sky Zone would indeed set aside the other right-restricting provisions of this agreement, the statute of limitations provision, and the absolute liability waiver. Now today, and in his brief before this court, he argued that Sky Zone does not now seek to have Apelli's claims dismissed. However, today, before your honors, Mr. Kessler said, well, we're going to leave it up to the arbitrator now.
I don't know how this has anything to do with us, because the issues we took, that we granted on, are focused on the arbitration provision of the participation agreement, nothing else.
Well, Your Honor, the participation agreement is not simply an arbitration.
I agree with you, but our questions only focus on the arbitration provision, nothing else. We're here only to decide whether the arbitration provision set forth in the participation agreement. That's what our questions say.
But, Your Honor, if the participation agreement goes directly to the minor's property rights, and the child's cause of action is a property right, then an agreement that turns over to an arbitrator, the decision whether or not to honor the liability waiver provisions in the agreement, goes directly to the child's property right.
I'm not saying it does. I'm not saying it doesn't. I'm simply, and maybe my colleagues will see it differently, but I didn't review briefing in this case as involving whether a waiver of certain causes of action are enforceable, whether this is. The questions we took were simply related to whether one parent can bind a child to an arbitration forum and whether one parent can bind another parent to an arbitration forum. That's it.
Correct. And with respect to that, Your Honor, the questions that Mr. Kessler was answering and addressed before this court today as to why, if he were making the decisions for Sky Zone, he would get rid of the other provisions, that came before Your Honors today. He said if he were making the decisions, he'd focus only on arbitration. Unfortunately, this court has to consider the fact that this participation agreement is more than that, and they are now saying the arbitrator will decide whether the child's claims are
well, and
dismissed.
that may be error. I mean, that may be error. And if the arbitrator enforces those provisions, there is relief available. I mean, if that is a clear violation of Pennsylvania law, if it's contrary to the power of the arbitrator to make those calls, there is a safety valve associated with that.
Well, Your Honor, I do not think we get to the point of considering that, because I do not believe we have a valid arbitration agreement in and of itself. Right. Which brings us back to what Your Honor was discussing. There is no evidence, excuse me, in the very limited Santiago record that there was any form of agency authority given to Ms. Santiago to speak either on her husband's behalf or on the child's behalf. There wasn't expressed, there wasn't implied, there wasn't apparent authority. Sky Zone had no interaction with Mr. Santiago.
Is there provision in the, you're going to get me on this one, right? Is the provider, the participation agreement, does it have, I hereby represent that I have authority to bind the child, that kind of a thing?
Yes, the mother signed a document that says that she had the authority by signing it to bind the child.
Okay, so that's not a representation of apparent authority?
No, but the issue for apparent authority is that the principal, Mr. Santiago, would have to have either vocalized or demonstrated by some action to Sky Zone that Ms. Santiago had the authority to act as his agent.
I apologize. I was focusing on the one question related to binding the child, not the question relating to binding the other parent.
Okay. As far as the issue of binding the child, the cause of action is a property right. Outside of the context of litigation over injuries, in the context of estates and inheritance, where a parent is acting not simply as the natural guardian, but also acting as the guardian of the child's estate, the court there has all kinds of supervision over what a parent can do. There are reporting requirements, inventories, periodic accountings that parents who are acting on behalf of a child and the child's estate have to provide to a court supervising those actions of the parent on behalf of the child. Here, we're talking about a fundamental constitutional right, the right to have this case adjudicated in a court of law, and the parents in both the Schulz and Santiago cases did not have the authority to waive those rights on behalf of their children.
Any other questions? All right, thank you all. Mr. Minner, the court is going to take a lunch break and we'll resume at 1 o'clock.
consent when his mens rea would be at issue, Justice Donahue.
I'd like you to address this issue of whether the alleged similarity among the three crimes could apply to any stranger rape, because to me, there are all kinds of stranger rapes. They don't necessarily meet this definition.
So there's certainly some commonalities, and I will say bluntly, anyone can find commonalities anywhere. So if we were to look at some of the commonalities, and forgive me, I'm going to actually turn to my chart so I get this right. It was 3 women. Non-commonality, different times of day, different years, different parts of the city. Commonality, there was sexual assault. Non-commonality, one was oral and vaginal, one was attempt oral and vaginal, one was vaginal. Non-commonality, one involved an offer to sell headphones. One was standing outside a store flashing money at the woman, apparently for sex. One was the woman approaching him and saying, can you sell me cigarettes?
Commonality only, there were 3 women each alone on the street, not an individual who breaks into a house or cuts through a screen or crawls through a window.
One was outside a store. I don't know, I just don't remember if alone qualifies. There's another non-commonality which makes this very different from Hicks, where the commonalities at least were more. And that was, one was a knife, one was no knife, but a punch, one was a tire iron. So we say, oh, they're all common because they have force. But no, they're not common. In Hicks, the court talked about the plurality, talked about it's always to the neck. It was always the threat to kill. It was always with drugs. So again, and I say this, I wish I could figure out the litmus paper test for when it's true commonality as opposed to propensity.
Well, here it was commonality by an element of force, not by poison or a date rape drug or something like that.
Certainly, but
Now, counsel, let's assume all of the rapes were performed in precisely the same way and there was some oddity in each of the rapes. There was no question of identity in any one of these 3 cases?
correct.
I still, even if they were done exactly the same way, and I know this is a difficult thing for almost everybody to accept, but unless there is a reason for offering the prior act evidence that's necessary for the case, you can't get it in because it is otherwise being used just to show that this defendant committed other crimes.
Exactly.
I mean, and that's why I keep getting back to the point in this case, why it eludes me how we actually get to the issue of defining what a plan is, or what a scheme is, or what anything else is, where there's no reason to offer the evidence in this case other than to show that he has committed other rapes.
And therefore, thereby to bolster each individual complainant's credibility.
To show his propensity to do the same thing. I mean, maybe that's okay. I mean, apparently our trial courts have a very hard time accepting the notion.
How do you balance that position against, say, the commonalities of the methodology, AKA, I'm looking for a woman, I know her, or I think she's a hooker or a prostitute, I'm going to go up to her and engage in some type of conversation, and then I'm going to rape her, and then I'm going to say, and I'm going to leave my semen, and I'm going to say it was consent. That to me, is commonality of methodology. Whether one woman is in North Philly, one woman's in South Philly, or one woman's in Jersey. We're not talking about specific commonalities in the sense that I'm raping everybody in this apartment building. So how do you balance that? Because I think that's the problem with trial judges. I know I did it myself as a trial judge.
So I think the word balance there has 2 meanings. One is, can we balance between where's the line between propensity and something of a non-propensity nature? And I'm going to suggest, sadly, that, especially in an urban environment with a lot of poverty, this is rather common, not a commonality to one person. The second is the fewer features that are really distinctive, my word. I don't want to go to signature, Justice Dougherty, but distinctive.
You are.
Well, distinctive. So I say respectfully, I don't find those particularly distinctive, and one of the issues is, unfortunately, we don't have a database of how many rapes are committed on vulnerable women who are or look like prostitutes, and we certainly know prostitutes are a particularly vulnerable population. But the fewer the defining characteristics, if you will, the probativeness goes down. The risk of unfair prejudice goes up because the greater likelihood of propensity reasoning comes into play. So that's the second balance. And Pennsylvania, if I may note this, is different from the federal rules of evidence. In our rules of evidence, we have a balancing of probativeness and prejudice right in 404. Federal rules use 403, which is the unfair prejudice has to substantially outweigh the probativeness. Ours is the opposite. The probativeness has to outweigh the unfair prejudice. And in the Yale case, this court talked eloquently and clearly about the kinds of prejudice there are. We are stripping people of the presumption of innocence. We are inviting a jury to accumulate evidence that in each case on its own would say, I have a reasonable doubt. Gee, I'm overwhelmed by the numbers. I guess he must be guilty. So
let me ask you this question. In response to my question earlier, you said the Commonwealth said they were offering this to bolster the credibility of each of the witnesses.
Right.
Is that a legitimate use of prior acts evidence?
I don't know of any case that says that expressly. I suggest respectfully it should not be, because it is an exception that swallows the rule. Because the second someone has two cases or two allegations, it means as soon as you say person one consented, somehow the fact that someone 2 years in the past, 5 years in the past, in radically different circumstances, accused me of a non-consensual act, comes in to say, oh, didn't consent here, we're allowed to bolster the credibility here.
But isn't that sort of the predicate question that we have to grapple with? Why can you offer 404B evidence? My understanding is that you can offer it to establish an element of a crime or the defense. If you don't have a 404B evidence that fits into fulfilling one of those needs, you aren't even talking about allowing it into evidence.
Justice Donahue, the last thing I ever want to do is disagree with a position that is incredibly favorable
tell me if that's wrong.
I think that's a tiny bit wrong because of the one exception of motive. Motive is not an element of a crime, but 404B is allowed for motive. So in terms of being honest to the court, I have to say on that one, but other than that,
that's a good point.
It is proving the actus reus, right? Did you do this? You've done that. So it's proving mens rea, the famous or infamous cases about doctrine of chances, or the parent who had 20 kids suffer, I think it's called a cyanotic episode, and they say, whoa, that's too much, or the less famous, the multiple wives dying in the bathtub.
But how
right?
about,
But that's
the doctrine of chances?
So
that goes to identity?
yes, it can. Yes.
What else can it go to?
Accident, right?
I'm sorry.
An accident
To
defense.
refute accident. That's
to
exactly
go
right.
against the defense of an accident.
Yes. And
What's the
under-
likelihood of an accident
right.
happening 10 times?
And under doctrine of chances, and the reason I suggest that has no applicability here, is number one, you need numerosity. You wrote about that, Justice Donahue. Number two, you need significant similarity. And
But you also need to establish identity or lack of an accident.
Right.
I mean, I understand everything you're saying about the characteristics of the prior acts evidence here. That's sort of beside the point. If you don't have a question of identity and you don't have a claim of accident, what is the evidence being offered for?
I don't know.
Well, the numerosity element of anything civil or criminal that comes in front of a court is a very difficult difficult issue to deal with. Is 2 enough? Is 5 enough? Is 7 enough? So I'm going to avoid that. Chief Justice Saylor's opinion in Hicks, how could that not be applied here to address the consolidation question? You have a defendant who wasn't contesting that he had consensual sex. His defense was they were all prostitutes, I paid them all, and they are now all having some form of remorse and are out to get me. I guess the question is if why under Chief Justice Saylor's view would the prosecution not have every right to show other instances where in these two other cases, I guess the 2 to 1, right, is 1 to 2, 2 to 1 is when you're counting the numbers, that the likelihood, the accident that you would have consensual sex with 3 women, all of them you paid, and then would turn around and say you raped them.
Or didn't pay, but whatever, right? Because one of the arguments was one of the women didn't get the pills she was hoping for. Justice Brobson, I will do my best. The difficulty is, number one, and it goes back to Justice Donohue's question, traditionally it's to prove an act or identity, absence of mistake. So we're now expanding that when even then Chief Justice, forgive me, Saylor acknowledged, and all the commentators do as well, that doctrine of chances is a pretty slippery slope. And so, and I keep hearkening to Edmund Winklereid, what he wrote is the test is extraordinary coincidence. And to do extraordinary coincidence, at least from his academic perspective, and he was a prosecutor back in the day, he was in the military, so he knows the trial courts, not just the books on the shelf, was if you're going to argue extraordinary coincidence, you want a baseline. Just like with the cyanotic episodes, how often does that happen in the general population? Sadly, the incidence of men who have been accused of rape more than once is not a low number. And so we'd need some more data, I'd suggest, if we're going there at all. But I think it's a very slippery slope, and
is there a stopping place on that slippery slope? How is the doctrine properly used to defeat a claim of accident versus a slippery slope to propensity?
It would be the numerosity along with the distinctive nature of the act. So if I said, oh, my first wife died in the bathtub 1 week after I took out the insurance policy, I say this with my second wife here in the room, so I do it most carefully, but you understand the rest of this, right?
Well, we had the Tubb case in Allegheny County a few years ago, the Bukowski case.
Okay, and so something like that, but it's appropriate for doctrine of chances precisely because in human experience, with the distinctive nature and with the recurrence.
But just one thing on that, if I may. Since you and Justice Brobson both were going at numerosity there for a moment, what guidance would you have us give trial courts, if any, on how much numerosity is enough numerosity?
For doctrine of chance? So the easy cop-out answer, but it is a cop-out answer, but I think it's actually the right answer, is someone has to come in and establish some sort of a baseline. And that's somewhat easy in the medical area, as you know, Justice Wax, with cyanotic episodes or something like that. And remember, that's where this doctrine emerged. This doctrine did not emerge on mens rea in particular. It was the peculiarity of a almost signature-like abnormal circumstance that very few of us have. And I think if I may briefly, one of the articles talked about, if it happens once, maybe. If it happens twice, maybe. If it happens 3 times and it's so peculiar, we have a problem. And that doesn't even prove in the literature that the first one was necessarily criminal.
I guess your answer then, because again, I don't want to touch the numerosity
I
thing.
agree.
It's dangerous. Your answer to my question then, if I understand it, is it's not unique enough for a defendant in a rape case to assert that the victim was a prostitute who is only accusing me because they regret the encounter. That is too common to allow the Commonwealth to produce other instances where that would sort of rebut that chance, the chance of having multiple consensual encounters that then turned around to be accusations of rape.
If until we have some baseline, the answer is I don't know when it's no longer common in terms of how many.
So it could be.
I imagine if we knew more, and that's exactly what a prosecutor's office could do.
So I think that's interesting, and I think it's a prescient point, and because if that is the law, then the Commonwealth should be given an opportunity to bring in expert testimony. I mean, in other words, this is something a jury couldn't sort out for themselves. You're saying, even if they brought in 15, a jury couldn't, using their own knowledge and experience, deduct, wow, 15 prostitutes, alleged prostitutes, that he's now saying have buyer's remorse, and that sounds beyond crazy. His defense can't be true. You're saying that even a jury couldn't make that determination.
It would always be a threshold determination for a judge, unless for some reason the defendant didn't object. So the real issue is going to be at the hearing before the judge. Could a judge say properly, I'm sorry, Mr. Epstein, 8 bathtub deaths, I don't need any data. I'm letting that go. I think a judge probably could, and
8 wives in and of itself is suspicious.
That's a separate issue. But with what I'm sad to say is a recurrent crime, rape. We need some, as the scholars say, some baseline, some data, something. And
Okay, do you want to sum up on that
Yes.
issue and then move on to, if you want to say anything about your admissibility of the nurse's report?
That's going to be my colleague,
Okay.
Mr. Sosnoff.
You'll say nothing about that. Do you?
I will say nothing
sum up on
about
this?
that. Just that we ask this court. I do have one very tiny. And Justice Robson, this court has never really adopted doctrine of chance as a majority rule, to my knowledge, in terms of mens rea or consent or anything like this. The one case that's cited is a case called Donahue, but that's physical acts of 2 children under the care of one person in one place, and they both suffer extremely distinct and parallel injuries. And that was for the limited issue of accident. So I don't know whether it's proper to say doctrine of chances applies to everything in the world. I think it should be narrowly construed because all of this goes back to the slippery slope. 200 years ago, 170 years ago, The Pennsylvania courts decided propensity is a real problem and that we're going to protect against it. And it's hard to do, and it's hard to find that line. I suggest the narrower the line, the better. I thank you for your kind attention.
Thank you very much. Let's hear from Mr. Sosna.
May it please the court. The only issue here with the confrontation clause is whether the statements concerning the swabs, the basis for the rape kit, the basis for later expert testimony, whether they were testimonial. Because if they are testimonial, the courts below agree, the district attorney agrees. If they were testimonial, there's a confrontation clause violation because the declarants did not testify at trial and there was no prior testimony from them and showing of unavailability. So as far as testimonial, Smith versus Arizona, which was decided just maybe 6 months ago by the United States Supreme Court, one holding is important, that it cleared up whether, if there's expert testimony, can you just say that basis testimony, like at issue here, that basis testimony is not subject to confrontation clause scrutiny. And the United States Supreme Court held, clearing up the fractured decision of Williams, the United States Supreme Court held that basis testimony, like anything else offered for the truth, comes under the confrontation clause. You can't just say, oh, well, it's something the expert relied on, therefore it's not offered for the truth. Otherwise, Smith did nothing new except to emphasize points that were made repeatedly by prior United States Supreme Court decisions. Whether a statement is testimonial is subject to a simple two-part test. One is, which they talked about at length in Smith and they've talked about before, identify who the declarant is and the exact statement that's being challenged on appeal. Once you identify the exact statement, the declarant and the exact statement, what is the primary purpose? And if the primary purpose, as this court has recognized, like the United States Supreme Court in Brown, the primary purpose, if it's something that's going to be potentially useful later in a criminal prosecution, then it has a primary purpose which establishes that it is testimonial. The statement here is at page 12 of the report prepared by the forensic nurse. Page 12 of the report is the section of the report where it states the swabs, who they were taken from, what particular private areas. And then those statements about the swabs are critical later to the prosecution's case, in many cases, like it was here.
But they weren't prepared, the statements weren't made particularly for the purpose of pursuing a prosecution.
The primary purpose, the test is potential, and that's the only purpose they're prepared for. In other words, unlike the rest of the report, the swabs then, put with a rape kit, the swabs that were taken, and the report, and it's the only part of the report, it's then sent to the police and stuck in an evidence room. And the reason it's sent to the police and stuck in an evidence room is that they hope that later they can analyze those swabs and find sperm fractions. And if they find sperm fractions, that then they can have a DNA analyst compare it to the DNA of a suspect in a case. So
I understand what you're saying. Can you cut to the point of what was it used to establish? Because your client didn't dispute that your client had had sex.
That was because that defense is a result of this evidence being allowed in. So it's circular, and I'll point to Your Honor's decision from, on behalf of the unanimous court in Commonwealth versus Stevenson last year. Once the motion to eliminate is denied, first, Rule 103 states, you have preserved it for appeal at that point. And in the Stevenson case, what happened was the defendant filed a motion to eliminate to keep out prior convictions of his prior convictions. After he lost the motion to eliminate, when he took the stand, he's the one that brought out the prior convictions.
Well, I think I think this is a little bit different because you're saying that your client that your client and your client's lawyer represented to a court a fact of consensual sex only because the DNA evidence showed it. So your client maintains that your client lied to the trial court in taking the position that he had consensual sex with these three people?
It's not a lie. He didn't testify. It's not a lie. It's
Well,
a defense. It's a defense that is presented that is...
Did a lawyer, an officer of the court, represent to a judge and to a jury that it was consensual sex?
Yes.
And now you're telling me that that's a lie.
I'm not telling you that that's a lie. I'm saying the defense would have been if these cases had no identification evidence whatsoever. So, if the motion to eliminate had been granted, the DNA testimony doesn't come in because the DNA expert cannot say, I tested the swabs of this particular woman taken on a particular date. You need, page 12 there, you need the swabs from the forensic nurse who took them and made a report and wrapped it around a rape kit. There would have been no identification evidence. So the defense at trial, if there was a trial, these cases weren't tried for several years. The case at trial, if the Commonwealth even tried the case, would have been misidentification.
Counsel, there wasn't a stipulation as to the chain of custody?
Pardon me?
There was no chain of custody stipulation or testimony? I mean,
Chain of custody stipulation is what happens after the basis report, which is this report.
The swab is put on a property receipt. The property receipt submitted for DNA analysis. DNA analysis is done, links up the defendant to 3 different rapes.
Chain of custody is just who got the rape kit. There might be 5 people who got the rape kit. In other words, after she prepared it, it's her report and the swabs, it might go to one policeman. He takes it to the evidence lab. It goes to another policeman. He takes it to the DNA lab. That's not the same thing. This is the whole basis, and this is what Smith talked about. In holding, the basis evidence is covered by the Confrontation Clause. The truth of the basis testimony is what makes it useful to the prosecutor. It is the predicate and what gives value to the expert testimony. The expert testimony is meaningless without the rape kit swab report because the DNA expert doesn't know anything about whose swabs that the DNA expert is examining. DNA makes it all irrelevant. The testimony of the expert would be irrelevant because the DNA expert can't say anything about what the DNA expert is testing.
Okay, I think we understand this. Is there anything more you want to say on the subject?
Well, I want to say that just the exact statements at issue is the first question, and clearly the important ones here are the swab statements on page 12. The prosecutor says, no, look at the whole report, and the case is, I cited 80-year-old case from this court. As far as hearsay, you don't look at a whole report. And as a trial lawyer, medical records all the time, I would stipulate to them, except if I found on page 35 something was inadmissible, then I would say, I don't agree to that, and I'm challenging that. That's the exact statement at issue. The Harris case 80 years ago was the same thing. Doctor had a report. Doctor's report was all fine, except there was one sentence in the doctor's report that this court held was inadmissible hearsay. Davis versus Washington from the United States Supreme Court held that in a situation, even one discourse between a police officer and a complainant can change in the middle. In Davis versus Washington, there was an assault complainant, and the officer went there, and the first statements he's taking from her were in connection with an ongoing emergency. And the court said, those come in, there's no confrontation clause. They weren't made for the purpose of potential evidence later in a criminal prosecution.
Did you have a second point on the confrontation clause argument?
The second point was just to, and again, since there is no rebuttal, I just want to say that their other argument is that, wait a minute, this is not subject to the confrontation clause because some of the cases I cited, they all involved analysts doing sophisticated tests and reaching conclusions. This is just an examination and a report of what was taken in an examination and recorded. It doesn't change the analysis because this has been the point of all these cases. The point of all these cases, and then I'll refer to one of them which they cite, which supports me. The point of all these cases is that every witness, including those who prepare lab reports, are subject to the confrontation clause the same way.
Even if the nurse did no analysis?
Correct. Correct.
Okay.
Because, if I could just mention bulk combing before I sit down, because they rely on it. There's much more involved here than what was involved in bulk combing, where the court found the confrontation clause violation. In bulk combing, the issue was a blood alcohol content report signed by somebody whose title was analyst. And the government said, wait a minute, that so-called analyst, he was just a scrivener because the number that's at the bottom of the report, 0.18 or whatever it is, there was a machine that produced the report.
This case is distinguishable from that matter. This was a swab that was taken by a nurse, as indicated in the notes of testimony, and that's it. There was no defined DNA or any person indicated when that swab was taken, correct? Or are you challenging that as well?
That when the swab was taken, there was no DNA?
No, that there was no identifiable individual. It was just a swab that was taken from the woman.
Right, and that's
distinguishable from bulk combing.
but not from Brown. Not from Brown in the other cases, because Brown is the autopsy case.
So are you now changing your position on bulk combing? Because you said it's not.
No. There's two different points, Justice Doherty. The first one is, as in Brown, it doesn't matter that there's a particular perpetrator or a particular individual. It was an autopsy report that was prepared for potential use.
I wrote the opinion. I understand.
I know that I was going to point that out, but yes. And, Your Honor, in your opinion, you reject that exact point made by the district attorney. District attorney argued, wait a minute, there was no suspect at the time, so this is not testimonial. And that was rejected. Now, getting back to bulk combing, which was a separate point. Bulk combing, it was a gas chromatography machine that gave the number. And the government said, it's a mere scrivener here. All he did was put the number down in his report. And the United States Supreme Court said, all witnesses are judged the same way, and this person, there were procedures for this person putting the sample into another vial and sticking it into the machine, and he had to put the cap on correctly, and he had to scrimp the cap. This involved much more with the forensic nurses as far as potential mistakes, and there's also at page 62 of my brief about what can go wrong, and they had special training, etc. And also this case has the aspect that was emphasized in Smith and in bulk combing, that the analysts in those cases, one of them was on leave, unexplained, and one of them no longer worked at the center where these tests were done. And the court in each of those cases said, that is something that someone would want to explore on cross-examination potentially about why they don't work there anymore.
Okay, Mr. Sosnoff, we really
Thank you.
do understand. It was well argued. Thank you. Let's hear from the Commonwealth. Mr. Baldwin?
Good afternoon, Chief Justice, Honorable Supreme Court Justices. May it please the Court, my name is Sean Baldwin. I represent the Commonwealth of Pennsylvania. I'm going to begin going back to the first argument regarding the consolidation of cases. I'd say that when this court took aliquotter, particularly to this issue, they asked what tests should the trial courts employ to determine the line between propensity evidence or evidence brought in for a common scheme or plan. I think what I didn't anticipate about the Honorable Professor Epstein's argument was that he would only talk about plan. And while I do understand that that was a part of the aliquotter question, I can't say I'm necessarily prepared just for that because that wasn't the facts of this case. At no point did the Commonwealth just, the Commonwealth has to put in a motion to bring in other acts evidence, or in this case, a motion for consolidation. And we didn't come in and say, we want to consolidate these because they're a part of one overarching plan. We asked for consolidation for one of the other purposes.
Which was what?
Common scheme, plan design.
What was the stated purpose?
Your Honor, I don't have the motion in front of me, but I believe it was common scheme, plan design.
They're the same thing. Counsel, you hit on something I meant to ask your opposing counsel. As I understand our aliquotter grant, we really took this to determine when 404B evidence is admissible, and we did reference the common plan exception. There are two different standards for that type of admissibility and the consolidation question, or is the distinction based solely on the test for prejudice?
No, I think it is the same standard. I believe it's Rule of Criminal Procedure 582, or 574, I apologize. It's in my brief, that states that the test for when cases can be consolidated is whether or not the evidence in one would be admissible in the other. And that test the test for when that admissibility would be the same as Rule 404B. And I
Which
think
is what? It has nothing to do with admissible in one case or the other. It's whether the whether the evidence is more prejudicial than probative, in addition to meeting one of the exceptions. So they really are two different standards, aren't they?
Your Honor, I don't actually believe that they are. I think that the Rule 404B also encompasses that prejudice standard, and in fact, it's actually a part of the rule. Specifically, it says in a criminal case, this evidence is admissible only if the probative value of the evidence outweighs its potential for unfair prejudice. And so I think it's reasonable that this court, both in case law and trial courts in practice, have used the 404B standard to determine when it's appropriate for cases to be consolidated.
Thank you.
So what evidence do you suggest from one case would be admissible in the other if we exclude the DNA? Judge, you have 3 different rapes here, 3 different women, 3 different parts of the city. What evidence of one do you think would be admissible in the other cases?
Your Honor, when we talk about the similarities, I think defendant has done a very good job of framing this in such a level in which they say that this might be the same as it would be in all stranger rape cases. But I would remind the court that stranger rape is not itself a statute. The statute is rape. And that's relevant because the fact that this is a stranger rape is probably the first thing that separates it from the majority of rapes. The Department of Justice's National Crime Victimization Survey from the years 2010 to 2016 let out a report that said 8 out of 10 rapes, reported rapes, are committed by a person known who's known to their perpetrator. So the fact that 81% of these rapes would not be inclusive here shows one of the similarities. Another that this court has looked at in other cases is geography. They weren't on the same block in the same neighborhood, but two of these rapes occurred 1 month apart, one on Girard Avenue in Northeast Philadelphia, one in Oxford Avenue in Northeast Philadelphia, and the third in
Girard
West
Avenue is
Philadelphia.
North Philadelphia, not Northeast. Oxford Avenue is the lower Northeast.
Oh, here we go.
Are you from Philadelphia by any chance?
I am not, but I've lived here. I lived on Girard long enough that I considered it Northeast because that was the direction I left to go to home from
Northeast
work.
of City Hall, but that's about it.
That's the direction.
I understand. But another similarity is victim selection. I think this court in I do not have the time to set my cases up. Apologize, Your Honor.
Okay.
But
Yeah, it's fine.
but there's a case, it's cited in my brief, where it talks about, I'm not sure if it was Aaron, or regardless.
We'll read it all.
The fact of luring the victim by pretending to sell them something. In one case, it was headphones. In one case, it was offering loose cigarettes. In another case, it was directly offering money. That's another similarity between these. Taking them from a public area to a private area. I believe it was Commonwealth v. Miller was the case.
A woman walking alone as opposed to a woman in her apartment where somebody breaks into a window. There are lots of different kinds of stranger rapes, and these are similarities.
That's correct, Your Honor. And I would also say that the factors of using force, whether it be threat of force via knife point at one victim, the use of a tire iron punched on the back to another victim, and the use of fist on a third victim, the fact of, the ejaculation and the victim selection, in that all three of these victims had some perceived or actual vulnerability. One victim testified that she had, in fact, smoked crack cocaine earlier in the day. Another victim testified that she had smoked marijuana earlier in the day. And the third victim, defendant approached her walking outside of a methadone clinic. And I think that the defendant's victim selection here also showed a similarity in that he picked victims who he believed were vulnerable and would not be believed, and that common scheme is just another one of the factors that the trial court used when they made their determination that these were similar enough that one would be admissible in the other.
Counsel, are you at all, are you kind of resting on the common scheme similarity, or are you also relying to a certain extent on the analysis that Chief Justice Saylor used in his opinion in Hicks, and the idea that it can't be that a jury should be able to decide how likely it is, I guess, that three people would be prostitutes disgruntled and then turn around and accuse him of rape?
I do agree with that, Your Honor, that the jury must make that credibility determination. I think that also goes to why this is more probative than prejudicial, because the jury, in this case, not only do they make that determination, but they have to look at the victims who give the testimony, these other victims, and they give a credibility determination on each one of them too. So it's possible that a fact finder could look at each one of these victims, maybe even based on these same vulnerabilities that led them to be chosen, and say, I don't believe this person. This person said they smoked crack cocaine. This person said I smoked marijuana. This person said they were a heroin addict, and not believe any of them. And I know you don't like the numerology argument, but
it's not that I don't like it. I just don't know how we would ever set it's not that I'm against numerosity. It's not a very judicially manageable standard.
I understand that, but it's part of the reason why I believe the line between propensity and permissible uses should, as it always has been, left to the discretion of the trial judge. A great example is in Hicks. From my reading of Hicks, there were 8 different victims that the Commonwealth sought to introduce, 8 prior paramours of the defendant, and the court, in its discretion, said, I'm only going to allow 3 to testify because it was cumulative. And I think that that was indicative of the trial court using its discretion to draw a line to say, you know, where does it become so cumulative that it's more prejudicial? But I don't think that this court can make a mechanical rule and say only if A plus B plus C does it come in, because the variety of case facts from case to case are going to be so dissimilar that you know, at some point you can't make a mechanical rule, and you are going to have to rely on, you know, the person who's on the ground, who hears the information, who is the trial court judge. And I do think that that's another reason why, when you're talking about both 404B and consolidation, there's a requirement before this ever hits the ears of a jury that the Commonwealth would have to, in preparation, file a pretrial motion so that the judge can hear these things specifically to make the determination of whether something's admissible or whether trials could be consolidated. I think that's the purpose of that. And while I understand that it will probably, I don't think this court will ever be able to give the trial judges an easy cheat sheet to say, if A plus B equals C, let it in, otherwise don't. I think that the discretion of the trial judges and an instruction that they should look for cases with a logical connection as a factor in determining that line, I think that is the best.
I think we understand. Are there other questions on that part of the argument for Mr. Baldwin?
No.
Let's move on then to your second argument on the nurse's report.
Sure, Your Honor. So for the medical examination, the rape kits, understanding that the argument here at the Supreme Court level is that it was that page 12 statement, my biggest fear is drawing a blank right here in front of you all.
Where the
chain of
alleged
custody.
testimony, no, it's not chain of custody. The alleged testimony is, I took a swab of this, I took a swab of that, I took basically what evidence was collected.
Well,
That's the alleged testimonial.
That's the alleged testimony before this court, but understanding that, you know, as a reviewing court, that's not what was brought before the trial court to make its consideration, nor was that made clear in the Superior Court that it was that specific testimony. In fact, the motion to preclude was literally titled, Motion to Preclude Allison Demon from Testifying to the Reports and the Fruits Thereof. So it was unclear, basically going all the way up to this court, what specific thing in the reports they were finding were testimonial. I should also point out that in agreeing with Attorney Sasanov that there is that 2-part test to determine whether a statement is testimonial. The first part of that is to identify the exact statement and declarant. And I don't think that was done at the trial level. But 2, I think that there was a little bit of two confusing ideas put up, which was that the test would be what is the primary purpose, but then it was also said whether it's potentially useful. And so I think there's a little bit of a conflict there, because it can either be the primary purpose or it can just be a potential.
Which do you think governs?
I think the primary purpose governs, and I think that was made clear in Commonwealth v. Yoder in 2013 from this court. Said specifically to determine whether a document or statement is testimonial, the court must look to the primary purpose.
And isn't by definition the purpose of a forensic professional testimonial? I mean, by definition, forensic means of the forum. It's for court. That's what distinguishes forensic professionals from non-forensic. Isn't that right?
Your Honor, I can't say that I have the knowledge to answer that question as far as the definition.
That's why we talk about, say, a forensic pathologist as opposed to a clinical or hospital pathologist, because they're doing work that's anticipated to be testimonial.
That may be a part of it, but I don't think the comparison of what they're calling a forensic nurse or sexual assault response nurse is the same as a forensic analyst in the terms of a doctor with 8 years of university training to actually make conclusions.
She's not making an analysis.
I'm sorry?
She's not making an analysis.
That's correct, Your Honor. And I mean, to compare it to Smith, where you're talking about the analyst who took suspected drugs and made a determination that those drugs were in fact cocaine, the same thing in bullcombing. The SARC nurse in our case will be more comparable to the police officer who took the suspected drugs and seized them to move them to the forensic analyst who connected the test.
Follow-up, counsel. I'm sorry.
Sure.
Just my forensic type question. I just zooming out, just conceptually, wasn't the whole development of the SANES over I don't know how many decades ago expressly for purposes of better developing these rape cases for court, as opposed to the work traditionally done by nurses and other allied health professionals in the clinical setting?
I don't doubt that that is absolutely one of the purposes of conducting these examinations, but I do disagree to the extent that opposing counsel says that that is the primary purpose of this. People don't go to the hospital in order to solve a crime or to gather evidence. They go to the hospital to get treatment. And the bulk of this report was a question and answer between this SARC nurse and the victim. And so the majority of the statements in this are literally check boxes. The victim says, where were you harmed?
You can't, counsel, you can't really say that the rape kit was for medical treatment.
I don't know that the rape kit is exactly a statement.
No, I mean the conducting of a rape kit, the intrusiveness of it, the examination is something that is medically necessary such that it would be considered medical treatment.
Your Honor, I actually, to my own discredit, will have to actually disagree with you. I think because when you talk about the rape kit, I know it's easy to think of kit as just the swab, putting it in, and moving it to the lab, but that's not what the rape kit is. The rape kit...
STD evaluations, it's more than just that, isn't it?
There is, and I think specifically the purpose of this is that if a patient comes in and they says, I was beat in the head, the nurse then knows to look for a head injury but not a neck injury. If the patient says, I was vaginally raped, the nurse and the medical officials know that they're looking, possibly for damage in that area and not damage in other areas. And so the purpose of this examination as a whole is to determine what medical needs are necessary. And in these cases, in this form, where they talked about vaginal intercourse, was what the victims informed the nurse about, it then made the determination, or at least it led the nurse's determination on what to do next based on an existing protocol.
Are you telling, a moment, just to follow up, counsel, a moment ago, I think you flipped the script when you said that of course, the patient's purpose in going to the hospital is not to prosecute a rape case, it's to get treatment, and that's intuitive and obvious. But that wasn't the frame of reference I thought that we're examining here on this sub-issue, which is that on the other side of that transaction, among the array of professionals, because it's not like Green Acres, there's not just like one country doctor waiting for the patient there, right? There's an array of professionals with different training and different responsibilities. Are you denying that, just as in the child abuse scenario, there are people trained to eyeball that case, so to speak, for the signs of bad acts, so to speak, child abuse, that that the responsibility of these SANES, or whatever term you want to use for these folks, is specifically as an adjunct to the potential criminal case?
Your Honor, I'm saying that that is a part of it, and I don't think it's a significant comparable part of it. In that same hospital, there's an oncology department where a patient who comes in reporting of cancer is going to go there. And even if, maybe that was a bad example, but
Yeah, not a lot of crime there.
I thought your example that you were going to made more sense. And you were talking about, let's take a crime scene. And, you know, the CSI team or whatever it is goes in to get the evidence. And they gather the evidence, they take the fingerprints off the wall, they do whatever, they get the bloody glove or the footprint or whatever, they put it in a bag and they take it. Is that more akin to what is happening here, that this was somebody who just gathered evidence? And if we rule in favor of the petitioners here, does that mean that every evidence gatherer at a crime scene will now have to come and testify, that they become testimonial in terms of what they did at the crime scene?
Your Honor, I don't dispute that in that particular hypothetical, that yes, that, you know, an evidence gatherer at a crime scene is very different from a SARC nurse at a hospital. At a crime scene, that I think it's a lot more clear that the primary purpose there is collecting evidence for use in a later prosecution or an investigation, versus a nurse, the sexual assault response nurse at the hospital. They're going to conduct their examinations regardless of whether or not the person ever wants to prosecute their crime or not. And that kind of just...
You're saying that there doesn't have to be a separate consent to the taking of samples and the swabbing separate from the just give me medical treatment?
Absolutely, there does not have to be.
So a rape kit will be performed as a matter of course by anyone that comes in seeking medical treatment for a rape?
Everything except page 12 that defendant brought up. Everything except...
Well, but that's what they're talking about.
Yeah,
they're talking about page 12.
Oh, well, that's... I think it might just be a difference of the way we define rape kit, because the way I define it is the examination as a whole. And, you know, I think if we... It's probably easier to defendant's argument if we were to say the rape kit only equals page 12 out of 4 things, but it's a rape kit examination. It's a report. It's a medical report, and they stipulated that this is a medical report. And there is just this small piece of the report that is brought out that does have the purpose, or at least potential purpose, of future litigation. But that's not the vast majority of this report. I should also bring this court's attention to the U.S. Supreme Court in their case of Melendez-Diaz. Footnote 1 to this case, should I find it? We do not hold, and it is not the case, that anyone whose testimony may be relevant in establishing the chain of custody, the authenticity of the sample, or the accuracy of the testing device must appear in court as a part of the prosecution's case. They go on in that same footnote to further say that it does not mean that everyone who laid hands on the evidence must be called. Gaps in the chain of custody go to the weight of the evidence and not the admissibility. And I think, and that's the U.S. Supreme Court interpreting the same confrontation clause that's at issue here. I think in Melendez and Bull, Cumming, and Smith, they are talking, when they say that their confrontation rights are violated there, it's a person who actually committed a test, not the person who took the sample. In Brown, where it's an autopsy, it's the person who conducted the autopsy, not the person who brought the body to the morgue. I think it's a very distinct difference on the roles of the SARC nurse versus the role of the forensic examiner, which would in fact be testimonial, and who did in fact, in this case, as the DNA expert who conducted the test and came out with the conclusions, Jamila Howard, who did come and testify.
This has been very well argued. Are there any other questions? All right, Mr. Baldwin, thank you. Thank you all.
Thank you.
Mr. Minner, would you call the next case? Good afternoon. In this appeal by allowance, we must determine whether the Superior Court misapplied the prima facie standard governing preliminary hearings by upholding the trial court's dismissal of the charges of simple assault, criminal conspiracy, and recklessly endangering another person filed against 2 off-duty police officers where the Commonwealth introduced evidence that the 2 defendants chased a pedestrian and threw him into a wall based on their belief that the man had been breaking into vehicles in the neighborhood. Please proceed.
Thank you, Madam Chief Justice and Justices. May it please the Court. Andrew Greer on behalf of the Commonwealth. As this Court unanimously reminded the lower courts just 2 weeks ago in its Williams opinion, the weight and credibility of the evidence are not factors at the preliminary hearing stage, and all reasonable inferences must be drawn in the Commonwealth's favor. The lower court here erred by not following that directive. Even if we focus solely on 3 items of the victim's testimony, the prima facie case was made out. Here, the victim testified that the defendants manhandled him and threw him into a wall, that the wall then slammed the side of his head, and that as a result, his head was bleeding and he got a black eye and bruising to both his arms and legs. If credited by a fact finder at trial, this would be sufficient to find the defendants guilty of all 3 of those charges. For those reasons, this court should reverse. With regards to simple assault, this court has held that it is reasonable to infer that a person intends the natural and probable consequences of their actions. Actually, Madam Chief Justice, I think what's significant is, as part of your summary, I don't think what is at issue is what the defendants did, but their alleged reason for doing so. It was not in dispute that they manhandled, in the victim's word, they physically touched the victim and thereby caused his injuries. That alone is enough to show simple assault. We can infer that the natural and probable consequence of throwing someone against a wall is that they will be injured and that they're intending that injury. And in fact, this court has also held that the evidence established a prima facie case of simple assault where the defendant intentionally struck the victim and the victim was injured. So in terms of what intention is required here, it is the act that the natural and probable consequence of which will be the injury, not the subjective motivation or whether, yes, I did it, but I have a good reason. Here, everyone is in agreement of what the defendants did. It's a yes, but, and that but goes to justification or excuse, which again, this court has held to be properly at issue at trial.
How would, just adopting that theory, how would that apply in the context of any police apprehension that yields an injury to the person that's arrested?
That is properly under the law an issue of charging or fact finding at trial. So, and to make a big difference here we do not have on-duty officers, which is...
Well, that goes to mens rea, and you said that wasn't relevant and you weren't focusing on that. You were focusing on the undisputed acts.
Correct.
So I'm asking you, focus on the acts. Don't you do and but. you do what you had said, which is enough for a prima facie case, and tell me how that prima facie case couldn't apply to charging every police officer with with assault on an arrest that results in an injury.
I'm not, Your Honor, and what I'm saying is that is properly a charging issue, because what that's going to, in that hypothetical that's not present here, is an issue of justification, and it is.
Well, that doesn't alter that is an element of the charge, is justification.
No, sorry, Your Honor. What I'm saying is by changing this hypothetical to.
I'm not changing the hypothetical. I'm going with the facts that you say are relevant facts.
Yeah.
And them being off duty was not an element of the crime.
Correct.
Okay. The element of the crime was they chased, they threw into a wall, they arrested, because they did restrain.
Yes, they physically restrained.
Okay, they physically restrained. Take all of those facts and tell me how, if those facts alone don't support a charge like here in an instance where police officers do it.
I am saying it confined to the prima facie standard that we were saying. I am not disagreeing with Your Honor. What I'm saying is when that happens, that makes out that prima facie showing.
Basically, you're saying every arrest, you agree then, every arrest that results in an injury through the use of force could be charged by the district attorney?
It could technically, and as Deputy AG Ron Eisenberg reminded us this morning that the DA has the maximum discretion at that charging phase, it would be at that level. And it is almost always the case that that charging decision is not made because of the evidence presented being that no reasonable fact finder could find that an officer was acting, an on-duty officer was acting unreasonably in those circumstances. That's just not simply the question here for the court.
Why didn't you charge aggravated assault? If these people were not off-duty police officers, they were just some guys in the neighborhood, and they slammed a guy's head into the pillar, you would have charged aggravated assault. Isn't that true?
I cannot stand here and say for certain that we would have. I say the facts of the case support the charges of simple assault conspiracy.
Would a head injury support aggravated assault?
Certainly, if we had, because we are not arguing here that serious bodily injury was caused, and but if it were caused, then I think that would have gone into that charging decision. I will say there has been one circumstance, at least where our office has charged an officer who was on duty with aggravated assault because their actions rose to that level.
It's very important, isn't it, to cleave off this category of on-duty officers, or even people who identify themselves as officers, because neither of those scenarios is what came out at the preliminary hearing here. Isn't that right?
Correct, and I just, for purposes of answering Justice Brobson's question, yes, but what is certainly relevant here to these facts is that they were not on-duty officers. They did not identify themselves as such. They weren't uniformed as well, which I guess more goes to explaining the victim's actions less than their own. But, I certainly wouldn't feel, comfortable to just stop just because any person who I don't know or have reason to believe that they are a peace officer is accusing me of breaking into cars 9 days earlier. It certainly explains why he ran from them. But what I am getting at is if this court were to uphold the lower court's decision, what that does is precludes the Commonwealth from taking to trial any case where a defendant at the preliminary hearing stage raises something that hints at this justification defense. So again, and actually I'll be back before this court next session involving a case. What is not at issue is the injury caused in the apprehension during a flight, but that was a case where we charged the person who fled from the officers. The person was injured during that chase, but the chase was legal, and of course we did not charge these on-duty officers in that circumstance. And that's just one case. But what I'm saying is here to uphold the lower court's decision based on this seemingly preferred justification defensive property of a off-duty investigation would preclude us from taking any case to trial where otherwise the underlying elements are made. In terms of conspiracy, the lower court did not dispute that the defendants were acting together, only that their intent was not criminal. Again, that went back to their subjective motivation. They're stated, we believed he was a suspect from these prior car thefts, and that's why we chased him. That was not inconsistent with, we acted together when we threw him against the wall and caused him the injury. I will also just note that they did not identify themselves as officers or call 911 until after the assault had concluded and they had him physically restrained on the ground. In terms of reckless endangerment, the manner in which they assaulted him placed him at risk of serious bodily injury by slamming him against a pillar with such force that it did injure his head. Here I have to cite 2 PA Superior Court cases that the lower court's decision was inconsistent with, one of which was, that both are cited in my brief, but where the courts have found both of these upheld a REAP conviction beyond a reasonable doubt. One where the defendant indiscriminately, quoting that word, took a single swing of his fist into a crowd, and then another where throwing one punch at another's face. So certainly at the prima facie level, where it's not in dispute the physical assault itself, and that it was done in a manner that actually did cause a head injury, and that this isn't about that, the victim put his own head in danger, and that it did, with such force cause a scrape to the back of his head, among his other injuries, that certainly put him at risk of a serious bodily injury. And just for what it's worth, the defense offered this video upon which the defendants were allegedly relying for pursuing the victim into evidence. It was played in front of the victim. The victim testified at the preliminary hearing. That is not me. I have not been in that neighborhood. I do not know where that is located. And under the prelim standard, those also must be credited at this stage. Before a jury, full fact-finding and full cross-examination and the full body of evidence can come through to test the weight and credibility of both what the defendants offered and the victim's explanation. Unless your honors have further questions about that, I would just ask that you reverse the lower court's order so we can take this case to trial.
Any other questions? Any other questions? Okay, let's hear from Mr. Gibbs.
Good afternoon, your honors, and may it please the court. Madam Chief Justice, my name is Charles Gibbs, and I represent James and Patrick Smith. In response to Justice Robson's analogy, my colleague said that there is either a charging decision or a trial decision. Missing in that is something called a preliminary hearing. As this court laid out in Commonwealth versus Williams 2 weeks ago, this is not just a point where the court is a rubber stamp. The court is not required at a preliminary hearing to close their eyes and cover their ears just because the Commonwealth has brought a charge. What the lower court is required to do is to examine two things. Number one, which my colleague rested his entire case on, is the actus reus. Number two is the mens rea. And to determine mens rea, the lower court is not required to ignore the fact that these two men were police officers. I would submit to this court that it is a red herring to get into whether someone was on duty or off duty, because the Municipal Police Officers Act says that an officer who's employed is a police officer.
What about the fact that they misidentified themselves, said they were the town watch? I don't think that's existed since the 1600s. So doesn't that suggest that they were not only acting off-duty, but that they affirmatively represented that they were something that they were not, and they did not identify themselves as police officers? Would we even be here if they had told him, stop, police, and identified themselves as police officers? Instead, they concealed the fact that they were police officers. How do you account for that?
I account for that at the preliminary hearing. The Commonwealth elected to call a sergeant from Internal Affairs who put in other evidence that disputes that. And the Commonwealth disputed their own evidence. They said they did call 911. They said they identified themselves as police officers, and subsequently they filed a use of force off-duty action report. If they said they were town watch, even a citizen can effectuate a citizen's arrest if someone is committing a crime. This begins because they observe the complaining witness in this case trying car doors and looking in. Yes, the 9 days prior information in the description helped influence their decision, but as police officers, they are entitled to make a stop. And when you actually look at the record here, it states that he agreed he was knocked into a wall, and that he was knocked into the wall to be stopped from running. Not because, so the court, municipal court, listens to that testimony and has to make a mens rea finding of intent. Because they're police officers, because the legislature has defined that there are certain people who can use different levels of force, the lower court is not required to ignore their factor. Justice Brobson's analogy, I can take a stretch further. In fact, it would not just be for an injury resulting in an arrest. It could be for any time that someone puts handcuffs on someone else. Under our crimes code, that would be unlawful restraint.
They would be identifying themselves, Mr. Gibbs, putting handcuffs on somebody. Again, they would be identifying themselves as police officers and placing somebody under arrest. I mean, when we decide this case, we're not just deciding this case involving this Mr. Smith and this Mr. Smith. We're deciding the case on what prima facie case means for preliminary hearings Commonwealth-wide.
Absolutely.
And I wonder if, you know, we can't give a one-off because these guys happen to be police officers, right? We can't just give them a pass because we're talking about the standard for everybody for preliminary hearings. And the concern I have, one of the concerns I have with the Superior Court's opinion here is it seems to strain and reach an entirely different standard than the one we've articulated in Williams, Perez, and all these other cases. It seems to be an outlier, and I believe we took Alicotter in order to see if this can be harmonized with our standard, which is pretty well articulated for preliminary hearings.
Absolutely, and the standard requires that the Commonwealth meet each and every element. And the mens rea element, we contend, was not met here, as the Superior Court laid out. The municipal court judge at the preliminary hearing has to somehow infer or get to a place where you get to the intent. It is not knocking someone into a wall to stop them from running. Is that the intent? Or is that the intent to make an arrest or to apprehend someone?
Counsel, this was a published opinion of the Superior Court, which is one of the primary reasons we're here. The one thing the Superior Court did is they drew all inferences in favor of the defendants. It's totally contrary to what the standard is.
The standard is all reasonable inferences go to the Commonwealth, not all inferences. And here, there are inferences.
All reasonable inferences in favor of the defendant.
I believe they drew reasonable inferences. The Commonwealth failed to meet their burden, and there is no other inference that you can make because the Commonwealth has the burden at each and every phase to lay out the elements of all the crimes, including the mens rea, even at a preliminary hearing. Calling the sergeant from Internal Affairs was a tactical decision.
Well, yeah, but counsel, I mean, I think the argument though is, I mean, you're right. In this situation, the Commonwealth essentially presented inculpatory evidence and exculpatory evidence from a mens rea perspective. I agree with you, but at the preliminary hearing phase, isn't the judge entitled to disregard the exculpatory and say, well, you know, I'll let a jury figure that out. I'm just looking at the inculpatory and there's enough there.
I don't know if the judge is entitled to disregard the Commonwealth's evidence in their case in chief. Respectfully, I think the Commonwealth presented the evidence, and I think it fills in the entire picture.
How is at a preliminary hearing, if there's evidence that they acted recklessly, and there is evidence that they did not, from a mens rea perspective, as a matter of law, are you saying the charges have to be dismissed?
I'm saying that the Commonwealth has to make out the mens rea element for this particular case. No, I'm not saying that the case has to be dismissed outright.
But that's what you're saying is here. You're saying they, in fact, in your brief, I believe, you conceded that if Commonwealth hadn't presented this evidence, that we wouldn't even be here.
Absolutely right.
So that's my question is, from a legal principle, Commonwealth presents conflicting evidence on mens rea. Is that, as a matter of law, mean that the Commonwealth doesn't meet their burden on mens rea because there's conflicting evidence in the record?
I think the municipal court preliminary hearing judge has to now weigh whether it's more likely than not.
Well, that sounds like a jury.
No, because the preliminary hearing standard is more likely than not. It's a more likely than not standard. It's not just.
We held many times, counsel, that the weight, not only the credibility, but the weight is for trial.
Absolutely.
And we've also said repeatedly, including in Perez, quote, the evidence must be read in the light most favorable to the Commonwealth's case. I mean, this is something you deal with. You do preliminary. How many preliminary hearings do you do in an average year?
More than I want to.
Okay. So, have you ever seen a case, anything like this, that wasn't bound over for trial in Philadelphia?
It's very rare. Oftentimes it's involving the Special Investigation Unit of the DA's office. So yes, sometimes I do when I represent police officers.
Do you think that had these men not been police officers, this case would have been tossed at the preliminary hearing stage?
Based on the evidence that was presented, yes. But if they weren't police officers, you don't have evidence that the Commonwealth is putting in that cuts into the mens rea issue. So the fact that how they are employed in a Commonwealth's trial or even trial strategy at the preliminary hearing, they can't run from that when the case is dismissed. This second witness cuts at the mens rea issue. And Justice Robson, as I was saying, there is a balancing that the court has to do. Is it more likely than not that all the elements have been made out? Is it more likely than not this is the person who committed the crime? With all reasonable inferences in favor of the Commonwealth, yes.
As a matter of law, it's not reasonable to infer a fact where there is competing evidence in the preliminary injunction stage. That's your argument?
That is not, I would not state that would be my argument. My argument would be that if the Commonwealth does not make out an element, the case cannot be bound over.
Counsel, is it fair to say it's rare at a preliminary hearing for that type of evidence to be introduced by the same party?
That is incredibly rare. Normally, a preliminary hearing is, Justice Weck, the ones I do through the year, it is an officer walking up saying, I observed this, I ask a couple questions and the hearing's over.
So when a party, the Commonwealth, introduces evidence that contradicts itself, the court is not supposed to ignore that contradiction and allow a miscarriage of justice to occur. They have to make a decision.
In Commonwealth versus McCullen, this court talked about the fact that the preliminary hearing is a substantial step and a substantial part, and that the preliminary hearing court is not just a rubber stamp.
And I can share with you as my experience as a trial DA and defense attorney in Philadelphia, I rarely saw any introduction of defense evidence at a preliminary hearing.
And we didn't introduce the evidence. This was presented by the Commonwealth.
I never, as a DA, introduced evidence that would defeat my prima facie case.
That would not be a wise
And it's fair
trial
to say
strategy.
that's the standard practice, not here, but across the Commonwealth with all district attorneys' offices. Fair enough.
Are you saying that the Commonwealth here, the DA's office, introduced evidence that sought to defeat its own case? Is that
That's my contention, that the calling of the internal affairs sergeant by the Commonwealth went against cut into the mens rea requirement that the Commonwealth had. Normally, a mens rea requirement is met by just saying an incident happened, but by putting in a testimony about them being off-duty police officers, putting in evidence about them filing a use of force report, putting in evidence about them calling the police and identifying themselves to the police, and subsequently following up with their job as they were supposed to, gives the preliminary hearing judge a window into the mens rea or the mental status when they made this particular stop.
And the testimony of IA Sergeant Koenig, which you feel defeated, and I guess you feel was a significant reason why the case wasn't bound over for trial?
That's correct.
That defeated this case at the preliminary stage was what? What was in his testimony that you maintain did that?
The fact that he identified them as police officers, the fact that he talked about that they called 911, waited on location, and then he read into the record the use of force report that the officers prepared as an off-duty incident, which is something that would never be in front of the municipal hearing court in a normal preliminary hearing.
Yeah, because I'm looking at the sergeant's report, and I don't see him stating in his report that they told McNally they were police officers until after the fact.
I don't see that in his report either.
What?
I do not see that in his report.
Right. Well, that's significant, isn't it?
Not as significant as the other information, that they do call the police, they do hold him down, that they say that they held him down to stop him from running, which the victim or the complaining witness correlates, and also following the after-action report. As opposed to having...
I guess the sergeant, the IA sergeant in his report recounts the version of the defendants here, Mr. Smith and Mr. Smith, that the male ran and tripped. So that's I guess what you're getting at. But why was given to the extent there's a conflict in testimony at the preliminary hearing stage, why was the Commonwealth not entitled to have the inference drawn in its favor about the slamming his head into the wall, from McNally's testimony rather than this IA sergeant recounting what the defendants told him.
Could be they didn't have to submit that evidence.
Well, let me hear Mr. Gibbs.
Justice Dockery does a better job at it than I do.
Go ahead, tell
but
me.
he doesn't say just slammed my head in a wall. I was knocked into a wall, and the wall hit my head is what his actual testimony was, not that they actually slammed his head into a wall. That's the evidence that the Commonwealth elicited, and even at the refile hearing, where the Commonwealth could have cleaned up or put on another preliminary hearing, they relied just on these notes of testimony, which created for that review the same issue.
If there are issues of fact, don't they have to be resolved in favor of the Commonwealth at the preliminary hearing stage?
I don't necessarily agree with that principle. If someone says that Mr. Gibbs took my car and went to Mars with it, I don't believe that the preliminary hearing court is required to hold me for court on unauthorized use of an automobile.
But all credibility and weight issues
Absolutely.
are left to the trial stage,
Absolutely.
not at the preliminary hearing stage. So here, what you're saying is the the preliminary hearing judge had to accept everything that the officer that was called to testify said on the record.
Yes, and the victim, and then weigh that evidence and whether or not it meets the elements for simple assault, including the mens rea requirement.
And any inference to be drawn from that evidence has to be drawn in favor of the Commonwealth.
That's this court's holding, Your Honor.
Yeah, correct.
Yes.
All right, any other questions for Mr. Gibbs? Thank you both very much.
Thank you both for being concise.
Thank you.
We're grateful. Kevin.
Would you call the next case, Mr. Minner?
Aplt's counsel looks familiar.
In 2018, a man was fatally shot outside of a Philadelphia bar. As part of their investigation, police obtained surveillance video from the bar and a nearby business, which purported to show Aplt walking around the area and then shooting the victim. During Aplt's videotaped police interrogation, the interviewing detectives repeatedly accused Aplt of lying when he denied being the individual in the surveillance videos, and they further stated their belief that Aplt was guilty of the murder. Over Aplt's objection, portions of the videotaped interrogation were played for the jury at trial. The jury convicted Aplt of first-degree murder and related offenses. Aplt appealed his judgment of sentence, arguing that the trial court erred in admitting the portions of the interrogation video that showed the detectives accusing him of lying and opining as to his guilt. Notably, the Commonwealth agreed that the trial court erred in admitting this evidence. However, it argued that the error was harmless. The Superior Court concluded that the trial court did not err in admitting the evidence, and that even if it did err, the error was harmless. We granted review to consider whether the trial court erred in admitting the videotaped interrogation and what steps can be taken in the future to prevent any undue prejudice to a defendant when the Commonwealth seeks to introduce videotaped interrogations. Please proceed.
Good afternoon, Chief Justice Todd and Associate Justices. Carl Schwartz on behalf of Rashid Malcolm. May it please the Court. This Court has long held that law enforcement accusations of guilt and mendacity have no place in a criminal trial. It corrupts the truth-determining process. Although this issue before the Court today, which involves embedded accusations in videotapes, is technically a matter of first impression, it's only a matter of first impression because of advances in technology. This Court, as early as 1955, in the Bolish case, in which tape-recorded accusations by a prosecutor were deemed to be violative of due process, And in the Di Nicola case, a more recent case in which a detective's recalling for a jury the prosecutor's statement that he believed the defendant was guilty, this type of evidence is, it makes what should be a fair fight an unfair fight. A defendant should not have to deal with those kinds of accusations. In this case, they included, and I'm not going to be repeating my briefing, but I think this is important to point out. They included some of the following. I'm sorry, they included the following, which is not the sum total. That was played for the jury, in which detectives stated with utter conviction the following: we picked you up on surveillance footage. I'm telling you that I know that this is you, pointing to that footage. That's what I'm telling you, Rashid. That's you right on 62nd Street. It is you. We checked the cameras and you were out there. I know you were right there. Do you know how absurd your account or a particular part of your account sounds? And we're confident that we have the right person here. None of these accusations are connected to, tethered to any question. And in fact, 3 of them, as I mentioned in my briefing, were the last parts of the videotape that the district attorney played. And as I said in the brief, so much for context. One of the cases that we cited, the Rhode Island case of Gaudreau, talked about the danger of incentivizing the manufacture of evidence. And when you have of improper evidence under the Trojan horse of we're looking for context. And when you have a 9-hour videotape in which Mr. Malcolm consistently denies guilt, and in which the prosecutor has to pick out, like gossamer wings, aspects of those 9 hours that suggest he's probably guilty, this is, I think, the paradigmatic case of just that.
Were there any limiting instructions given related to the admission of this video?
There were not. There were not.
And what were the redactions?
Give me a second to think about that, Justice-elect. Well, the entire 9 hours were not played. So there certainly were redactions. My memory, and Mr. Greer can correct me, my worthy opponent, is that they were redactions that really served the Commonwealth's interest. In other words, what part we as the Commonwealth, they as the Commonwealth wanted to play.
Did the defense move to redact any statements by detectives that the defense alleged were fabrications?
Well, the defense moved to redact accusations. Yes, absolutely. There was an objection, and the judge said a very specific objection that the detectives say that we know you did this. We believe we have the right person. We believe you're guilty, and the trial judge said to trial counsel, no, they can say that, and that resolved the question, at least at the trial level. And you know, this is a serious problem, but it's a serious problem with a simple solution that does not impair one iota the truth-determining process. It's a solution that this court has approved in many other circumstances. Of course, the most well-known would be the Bruton context. It's redaction. These accusations must be redacted. And this case, I think, is, again, the perfect example of how such redaction would not affect in any way, and frankly, even if it did, based on our 403 standard, I would still argue that it should be redacted. But if you look at the statements in this case, and I haven't done a study, but I don't think it's coincidental that none of them are connected to a question. They are simply rank accusations that are made with such, and I'm sure the court has seen these, I mean, there's no way to look at this videotape and not believe and not know that these detectives believe every word that they're saying, that while this may also be an investigative technique.
Can I?
Yes.
Can I break in right
Yes,
there?
please.
Was the interrogation video ever transcribed and admitted into the evidence in this case?
No, it was not.
Okay, so that if, as a reviewing court, we wanted to look at what objections were made, we don't have a record of that.
The objections that were made, well, a couple of things. The Superior Court gave me permission to have transcribed the entirety of the interview. And that is, I believe that's part of the reproduced record. I certainly could supply it. The actual video that was presented to the jury was submitted to this court. This court has that evidence. All of the objections that defense counsel made regarding the video are on the record, and they accommodate my argument in toto, Justice Mundy. There's nothing that he missed. So I don't think there's a problem of an incomplete record or a waiver or anything like that. What he said was, anytime, and I'm paraphrasing, but I'm paraphrasing correctly, anytime the detective says, we think we have the right guy, we think you did it, we're confident you did it, words to that effect, he objected to that very specifically. And those are the only offending comments that are the subject of this appeal.
Counsel.
Yes.
Share with me, why weren't the jury instructions in this case sufficient to remedy that error?
Your Honor,
and correct me if I'm wrong, they said that questions are not evidence, only the answers.
yeah, but these weren't questions. And the judge ruled that this was appropriate evidence. And this court held in Di Nicola, I think presciently, that as bad as prosecutorial argument is, in which the prosecutor points to the defendant and says, he's guilty, he's a liar, it's infinitely worse when the jury receives it as evidence. And that's what happened in this case. The jury received...
Yeah, but the difference was the evidence came from a police officer as opposed to a DA. I mean, as far back as Bolish, we've declared the law in Pennsylvania is that it's a due process violation which deprives a defendant of his right to a fair trial, where you have a prosecutor making a comment about the defendant's credibility. Essentially, what you're asking us to do in this case is extend the Bolish principle to when detectives or law enforcement make it in the form of evidence or from the witness.
Yes, their opinions, absolutely. And that's what the court did in Kitchen, but that's not the highest court. This is the highest court. And had the Superior Court decided the case correctly, and I can address why they didn't in any number of ways, then I would, and we were here, I'd be asking this court to affirm and announce a new rule that I'm asking the court to do right now.
You're saying, you're asking for a per se rule of exclusion?
Yes, unquestionable.
Just out of curiosity, Justice Stockard, to ask you a question. Was there a curative instruction? There wouldn't have been a curative instruction because the judge felt that it was okay to put the evidence in.
That's the point. And
so there was no curative instruction even given in this case?
Correct. There was none. Because the judge said it was okay. And Justice Stockard, I didn't finish my answer to your question, which is several courts, including the Superior Court in McClure, and a case I cited in my brief, I believe it was the Wyoming Court in Sweet, talked about the fact that general instructions about credibility and that the jury determines credibility do not cure this kind of very specific error. And I would argue, Justice Doherty, that even if there were a curative, and I would be on far less firm ground than I am right now, but even if there were a curative, I would argue that based on, in part, Justice Wecht's dissenting opinion in Hicks about the ineffectual nature of instructions, and let me say this, I'm not saying that curative instructions around things like 404B and accusations can't ever cure the error, but they can't when what the error is the jury seeing in real time real detectives in a very real way espousing these opinions. Such an instruction asks a jury to not believe their own eyes.
Well, I just looked this up. The trial court opinion at page 10 quotes from the notes of transcript jury instruction with regard to that testimony.
No, it wasn't in regard to that testimony, respectfully, Justice Mundy. There were two instructions, and if I'm getting this wrong, you have the transcript, you correct me, but I'm pretty sure I'm right. There were two instructions around police credibility. They both were of the same nature. They both were, while these detectives or police officers are viewing the video that you're viewing, what they observe, you can consider it, but ultimately it's what you're seeing with your own eyes that control. So in the first case, it was when Detective Burns was trying to see if he could see drawstrings, because there apparently were no drawstrings on the sweatshirt that was used in the incident. And at the preliminary hearing, Detective Burns was cross-examined on that because the sweatshirt that was found in a residence that Mr. Malcolm used did have drawstrings. So what the judge was saying was, you can see what the detective can see, your powers of observation control. The second instruction...
That's an instruction?
Right, it is an instruction, but it doesn't... And the second instruction was very much the same thing. It was at the end of the trial, after defense counsel went to sidebar, it related to... In my brief, I said it related to Detective Lucky's narration, but I think it also related to
So you were unhappy with this instruction?
I don't think this instruction in any way addressed the question of the impropriety of detectives saying, we know you're guilty.
Did you do anything about it?
I'm sorry?
What did you do about it? Did you ask the judge for further instruction? Did you ask for a charge to the jury?
So I wasn't the trial lawyer. So what did the trial lawyer do about it? Mr. Teneri, as Justice McCaffrey pointed out, once the trial judge ruled that a detective's testimony that we know you're guilty, we know you're lying, is admissible evidence, then at that point, there's very little... I've made my objection. I made it very clear. I let the judge know what it was. I think that I've preserved that issue. The instruction that the judge mentioned, and that I think the trial lawyer asked for, it was directed to a completely different issue. It was directed to, while the video was being played, who do you trust to see what's going on in that video? You consider the detectives, but ultimately it's what you're viewing. That's very different. Jurors know that when detectives do an investigation, there are any number of things that they learn that may not even come into the trial. So that when the assigned detective 13 times tells the defendant, look, we know you're guilty. We know it. That's you. You're there. Then that can't but prejudice, can't but corrupt the trial process. And it's completely unnecessary. This case, I think, is emblematic of that.
Counsel,
yes.
I'm struggling with what a curative instruction could have been in light of the fact, you said you believe that these detectives honestly thought they had their guy. But during an investigation, they could lie to the defendant. So what is the judge to say to the jury to cure any error by showing a statement by a police officer that you did it, you're guilty, we know you're guilty? Is the judge to say, and ladies and gentlemen of the jury, that detectives can lie during interrogations?
So
I just don't know what a curative instruction could be under those circumstances.
So I agree with you, Justice Donahue. I think the only solution, and a painless solution, is complete redaction of those accusations. That's what this court has said over the years, and I think that's what this court should say in this case. The Innocence Project did an amicus brief, and in their amicus brief, they suggest an instruction. Now, if this court were inclined to disagree with my position, and also I have an alternative position, which I put forth in the brief, which is very much akin to the Musser case in Michigan, which is unless the accusation is both tethered to a question, which none of these are, and generally in these cases they are not if you look at the other cases, and unless the accusation is followed by an answer that cannot be understood absent the accusation, it should be excluded. Okay, so that's one solution short of redaction. I don't think it's the best solution. I don't think it's a necessary one. In regard to an instruction, the Innocence Project put forth, I didn't even put it in my brief because I don't think it does the trick, but they put forth an instruction. Essentially what you say to the jury, and you may not even, what you say to the jury is, look, this is a technique. They're using this as a technique. Don't take this as evidence. This is what detectives do to try to get the truth, right? Now, number one, I don't even know if that's truthful in this case. So the judge may be telling the jury something that's not true, because I looked at that video and it didn't look to me like a technique. And I think that the concern that the Innocence Project talked about in regard to instructions, which is jurors feel like, don't tell me what to believe, in where the video is occurring in front of them in real time, that instruction is not going to do very much, I don't think. So I would urge this court not to go in the direction of instruction. I would urge this court to simply say, these accusations need to be redacted in all cases. If the court's not comfortable with that, then do what the court did in Musser, the Supreme Court of Michigan, and came up with a very careful way. And I think under the Musser test, none of these accusations are coming in anyway, because it's rare that an accusation is tethered to a question to begin with, and secondly, it's even rarer that you can't understand the defendant's, the substance of the defendant's response absent the accusation. I just think it just pollutes the trial, and that's what this court has held. And I Mr. McCaffrey, the distinction that you draw, but I think that there's no reason to believe that, and this is what the Kitchen Court held, there's no reason to believe that the jury is going to be any less moved by the detective's improper testimony than the prosecutor's improper argument.
Mr. Schwartz,
yes.
what other evidence was presented by the Commonwealth as to guilt?
Very little, and I want to address that. Shall I do that through an analysis of the Superior Court's harmlessness analysis?
That's exactly where I was going.
Okay. So, and I can also talk about the evidence absent that analysis. Well, the Superior Court said, again, I think a straightforward application of Kitchen would have gotten Mr. Malcolm a new trial, let him be tried fairly. If the Commonwealth can prove him guilty, so be it, but let him be tried fairly. That did not happen. The Superior Court first said that Kitchen, this isn't Kitchen because it only condemned specific allegations of lying. But when the detective says, do you know how absurd that sounds? That is really a distinction without a difference. And in Kitchen, the Superior Court found that when the detective said, what you're saying is something different than what you said before, that was an improper question, improper statement. I agree that it was, but that was far less a direct accusation of lying than, do you know how absurd that sounds? And as we pointed out in our brief, the detectives here did something more. They explained to the jury, as a prosecutor would in closing argument, why the defendant's story should not be believed, right? They said it's absurd, it keeps evolving, it's suspicious to me that you didn't have the cell phone. Now, they interviewed this young man for 9 hours, and I think the failure of that interview is powerfully persuasive on the question of guilt or innocence, and powerfully persuasive on the point that the purpose of this statement was to Trojan horse these accusations. Although I don't need the court to find that. I'm musing. The Superior Court also did not address the fact that in this case, the detectives repeatedly said that Malcolm was guilty over and over and over again, far more forcefully than any detective ever did in Kitchen. And the way the Superior Court got around it was by saying, well, they were just relying on the police officer's identification of the video in the courtroom, okay? There was no evidence to that effect. Moreover, as I pointed out in the brief, so I'll say it very quickly, that was impossible because the police officer was interviewed on May 7th, and Mr. Malcolm was interviewed on April 10th. So respectfully, that was an incorrect, if not pretextual, rationale for finding that these accusations were not harmful.
When you say the police officer was interviewed a month after Mr. Malcolm, you're talking about the patrol officer that identified him from the video. So this particular statement that we're talking about redacting was given well before any identification by anybody was made. Is that?
As far as the record is concerned, yes. I think that's right.
Up until that point, had anybody identified Mr. Malcolm? I mean, he's sitting there for a reason.
I'm saying, I have no. Mr. Greer may be able to expand on that. I have no knowledge that he was identified before that interview. And in fact, he was released after that interview, and was released until Lamanna, the officer, made his ID a month later. My point is that the Superior Court, a critical problem with this case and a critical reason why it aligns so closely to Kitchen, and I'm not saying Kitchen is this court's case, but I think the reasoning is good and consistent with this court's jurisprudence, but the reason the court departed from Kitchen is because it said everyone knew that Lamanna's identification, the accusations were based on Lamanna's identification. Nobody knew that. Nobody knew that. And so the prejudice was profound. I think on this record, to find that there's no reasonable probability that the error might have contributed to the verdict, that's the Story standard, I don't see how a court could make that finding. Beyond the fact that the instructions did not address this error in any way, shape, or form, there was no eyewitness. There was one person who knew Mr. Malcolm, and that person testified he was there that night. He did not see Mr. Malcolm on the scene. The video was at all times either highly pixelated or, and I'll concede the Commonwealth's point in their brief, that at times it was clear, but at those times the perpetrator's face most of the perpetrator's face could not be seen. The jurors, and I pointed this out in the brief, and in the question of prejudice, this is a relevant consideration, asked to see the photo of the perpetrator and Mr. Malcolm side by side and struggled over the question of identification, and then asked to come back after the weekend. This court has talked about the problems, the concerns we have with identification testimony in the Walker case, even with people who are acquainted with each other. And I concede that there was some level of acquaintanceship here. And
Mr. Schwartz,
yes.
Am I correct to recall that your client was 6'7"?
Yes, I think that's right, yes. Yes, and there's no question that that's distinctive. And in fact, the Commonwealth's brief, Justice Doherty, when it comes to the question of harm, I respectfully suggest that what it really read as was an argument for sufficiency. Was there sufficient evidence to convict Mr. Malcolm? Unquestionable. Lamanna comes in, he says, I don't care that his face is covered, he's tall, he walks in a certain way, that's the guy. I wouldn't come before you and say that wasn't sufficient to convict. But the harmlessness analysis is much different. You have to find that this error, that there's no likelihood that this error contributed to the verdict. And I would respectfully contend that there's no way to make that assessment. I think that, we often hear about, certain pretrial rulings that takes evidence away from the Commonwealth, and it's not really a search for the truth anymore because now the Commonwealth is hamstrung and a guilty defendant is getting off. This is the mirror image of that. We all know that this kind of evidence, and it is evidence because that's how it was admitted, has no place in a trial in Pennsylvania. And in this case, if this case isn't the exemplar, then there is no case. And as I said before, I don't think it's coincidental that not one of these allegations was tethered to a question, and that 3 of them were made and then the video stopped. I mean, what's the contextual purpose of that? The only purpose is to, or the only effect is to convince the jury that Mr. Malcolm is guilty because these detectives think he is.
Okay, thank you, Mr. Schwartz. I think we've got it. Let's hear from, were there any other questions? No. Let's hear from, let's hear from the Commonwealth. Mr. Greer, you're a glutton for punishment. Back again as we move at our glacial pace toward the end of the day.
Yes, and I was in Superior Court yesterday, so it's a busy week.
You're having a great week.
Your Honors, there's a lot of inaccuracies I want to clarify. First, just speaking chronologically, first, because no civilian eyewitnesses were willing to come forward or able to identify the defendant, a patrol alert, like a wanted poster, was circulated amongst the police. So a still image was circulated. Officer Lamanna identified defendant from that patrol alert and communicated that to homicide detectives before this interrogation. So he was ID'd from a still photo from that video before this interrogation, and that was the
That's how he got there. That answers my question.
Yes.
I know he's there
By
for
a
reason.
police officer.
Correct. He was then, whatever it was, weeks or a month later, shown portions of the video or the video in full, and that's when he then again made an identification from the live video. But he identified defendant from a still image taken from that same video, circulated in the patrol alert before this interrogation. So,
Identified him as a person of interest?
I identified him from the surveillance video from the crime, said that is the person I know to be defendant.
Because the trial judge tells us it was unclear. I think she said at some point the video was unclear. Not clear, I think she said.
It's at night, and sometimes his face is showing, sometimes it's not, sometimes it's light, sometimes it's dark. So I think the trial judge was referencing the video in full. The patrol alert showed the most visible portion of his face. From that's where he was identified. My point being, in terms of the allegation during the interrogation from the detectives, you have been identified, was correct because it had happened by police officer Lamanna from the patrol alert. Now, going to
you have been identified as a suspect, or you have been identified as the person who committed the crime?
That, Your Honors, I am not entirely sure from the record.
There were no eyewitnesses. The video is not the still that you're saying that the officer looked at was not a still of a person committing the offense.
Correct.
So at most, he was identified by an officer as saying that still looks like this person.
Yes.
And then at the interrogation, the police said, "We have identified you as what?" Because that's what the whole. I just sat here during the whole argument. That's the point. They said the detectives didn't say, "Hey, we circulated your photo. We have an officer that says it's you. We're doing this investigation of this crime. Did you do it?" They said, "We have identified you as the perpetrator."
I'm pausing because it was phrased slightly different. The phrasing was multiple people have identified you, and it was from that video because defendant
identified you as what?
As the person in the video.
Okay.
That.
Lamanna, who had identified him?
Sorry, I missed the beginning.
Pardon me. Other than Officer Lamanna, who had identified him?
No one, which gets to the issue of curative instructions that were given and whether this actually was a preserved objection. What I am saying is defense counsel, I believe, misrepresented that they were lying when they said defendant had been identified from the video, but that's not true because he had been.
Ask us to, on that subject, you ask us in your brief to adopt Kitchen. So you don't ask us to overrule Kitchen, you ask us to adopt Kitchen. So you need to rely, if I'm not mistaken, on on there being meaningful daylight between the facts in Kitchen and the facts here. So you need to rely on your argument, I take it, that while Kitchen involved detectives lying, here they weren't, I'm sorry, Kitchen involved accusations, right? That he was lying.
Yes.
Right, sorry. Kitchen was detectives accusing the defendant of lying. And you're saying that because the detectives here didn't actually use the word lying, but said things like, do you know how absurd that sounds? And I don't believe that we have the, I guess implying the wrong guy. Your story keeps evolving, changing, and everything else. And I find it awfully suspicious that you wouldn't have. You think this is a meaningful distinction between Kitchen in this case?
No, Your Honor. Just to clarify, my reading of Kitchen was very, very broad. That the Superior Court in Kitchen, because they added on statements such as "we have a strong case against." I am not bringing up what the detectives say to distinguish from the facts of Kitchen on that basis. I'm bringing it up to say that what the jury heard did not suggest to, what the detective said did not suggest to the jury that they had any information that was not before them. With one caveat, they heard them say multiple people have identified you as the person on the video. The video shows I'll say it shows the shooting, but it's in complete darkness. I think you see a flash of a gun. But there's no question that the person identified as defendant is the same person at all relevant points in this video. So the still frame doesn't come from defendant holding the gun to the victim's head. It comes from him walking down the block in the light a little bit later. I am just saying it.
You're saying there's no dispute that the still frame is a still frame of the person in the shooting video?
Correct.
Nobody's disputing that?
Not that I'm aware of. Everything has been saying defendant's clothes didn't match his clothing, or that the identification wasn't good enough based on that video.
Is it your contention that this case comes down to the identification of Officer LaManna from the videotape?
Not. You mean the old?
What did the jury, if somebody asked you in a bar, what did the jury hang its hat on? What are you saying?
In terms of identification, Officer LaManna.
They came back and they said guilty, based upon what?
The identification testimony the identification came from Officer LaManna's testimony from the video, that the jury also saw the video, also heard Officer LaManna testify, also explained the basis for how he knew defendant and what about defendant on that video led him to believe it was him.
That was the basis for the conviction. So why did you put the statement in with all of these other statements saying, we don't believe you, we know we got the right guy? You were basically putting it in for only one purpose. There can only be one purpose. He didn't confess, which is you wanted to get in front of the jury the police officer's belief that the defendant's a liar, or was lying in the video when he said he didn't do it.
No, Your Honor. It was submitted for defendant's responses during that interrogation to show his evolving story. He claims not to have a cell phone, or keeps changing, this was my number then. Over the course of time, not as, defendant didn't give the most incriminating statement, but what we argued in closing was not, hey, believe he's guilty because the detectives are accusing him, and not even saying, hey, believe that he made a direct admission of guilt during this interrogation. It was,
If that's what you wanted to offer, I'm sorry to interrupt again, but if that's what you wanted to offer it for, why didn't you just redact all of the detective and the police officer's statements regarding his credibility?
And Your Honor, that is leading me to exactly what I want to clarify about this record and how it came up. Is we said, we discussed, we gave the defense the video, said here are the portions we want to admit. Let us know what you want to redact. Before trial, the defense did that, and then we only submitted agreed upon portions. And then here's what happened at trial. The portion I was discussing of detectives say multiple people have identified you from this video. Court, sua sponte, with no objection, says we're going to stop there. I don't know how many times he will say this, and nobody told me, but ladies and gentlemen, for our purposes, all you can consider is that one person came in and said that that was the defendant on the video, and that was the police officer who testified yesterday, being police officer Lamanna. Again, this is March 24th notes of testimony between page 29 and 35, include all the relevant parts.
I'm sorry, Counsel, just to
Yeah.
clarify my understanding of what you're saying now. Now you're, because I didn't see this in your brief, that you're arguing waiver? Because I thought you were going to try to explain to us how this can, if this was error to put this in unredacted, following Justice McCaffrey's question, how could that be harmless error beyond a reasonable doubt? I thought that's what you were going to get to next, but now you're trying to make a waiver point, I take it, which I didn't see here.
No, I am trying to explain the development of several issues that have gone out of hand because they're misrepresentations that I want to clarify. The officers were truthful insofar as when they said that, Police Officer Lamanna, who had just testified the day before the jury saw this video, had identified defendant. So once something that is inconsistent with evidence the jurors have heard, saying multiple people, that was immediately corrected. So going to harmless error, that is one of the instructions that eliminates the idea of the risk of prejudice from accusations such as this.
And again, maybe I'm misremembering it, but it's not that we have an officer or even multiple officers have identified you from this photo. They said, we know it's you. Like, we know it's you. Not that we've been told it's you. We know it's you. And how is that not a bridge too far? Because that's what the jury's supposed to decide. The jury's supposed to decide whether it's him.
In terms of the admissibility, in which aspect are you asking me to answer? Bridge too far in terms of whether it could be admitted, or about whether this was so prejudicial that this is why the jury could have convicted
Well,
him?
the latter. I mean, why? Number one, what's the point of admitting it anyway? And number two is you have a police officer saying repeatedly, I know this is you. I, who am not testifying, I know that it's you.
In the first instance, the purpose of admitting this videotaped interrogation, which includes both things the detective say and the defendant says, the purpose we offered it for is for what defendant said. And I'm saying, don't just take me as true. Look at what a prosecutor said in closing argument.
Then why not redact the officer's statements? If that's the purpose.
And in hindsight, what I'm saying is, I think it would have been appropriate, and we offered defense the ability in the beginning to come to agreeable redactions. In terms of, I'll say why I didn't argue waiver below is because I was under the impression that we were in agreement that the instruction I just recited was a curative instruction related to the same type of evidence we are now discussing. Because what happened, again, the multiple people accusation, court pauses, gives the instruction, only one person has identified defendant. That was the officer you heard testify yesterday. That is true. The jury's understanding of the evidence is now in line with what is true and what is properly before them. The court goes on and goes, why was I not made aware of this? And then excuses the jury. We then say, we try to come to an agreement. We gave defense the portions of the video we wanted to enter. Everything they said that they didn't want in, we took out. This is news to me. Court says, go back, try and work it out amongst yourselves. So then we come back, and it's not defense counsel, it's our prosecutor who represents that Mr. Tenardi, defense counsel, and I disagree over one of the other things. The part of the statement where the detective says, we believe it's you in the video, we believe we have the right person, we believe it's you. And the court said, that's okay, he can say that, and then defense counsel said, well, I object. All I'm saying is the defense can't have it both ways. Either the curative instruction that was the basis for recessing the jury and coming to an agreement about what is admissible was related to the issue now before this court. He can't say that it's related to some entirely other character of evidence.
It seems to me, counsel, that they're two different things. That the judge instructed the jury, no, there were not multiple identifications, there was just one identification. That clears that issue up, but it doesn't seem to address the issue of the police officer saying, "We know you did this." Am I missing something here?
That their belief has to be based off of something. I don't think there was any idea in the juror's mind that these detectives interrogating him were eyewitnesses or were the detectives who made the initial investigation. Their accusations have to be based on something. And
So do I understand you not, because I'm getting confused now. In their, the Innocence Project, their brief, they share comments from the interrogatories. I'm telling you that I know this is you. That's what I'm telling you, Rashid. I saw you in the photo and you looked and you say, no, that's not me. I said it's you. And I know you were there. This is various sections. Is this the officer who identified him in the still photograph previously telling him, is this a reference to the identification of the still photograph? Or is this just a free-flowing statement, I know it's you?
the latter.
Wow.
In the context of, and those are in the context of an interrogation. I mean, this interrogation would have happened if the identification didn't, if the proper Officer Lamont identification hadn't happened as a reason to bring defendant in.
And from your perspective, it doesn't matter whether the officer did know it was him or was just saying, I know it's you, from an investigative technique standpoint. It doesn't matter to you which it was, does it?
I believe I agree with you. I'm saying it was clear to the jury that these are accusations in the context of an interrogation to get the defendant to say something incriminating. Saying, I know it was you, with no other information does not suggest that this officer has some unknown information. Saying, I know it's you because multiple people have identified you could, which is why that was corrected.
I'm puzzled because in this latter part of your argument, you've diverged from your brief. In your brief, you say the Commonwealth maintains that the detective's accusations and opinions were inadmissible, but that their admission here was harmless, and you go on. And then you say, in future cases, retaining all non-accusatory questions while redacting only blah, 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 will be a sufficient remedy. Well, the question is, what about the remedy here? Right, a guy got life in prison for something you concede is error, and I'm trying to see how you can establish how that error was harmless beyond a reasonable doubt, but instead of going there, you're going into something that's not in your brief.
You seem to be suggesting that this was not error, which is contrary to the argument that you presented in your brief. I think that's where my confusion comes from. I mean, I thought you were going to stand up and tell us why this error was harmless, but you aren't going there.
Your Honors, I apologize for confusing you so far. I opened with wanting to correct what I viewed were misrepresentations about what happened. Again, when he was brought in, having already been identified, that's what I wanted to start with. I stand by what was in the brief. The Commonwealth does not see an affirmative reason to depart from Kitchen because, again, the Commonwealth did not enter this video to show, look at all the things the detective said. It was, look at what the defendant said. That is what is relevant to proving guilt.
Of course not. But why? I mean,
but that's just what I was accused of a Trojan horse.
Okay. Well, I think okay. I understand, and you're spending this portion of your argument to rebut what he said. But you're not saying from a legal perspective it matters. You're rebutting what he factually said.
Correct.
Okay, but from a legal perspective, you stand by your brief. You think it was harmless error.
Yes.
And why?
It is harmless error in light of both the curative instructions and the ID. Curative instructions, one given right off the bat contemporaneously. Defense counsel pointed to another different curative instruction that is still relevant, but attempts to diminish its relevance because it didn't happen concurrently with the video. What I'm saying is this curative instruction, the police said multiple people, you are only to consider the identification evidence being the one police officer who you heard testify live in court the day before. Then goes on, so the detective is doing an interview, and this is how the detective interviews go sometimes, making clear to the jury that this is a tactic. The jury does not, the detectives don't have, the detectives' accusations and implicit accusations of lying or disbelief in the defendant's story are not based on anything you, the jury, has not heard, and you are the ultimate fact finders.
But I think they were about Detective Burns' statements on other matters, not, that the instructions were prompted by testimony, by statements rather, by Detective Burns about things other than what we're talking about here. You know, that's suggesting he's lying. There's like apples and oranges here, isn't there?
There are different instructions. The one I was just reciting is about when the video was played. Detective Burns testifies later. And then I believe the instruction you're referencing, so this is not contemporaneously with the video, it's later that day or maybe the next day when Detective Burns testifies that when he's asked what he thinks he sees on that same video, the judge gives the curative instruction. It doesn't matter, sorry. You are the finders of fact, so it doesn't matter what the detective believes he sees in the picture, not the video, the picture from the patrol alert, which again is derived from the video. That was not given concurrently with the accusatory statements in the interrogation, but there was a different instruction given concurrently with the interrogation video that I just read. So what I'm saying is there are multiple curative instructions. There was not one model of clarity given right before the video. If I had to propose one, that you're about to see a videotaped interrogation, to the extent police accuse the defendant of lying or express disbelief in his answers, this is simply an interrogation tactic, not based on any information you yourselves have not heard, and I am instructing you to disregard such a statement. Now that, of course, cleanly puts together what I am saying, several instructions given over the course of trial, some concurrent with the video, some not, but relevant to the same detective who is giving this interrogation, gave the jury that impression. And in addition to the untainted identification evidence, that is what I'm saying the harmless error argument is based off of. That the juror's verdict saying this defendant was guilty of the murder was not because we think something's being hidden from us, and for some reason the Commonwealth's hiding something that is more damning than what we know. Any improper suggestion of evidence outside the record was done away with by the instruction. So that is the harmless error argument. It's both the curative instructions and the identification evidence.
Mr. Greer, I think we got it. Are there any other questions by counsel? You can sum up if you want and bring this to a merciful end.
Before you do that, counsel, where in the record, what specific curative instruction are you referring to that's in the record? It's just so I can take a look at it. You don't have to get into it and argue.
There are three. The first one, I'll direct you to pages 29 to 31 on March 24th. That is where, in short, you just heard them say multiple people identified you.
I'll read that. Just tell me where they are. I don't want to steal your thunder here.
That's the one. And then, yes, page 138 on the same day is when you are the finders of fact, so it doesn't matter what the detective believes he sees in the picture.
Okay. That's March 24th as well.
Were there 3 or 2?
I'm sorry. In the first page range I gave, 2 different instructions are given. I'm sorry.
All right, thank you, sir.
Sorry, I have no further questions. Thank you.
All right. Thank you both. Call the last case, Mr. Minner.
Yoder, McCarthy construction, representing Santiago,
No, I was interrupted. I shouldn't. I was trying to look for.
We need a very patient. We appreciate that. In this discretionary appeal, an employee of a roofing company, which was a subcontractor of a general contractor, fell through a hole in the roof of the job site, and was seriously injured. The employee collected workers' compensation benefits from his employer for his lifelong injuries, but the benefits did not fully compensate him. As a result, the employee sued the general contractor for negligence in failing to provide a safe work area. Although a jury returned a verdict in his favor, the Superior Court set aside that judgment on the basis of our decision in Fauner v. Shandon, which held that under the Workers' Compensation Act, a general contractor cannot be sued in tort, as the Act provides the exclusive remedy. Among other issues, Appellant asks us to overrule that decision and hold that a tort claim such as his is not barred by the Workers' Compensation Act. Please proceed.
Chief Justice Todd, and may it please the Court, my name is Howard Bashman, and I represent the plaintiff appellant Jason Yoder. With me at council table is David Pazika and Laura Pansini of the Pansini and Pazika law firm. In case after case, the statutory employer doctrine inflicts a profound injustice on Pennsylvania-based construction workers injured by the negligence of a general contractor who did not qualify as a statutory employer because the employee's actual direct employer had and paid workers' compensation benefits to its own employees. A doctrine that was created for the benefit of injured workers has been turned on its head to allow negligent general contractors to escape liability under both the workers' compensation system and the tort system in violation of the public policy prohibiting a supposed employer from escaping liability under both recovery tracks. Now, this case raises three issues. I suspect that I'll be spending most of my time on the first issue, which is whether the Fauner decision should be overruled, but I would like to save a sentence or two at the end for the second and third issues, so I'm just flagging that right now. Fauner should be overruled because it erroneously construed the Workers' Compensation Act by overlooking that the substantive provisions to qualify as a statutory employer had been moved by the General Assembly in 1974 from Workers' Compensation Section 203, which is the very section that this court's decision in the McDonald case from 1930 originally examined and came up with a famous five-part McDonald test, moved the substantive criteria for obtaining statutory employer immunity from Section 203 to two brand new sections, which are now found in Sections 302A and 302B. I'm referring now throughout my argument to the sections of the Workers' Compensation Act instead of to the sections of the Pennsylvania statutes annotated, just to be clear to the court. And the effect of moving those provisions, substantive provisions from Section 203 to 302A and 302B, and including that unless clause that mandated that the only circumstances that a general contractor should be considered a statutory employer was where an employee's direct employer did not have workers' compensation coverage to pay to the direct employer, was to say that in situations that are the most common, where the direct employer does have workers' compensation insurance, because that's what the law first mandated in 1974. Before that, it was an optional system. That in the common situation where the direct employer has the required workers' compensation insurance, that the general contractor would simply not qualify as the statutory employer. Now what Fauner said was that, yes, we recognize that the General Assembly has enacted these two new provisions, but the General Assembly has left Section 203 of the Act in an unamended form that it existed in 1939, which was very similar to the way that it looked back when it was first enacted in 1915. And this court said, as a result of the failure to include the unless clause in Section 203, there still exists the ability of a general contractor who does not qualify as a statutory employer under the substantive provisions to avoid having to pay any tort liability to its so-called statutory employee. The reasons we say that are wrong are twofold. One is Section 302A and 302B are the substantive provisions. If you don't qualify as a statutory employer under those provisions, then under Section 203, you are treated the same as the direct employer, which is you don't have any liability to pay workers' comp, therefore you're liable in the tort system.
Mr. Bashman, can I interrupt you, please, just because the arguments that you're raising here are the same arguments the court rejected in Fonner. You're not offering anything new. Fonner is precedent. It's been in existence for over 25 years. The General Assembly's known about it. They've amended the Workers' Compensation Act numerous times and has never done anything to abrogate what our statutory construction analysis was in Fonner in 1999. There are reliance interests at play in terms of how general contractors contract with subs, how they choose to contract with subs, knowing that and encourage subs to have workers' compensation so they get the benefit of Fonner. So tell me why we should upend this precedent that if you check all the, other than the old chestnut of we're just not going to perpetrate error, which is sort of in the eyes of the beholder, what is the great consideration, I forget the language that we've used to override precedent, what gets us over the fact that Fonner may just be wrong?
Right.
But that doesn't mean we should overrule it.
Right. Well, just being wrong is not enough to overrule it. That's the point.
And I think that we are making a different argument in part than what was made in Fonner, which is the second reason that Fonner was wrong, which I was about to get to. But let me put a pin in that to come back to it and to talk about this doctrine of so-called legislative acquiescence, which this court has recognized is a discretionary concept that the court can decide to apply in a given case or decide not to apply in a given case, and not to reopen an issue that has somewhat cleaved this court recently. But in the Herald versus University of Pennsylvania case, you, Justice Robson, and Justice Wecht, both believe that an earlier decision of this court construing the Workers' Compensation Act should be overruled, and did not discuss to any degree in the opinions that I saw anything about legislative acquiescence. Now we're also trying to appeal to the majority in that case because two votes are not going to do it for me here. And that's why I started out by saying that this case does share something very much important in common with the situation. Yes.
Before you move on from legislative acquiescence, is it fair to say that doctrine needs to be used advisedly, in as much as the huge confidence that the legislature is avidly following and reading our decisions as they come through the ticker tape is perhaps a bit optimistic?
No, absolutely, and we've cited two majority opinions, the Clark case from this court in 2023 and the Commonwealth versus Dixon decision from this court in 2007, that both recognize that legislative acquiescence is not the beginning and end of this inquiry.
And neither did I suggest it was. I gave a litany of things in addition to the legislature not acting, and I think, I understand legislative acquiescence alone, but I gave more than one thing.
So the 1993 amendments, which I recognize were in existence when this court ruled in the Fonner case in 1999, were also not discussed in Fonner, and those require the general contractor, before hiring a subcontractor, to make extra certain that the subcontractor has the required workers' compensation insurance for its own direct employees. The second reason why Fonner should be overruled that I don't believe was considered in Fonner is that Section 203 of the Act, which Fonner relied upon, worked in a far different way before the 1974 amendments as it works under Fonner after the 1974 amendments. And what I mean by that is that in the elective system that existed before 1974, the purpose of the legislature was to encourage both direct employers and potential statutory employers, such as general contractors, to go out and voluntarily obtain workers' compensation insurance, which was not mandated at that time. And if they did that, then they would be entitled to the statutory employer defense. But after the 1974 amendments, the effect of Section 203 is to give blanket across-the-board immunity to the general contractor in every case, because in every case, the general contractor has been mandated to have workers' compensation insurance that exists in the situation where the very rare situation where the direct employer did not obtain it or doesn't have it. And we concede that in those very rare situations, the general contractor should and is able to invoke the statutory employer defense. But this whole situation of grand bargain and quid pro quo, and I promised myself I wasn't going to say grand bargain, and here I am saying it, involved giving something up in exchange for getting something. And that is really not happening here anymore, because it is so unusual to have a situation where there is a general contractor that's being called upon to pay workers' compensation benefits to the employee of a subcontractor. And the judges have recognized how unfair this doctrine is. And so we're not coming in front of the court saying, this is really unfair, and we're the first ones to notice it. What
has changed since Fauner, though? What has changed since 1999?
What has changed? I think that what has changed is that the legislature, for one thing, is simply not doing anything about it. When Fauner considered it, it was already 25 years after the original legislation in 1974. And what we believe that we've shown are additional reasons why Fauner was wrong that were not in front of this court in Fauner. And other things that have changed is that judges have continued to complain about the unfairness of the result. And I think that the unfairness of the result is not something that my able adversary is going to deny. This is a windfall immunity that
well,
in
Mr.
essence,
Baxman,
judicial.
I think the fact that the legislature has done nothing since Fauner doesn't help you, because we have had numerous judges, I agree with you, that have expressed not at Fauner, but at the statutory employer doctrine being unfair. But all those courts have also said it's a matter for the General Assembly. So for us to turn around and say, well, we're now going to overrule Fauner because the General Assembly hasn't done anything, seems a little disingenuous. But on the fairness issue, if we overrule Fauner and say what you say, and say that the statute now says something else, if you have a general contractor's employee on the roof and a subcontractor's employee on the roof, and both fall through the hole, the subcontractor gets workers' compensation and gets to sue the general. The general only gets workers' compensation for the same injury, the same event involving the same negligence. Right now, both would only get workers' compensation. How is your scenario more fair than the current scenario where both employees are treated the same?
Well, the reason there's a distinction there is because the direct employer does get the workers' compensation immunity, and it will have been paid workers' compensation by the general contractor that it's losing its tort system remedy against, where the subcontractor employee got the workers' compensation from his direct employer, who's not the negligent party here, and is deprived of going after the negligent party, which harms not only the employee, but as we noted in our brief, also completely eliminates the subrogation right that this court has recognized is so important in many of its cases. And so it works to prejudice not only the...
So there's no unfairness in your view that same work-related incident, same injuries, the only difference is because this one was employed by the sub, this employee gets to recover both in workers' comp and against the general, but the injured employee from the same workplace negligence only gets workers' comp. You don't see that as unjust?
I'm not here to argue that the workers' compensation system is unjust, even though there may be examples where that position can be taken. What I'm trying to say is that given that one was the direct employer and one is the beneficiary of, for lack of a better term, a fiction that the case law has developed at a time when it was intended to help workers and is now being used to hurt workers, that this is the appropriate case for reconsidering.
Putting all that aside, though, for a moment, do you have a position on whether the actual text of the statute drives the result either way here? Or
Yes,
do you, to win, do you need to resort to the language about remedial purpose and the grand bargain and all this stuff we recently read in the Herald majority?
No,
Does the statute actually drive the result? Is just a specific question.
Section 302A and 302B are the provisions that determine whether someone substantively qualifies as a statutory employer. If the answer is no, then under Section 203, you are in the same position as the direct employer. You don't owe benefits, and therefore you're liable under the tort system.
So, like in a world where, just to be clear on this, in a world where we didn't have Fauner,
right,
and this case was funner than Fauner. It's just Fauner wasn't there. And there were no precedents in windy, lofty language about the grand bargain and remedial purpose. And just look at the statute. You're saying just in that world, the statute drives the result in your favor.
Correct. And the second reason is that Section 203A, as it originally enacted in 1915, was not intended to provide blanket protection in every instance to a general contractor. The general contractor had to do something to help the worker by going out and getting the optional workers' compensation coverage. That sort of quid pro quo no longer exists under the current system.
Is it possible that the General Assembly has chosen not to do anything in response to Fauner out of concern that general contractors will no longer hire subs? And from a policy perspective, small employers would essentially be put, subcontractors would essentially be put out of business, that it would just be general contractors. Is that possible, a policy reason why they've said, we'll live with Fauner?
I think that gives way too much credit to how closely the General Assembly is monitoring the situation in this area.
Well, wasn't there legislation proposed to try and get the General Assembly to change this?
That I don't know for certain, so I apologize in that regard. But a thought experiment that I have undertaken is to think, what would the General Assembly do if this court decides to make the law what I would consider, more fair in this area without trying to add too many adjectives. And I think that, similar to what's happened after Fauner, I think the General Assembly would not want to have some draconian view reinstituted. My friend on the other side argued that if you allow general contractors to be liable under the circumstances of this case, that would result in them putting language into their subcontracts that made the subcontractor liable for the negligence of the general contractor, which I believe is an exception that the law would allow to be enforced. But if you look at the actual subcontract in this case, that language is nowhere to be found in there, and you would think that if you had an aggressive contractor, they would want to use that even today, if they could get away with it, but they didn't try to get away with it in this case.
Mr. Bashman, we hear a lot about our role in the courts versus the General Assembly, and we kind of take certain, guide from the fact that the General Assembly takes some action or doesn't take some kind of action in response to what Justice Brobson just asked you about efforts to amend it in this particular case. Can you think of any reason why the General Assembly would want to immunize negligent contractors and prevent injured workers, catastrophically injured workers of a subcontractor from collecting workman's compensation insurance from its direct employer, but not being able to get them from a general contractor in light of the 1974 amendments? Like, what would, we keep talking about a grand bargain. I'm just wondering, the grand bargain requires everybody, generals and subs, to get workman's compensation insurance. So if I got insurance, it covers my employees. Why would the General Assembly ever want to immunize and incentivize negligent general contractors?
No, I agree with that 100%, and I think that, you know...
Can you think of any, I don't want to use your terms, but can you think of a thought experiment on why they would ever want to, I mean, the General Assembly cares about Pennsylvanians. Why would they want to preclude a Pennsylvanian catastrophically injured on a work site from recovery against a general contractor who didn't even provide them any benefit?
I think the reason for inaction, to the extent any reason can be given, is just that, you know, nobody wants to mess with this whole thing. There's so much involved in the Workers' Compensation Act, and now you're going to, you know, reopen some part of it might give rise to a question of reopening something else, even if this court actually got it wrong. And secondly, that when all this was done in 1974, well, this court's ruling in 1999. It's not the same General Assembly anymore. And as we see, you know, how government works now, seemingly at every level, you know, the legislature doesn't do anything anymore for the most part. So this court has a case that has caused all these problems and you know, results that are in given cases, you know, horrifically. Yes, Justice Mundy.
And adding on to Justice McCaffrey's question, in this case, if in fact your client was able to sue in tort the general contractor and made a recovery, wouldn't in fact the subcontractor's workman's compensation insurance carrier be entitled to subrogation of the money that they paid to your client from
Absolutely.
that fund?
And this is the State Workers Insurance Fund, which, you know, I don't want to say that, you know, the Commonwealth in some sense should be supporting our position here, but it is a fund that the state government set up to help subcontractors obtain workers' compensation insurance. And that fund, like you just said, would be entitled to that subrogation, which they're now denied as a result of having this recovery taken away. And this court has noted that one of the reasons that the workers' compensation system is achieving its purpose of keeping costs low is to allow those types of subrogation against actually negligent parties. That's cut off in a scenario like this. I don't know if I should move on to my sentence or two on issues 2 or 3, or if the court has other questions on the first issue.
You're welcome to do that. Are there any other questions on this issue? And you're also welcome to rely on your brief.
What I wanted to say about the issue of waiver under the LaFleur case, which says that under no circumstances can a general contractor that has not paid workers' compensation insurance be deemed to have waived the statutory employer defense regardless of when they bring it up, is that the absurdity of that argument is actually highlighted in this case in the brief for Aplt, where in footnote 19, McCarthy argues for the very first time in this litigation that it's entitled to statutory employer immunity also under Section 302A, which is the section involving mining of minerals and cutting down of timber, and also cases where the matter that was delegated to the subcontractor is part of the regular work of the general contractor. Under this court's decisions governing waiver, the inability to waive the statutory employer doctrine ever, as long as the case is in the direct appeal pipeline, this court now conceivably has to decide that 302A issue, even though it was for the first time raised in a footnote of the brief for Aplt in the PA Supreme Court, never having been broached earlier in the case. And we think that, you know, for the reasons we say on issue 3, McCarthy can't strictly satisfy 3 of the grounds for the statutory employer immunity, but certainly the waiver point, we think is the absurdity of it is illustrated by what McCarthy actually just did in its brief for Aplt here. So thank you, Your Honors. We ask that the judgment be reversed.
Thank you, Mr. Bashman. Let's hear from Mr. Hare to close out our day.
Saving the best for last.
Yeah. Good afternoon, Madam Chief Justice, Justices. May it please the court, John Hare. I did have a co-counsel who was with me most of the day, Joseph Del Sol, but he had to be somewhere tonight and had to catch a plane. So, Your Honors, we do think this is a classic statutory employer immunity case, as this court has always defined it. And I'd start there with immunity, if I could, and then address waivability very briefly and touch on the McDonald elements. We've heard a lot about the Fauner case. Plaintiff obviously has built his entire written and oral argument around that case. But in fact, that case is only one in an unbroken line of cases, decisions of this court, almost all unanimous going back 98 years, long before the 1974 amendments to the Work Comp Act, long after, including the Patton decision only 10 years ago, unanimously, that have specifically rejected this argument that immunity depends on payment of benefits. That has never been true in the work comp system generally, and it's certainly not true with respect to statutory employer immunity. 80 years ago, next month, in the Capozzoli case, this court said unanimously that payment of benefits is immaterial. It's irrelevant to the extension of statutory employer immunity. And that is the entire argument here. But I'll put legislative acquiescence off to the side, but with a pedigree of case law like that, and no one has, neither party at least, has cited any instance, and maybe there is one, where this court has decisions, all of which are probably unprecedented here, but it also looks at whether the court's engaged in statutory interpretation or constitutional interpretation. This is only statutory, there's no constitutional claim here. And importantly, it applies, as the court said in Clark not all that long ago, it applies regardless of a handful of criticisms over time. And plaintiff cites, and he referenced them today, a group of primarily lower court judges who have criticized and mostly directed the criticisms to the legislature. But by my count, justices of this court have cast 46 votes on whether a GC in exactly this situation didn't pay benefits, complied with the act, and satisfies the five-element McDonald test. And this is a perfect McDonald case because it's such a small job site. 46 times, 45 of those votes have said this GC has to get immunity. The only exception, of course, is Justice Nigro in the Fauner case. But just 10 years ago, then Justice Baer said the statutory language is clear. The statutory, not this court's case law. He said that's clear too, but he said the statutory language is clear. And I know Justice McCaffrey 2 years ago in the Yoder case, you said exactly the same thing in the Superior Court. The statutory language and the case law is clear. So I won't belabor any longer stare decisis, but there is a tremendous pedigree supporting the immunity that the Superior Court unanimously applied here. What I would move, though, to is the heart of this argument that the 1974 amendments somehow limited immunity to situations where the general contractor has paid benefits. Your honors know, because you've said, the 1974 amendments resulted from a congressional report that came out in the early 1970s and was very influential nationwide and proved, I think, conclusively is not too strong, that the grand bargain, as your honor said in Herald and described it at length, is far superior to the tort system. Maybe not in individual cases where a plaintiff's going to get a bigger tort verdict, but it is far superior to the tort system. That was the purpose. And if you look at the changes these amendments made to Section 302, I would respectfully submit it's just impossible to read into those changes that they were saying now general contractors pay. Before 1974, all 302B said is general contractors pay unless they opt out or unless the employee opts out, unless the general and the subcontractor agrees otherwise. The only change that the 74 amendments made was to take out the two optional withdrawals from the system. The employer and employee can no longer withdraw. So all that means nowadays is what exactly 302 says. A general contractor that satisfies McDonald pays benefits unless the subcontractor does.
So, Mr. Hare,
I'm sorry.
Since you're on to the grand bargain piece, why don't you tell me what is general contractor giving up?
Yep. It's a good question, Your Honor.
They're getting blanket immunity, and they're complying with the law by having workman's compensation insurance. They're not paying for workman's compensation insurance for an injured subcontractor. So what are they giving up as part of that grand bargain that you're onto?
Yep. And Your Honor, this is, we are in the non-constitutional fairness realm. So the balancing of this should be for the legislature, but they actually give up a lot, and it's illustrated by this case. The statute requires general contractors to purchase insurance, not just for their own employees. And Mrs. McCarthy, in this case, actually bought insurance for all of the subcontractors' employees on a job site. Now, that might not be large where you have a municipal library roof. This is like a $120,000 job. But Your Honors go all over this Commonwealth, and you see these big construction sites where there are hundreds of subcontractors' employees on a job site. Those general contractors purchase insurance for every one of those subcontractors' employees on most or all job sites in the Commonwealth. So as our amici, I think, who come from across the spectrum of contractors, the insurance industry, even self-insureds, they literally pay for this immunity on most or all job sites to get it in an exceedingly small handful of cases. We're talking about, at least in its course decisional law, 7 cases over the last century, yet every job site on this Commonwealth that's big enough to have a general contractor, they are paying for the immunity for the employees of subs. But that's only one. I'm sorry. Were you going to say something, Justice?
No.
Oh, I'm sorry. The second thing is what this court said back in 1930 and ever since in the Byrne case. General contractors are guarantors. That's what this court called them nearly 100 years ago. Because unlike the tort system, where a case goes to verdict and it ends, or maybe the judgment comes up on appeal and it gets affirmed, the comp system endures. A work injury today could spawn the need for a medical expense or wage loss years or decades into the future. And we know subcontractors, not a slight against subcontractors, they come and go, maybe their insurance lapsed, maybe they went out of business for whatever reason. That general contractor remains the guarantor of payment. In this court's Peck decision, it ordered a general contractor to pay 10 years after the work injury. That is the kind of enduring obligation that general contractors incur. And the third thing is the statute, and counsel said this, the 1993 amendments to the Act require general contractors to ensure that subs have benefits. If, as counsel argues, and respectfully, if, as Justice Baer said, the 1974 amendments fixed this problem, they made comp mandatory, everybody has it now. You'd have to wonder why in 1993, the legislature had to amend the Act to mandate that general contractors are making subs get insurance. In 2006, 32 years after the 1974 amendments, the legislature creates the UEGF, the Uninsured Employers Guarantee Fund, because contractors still didn't get insurance 32 years after this statutory change that just fixed everything. So they said general contractors now have to do that. And on a job site like this makes Mrs. McCarthy collect the subcontractors' policies and put them in a file folder. Maybe it's not that onerous. On these big job sites, these general contractors hire people full-time to monitor and collect the documents of the subcontractors to make sure they're doing everything. And to the point, Justice, yes, that benefits the general contractor because, that is providing the first layer of protection. But it also protects the claimant, and we know that here. Mrs. McCarthy did her job. She made sure that this sub had insurance, and that's what he collected from. So the GCs pay for it. They remain guarantors years, and again, as impact possibly decades into the future, and they have to comply with all these administrative obligations to make sure the claimants are protected. So they do pay for it. They don't have to, but they do. And this then, I think, leaves us just in this, what I'd call non-constitutional fairness arguments that the plaintiff has made, and this court has repeatedly said the legislature is equipped to balance this. Subrogation, SWIFT never had a right to subrogation against an employer. If there's one thing we know, and Justice Baer said this in the Patton case, when 203, the immunity provision, and 302, the payment provision of the Act, use the word employer, they're talking about the GC. That's very clear. These are very short provisions. And McDonald took these elements right out of there. They just put semicolons in them. So When those sections use the phrase employer, they're talking about the general contractor. The statute says no insurer, no SWIFT can subrogate against an employer. And even if they could, that would get passed along to the subcontractor. Because in all of these contracts, and in this one here, twice actually in bold lettering, this subcontractor waived its comp immunity to the general contractor to give it indemnification and to give it defense obligations. So you'd literally have a situation if we take away this comp immunity, which is extremely complicated. All these job sites are ordered based around how these contracts are structured. You literally could have subcontractors. It's not like, I don't like slippery slope arguments, who pay the comp benefits, who pay the tort recovery back to the GC, and who pay the subrogation recovery back to the GC. That's how disordering this would be. And so I'll wrap this up, Your Honors, but plaintiff, despite all of these calls and this sort of consternation about this doctrine, apparently has never once gone, despite Justice Baer 10 years ago very clearly saying, take this to the legislature, never even asked. They've apparently never asked. They just keep coming back to this court every 10 or 15 years and asking you to change your minds. But the judges, these handful of judges, and I said 45 of 46 votes on this court, immunity, the handful of judges who have criticized it have asked the legislature, and they haven't. And as Clark said, that speaks volumes. The fact that the legislature hasn't changed this speaks volumes. I'd address waivability very briefly. The same stare decisis implications, I think, apply. LaFleur's 39 years old, has never been changed. But if you were to do what they want here, and to be clear, they want waivability only on construction sites, only for GCs, and only for GCs who don't pay benefits. Section 203 says a statutory employer gets the same immunity in the same manner and to the same extent as does an actual employer. Obviously, waivable and non-waivable immunity are not the same immunity. But it's even self-defeating. This argument they make that payment is going to be the litmus test, not only for immunity, but for waivability. In their world, if you don't pay benefits, you don't get immunity. So who cares about waivability? You never get to it. It's a completely circular argument. There's no reason to change that. You can't allow parties to confer subject matter jurisdiction on courts. And if you overturn this just for GCs who don't pay benefits, you're going to allow a party whose amended answer gets stricken to confer subject matter jurisdiction on courts. So I'll wrap it up unless Your Honors have questions. The only thing I would say is the McDonald elements are perfectly satisfied because this was such a small job site. As these have gotten bigger, you have corporate multiplication. It's hard lining up owners and GCs. This is one owner, one GC, and a subs employee got injured. So this is the McDonald case, Your Honors, in terms of satisfaction of the elements. Thank you very much.
Thank you very much, Mr. Hare and Mr. Bashman. Exceedingly fine arguments, as we would have expected. This concludes our Philadelphia spring argument session. I'd like to thank PCN for broadcasting our court sessions for educational purposes to the public. We really appreciate it. I'd like to thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman. Also our court security, John Evans, Scott Town, and Gary Shovlin, as well as the Philadelphia Police and their special dignitaries unit for looking after us. Much appreciated. Mr. Minner, you may adjourn the court.